Let's prepare to begin this morning. We are on day 3 of the hearing in EIB 25-61, the Fluoroalkyl rulemaking. When we broke yesterday, we had completed the 8th of the petitioner's witnesses. We'll begin this morning with the petitioner's final 2 witnesses. Are there any preliminary matters before we begin? No? All right. The hearing is being recorded and transcribed by David Lee of Cumbre Reporting and interpreted between Spanish and English and Spanish. Ms. O'Grady, would you share that with us, please?
Yes, good morning, Madam Hearing Officer. Buenos días a todos. Para los que están en la plataforma que quisieran escuchar la interpretación al español, por favor busquen el globo que está en la esquina inferior a la izquierda y allí le pueden hacer clic y luego escoger español. También puede deslizar la barrita para escuchar más o menos de la interpretación. Para alguien que esté aquí presente en la sala de audiencias, si necesita interpretación, puede pasar ahí atrás y con mucho gusto les entrego el equipo. For anybody that's on the platform that would like to listen to the Spanish interpretation, please go to the lower left-hand corner of your screen and click on the globe. From there, you'll need to choose Spanish. You can slide the bar so that you can hear more or less of the interpretation. And if there's anybody present here in the hearing room, just meet me in the back and I'll give you the equipment.
Thank you, Ms. O'Grady. And as usual, we will take a morning break, an hour for lunch between noon and 1, and we'll invite public comment at 1 p.m. Good morning, Mr. Roseborough and Mr. Smith here. Who's going to kick us off?
Good morning, Madam Hearing Officer. I will. And NMED begins the day by calling Dr. Richard Melstrom, who has joined us virtually on the WebEx platform.
Thank you very much. Dr. Melstrom, would you please spell your first and last name?
Richard, R-I-C-H-A-R-D, Melstrom, M-E-L-S-T-R-O-M.
Thank you. Do you swear or affirm to tell the truth?
I so swear.
Thank you very much. Go ahead, Mr. Roseborough.
Good morning, Dr. Melstrom, and I'll just remind and ask you to speak slowly today for the sake of the court reporter and Spanish language interpreter, please. Where are you employed?
I work at Loyola University, Chicago.
How long have you been employed there, and what is your position?
I have worked there since 2017. I am an endowed associate professor of ecological economics in the School of Environmental Sustainability.
Please briefly describe your education and professional qualifications.
I have a bachelor's degree in economics and business from Kalamazoo College, a master's degree in economics from Michigan State University, and a PhD in economics and agricultural food and resource economics from Michigan State University. From 2012 to 2014, I was assistant professor at Salisbury University, and from 2014 to 2017, I was an assistant professor at Oklahoma State University before joining Loyola. I have 14 years of experience conducting research on the economics of environmental resources, which includes collecting and analyzing data, hypothesis testing, and preparing reports and writing peer-reviewed articles on the economic effects of pollution, remedial actions, and environmental policies. I published more than 60 articles and book chapters on environmental matters. And as a respected professional economist and academic, I regularly referee the work of other economists. I developed the environmental economics and sustainability major at Loyola, which teaches students how to measure the benefits of environmental resources and the costs and benefits of environmental regulations. I'm a member of the Association of Environmental and Resource Economists and the Agricultural and Applied Economics Association. And I was previously managing editor at the journal Agricultural and Resource Economics Review. And I'm a current deputy associate editor at Cogent Economics and Finance.
Thank you. Did you file written rebuttal testimony in this matter?
Yes, I did.
Do you have any corrections that you would like to make to that written testimony?
I do not.
Do you adopt that written testimony as your testimony here today?
Yes.
Please provide a summary of your written testimony.
The New Mexico Environment Department invited me to review the written testimony of Martha Marapesi regarding the economic consequences of proposed Rule 20.13.2 NMAC. My rebuttal addresses three specific claims in Ms. Marapesi's testimony. First, that there are no consumer benefits from labeling. Second, that the costs of labeling are astronomical. And third, that the economic burdens outweigh any benefits. I understand that the proposed rule prohibits the sale of products with intentionally added PFAS to be phased in between 2027 and 2032. It requires manufacturers to report products containing intentionally added PFAS, including the purpose and amount of PFAS. The rule also requires manufacturers to label products to make consumers aware of intentionally added PFAS, with some exemptions and waivers available. I understand the board gives weight to economics when considering proposed rules. This is described in terms of technical practicability, necessity, and economic reasonableness. In regulatory economics, economic reasonableness can be interpreted in two ways. The first interpretation is whether the benefits exceed the costs. This includes the non-monetary benefits of environmental regulations. I am closely familiar with these techniques that economists have developed to measure non-monetary benefits. I have applied these techniques in my own research. The second interpretation is whether a regulation achieves its outcome at lower costs than alternative regulations. My testimony focuses on the first interpretation. Ms. Marapesi claims that benefits to consumers will be minimal. She bases this on a review of studies on the health risks from PFAS associated with medical equipment. This approach is problematic for three reasons. First, it extrapolates PFAS health risks associated with medical devices to a broad range of final consumer goods that will have different exposure pathways and use patterns. Second, it extrapolates economic impacts from medical studies rather than from economic studies, which need not align. Third, it does not attempt to measure the economic benefits of warning consumers about PFAS presence. Whether consumers benefit from PFAS labeling depends on their willingness to pay for that information. Willingness to pay is one of the key measuring rods economists use to calculate benefits. To be clear, willingness to pay does not indicate what consumers will actually end up paying, only what they would be willing to. The difference between what consumers are willing to pay and what they actually pay is a measure of the benefits to consumers. This is how economists quantify the value consumers receive from products and policies. Importantly, willingness to pay does not have to align with medical risks because consumers care about many things beyond just their personal health. They also care about environmental impacts. Thus, minimal health risks associated with a particular class of medical devices should not be taken to imply that consumers will not benefit from labeling. Although a review of the literature turns up only a few studies on the benefits of PFAS labeling, the evidence is clear that consumers value PFAS information. Here's a brief summary of this literature. One study of U.S. dinnerware products estimates benefits of $1 to $2 per sale for bio-based over PFAS-treated versions of the product. Several studies on real estate markets report that buyers pay a significant premium to avoid PFAS-contaminated water systems. A study from Sweden shows that consumers prefer garments not treated with PFAS. These studies demonstrate that consumers value information about PFAS, which has measurable economic benefits. There is also extensive evidence that consumers benefit from labeling in general, even when personal health risks are low or uncertain. Economic studies show consumers value environmental labels on cars, electronics, and food products. Research shows that consumers want to know if, for example, mobile phones and batteries contain toxic components. Consumers use labels to make informed decisions about environmental impacts from using and disposing of products, not just for assessing personal health risks. Based on the literature, it is my opinion that the evidence does not indicate that there are no benefits from PFAS labeling. On the contrary, the available evidence indicates that consumers will value and benefit from PFAS labeling. Next, Ms. Marapesi claims that costs will be astronomical. This raises two concerns. The first concern is that there's no context for astronomical. It is unclear what benchmark is used for this characterization. There must be some comparison in order to conclude that compliance costs will be astronomical. Potentially insightful comparisons could come from answers to questions like, how do the costs compare to benefits consumers would receive? How do the costs compare to alternative regulatory approaches? How do the costs compare to manufacturers' revenues and profitability? Or how do the costs compare to updating labels in general, which manufacturers periodically do? Ms. Marapesi's testimony does not answer these questions. The second concern is that she estimates costs by improperly extrapolating from California's Proposition 65. She takes a 2015 estimate of $1,400 per product, adjusted for inflation, which produces an annual cost estimate of $21 to $41 million. This extrapolation is flawed for two reasons. The regulatory requirements aren't comparable. Proposition 65 covers approximately 900 substances, whereas the proposed rule targets a specific class of chemicals. The narrower scope of the proposed rule implies lower compliance costs. There is also no attempt to scale the unit costs appropriately. The Proposition 65 estimate cannot be applied without determining or estimating, for example, how many products are sold in New Mexico that contain intentionally added PFAS. Proposition 65 unit cost needs to be tailored to this specific rule for New Mexico. Thus, in my opinion, there's no basis to claim labeling costs are astronomical. The estimate is the result of a flawed analysis that wasn't tailored to the proposed rule. The third concern is that Ms. Marapesi frames the costs of the rule as dire and the benefits as minimal. However, this framing is based on analysis that quantifies costs, but makes no attempt to quantify the benefits. To balance Ms. Marapesi's testimony or cost estimate and avoid biasing the economic evaluation, I will provide a benefit estimate by transferring and scaling findings from a peer-reviewed study that measured the economic benefits of mandatory labeling. The National Bioengineered Food Disclosure Standard requires food manufacturers to disclose genetically modified ingredients. Maria Loureiro and Susan Hine in 2004 estimated an average benefit to U.S. consumers of $81 per household per year for such labeling requirements. This benefit estimate is based on measures of willingness to pay that reflect consumers' desire to avoid products associated with health and environmental concerns. This estimate is transferable to PFAS labeling because both policies address missing information about products attributes that consumers want to avoid in order to reduce health and environmental risks. Both PFAS and genetically modified foods are product attributes where consumers perceive human and environmental health concerns. And the Loureiro and Hine study examined a mandatory labeling policy just like the proposed rule. These similarities increase the likelihood of an accurate benefit estimate. Adjusted for inflation to 2025 gives $145 per household, and then multiplying that by New Mexico's 837,414 households indicates a benefit of approximately $121 million annually. This benefit estimate exceeds the compliance costs Ms. Marapesi projects, even using what is likely an inflated Proposition 65 methodology. Moreover, this is a deliberately partial conservative estimate for three reasons. First, $145 is a lower bound estimate of the average household benefit. Second, it is based on the food sector, whereas the proposed rule applies more broadly. Food products absorb only 5% of GDP spending in the goods producing sector, whereas durable goods, clothing, and other goods absorb 15%. Third, scientific certainty about PFAS impact suggests higher benefits because evidence clearly indicates PFAS pose health threats, whereas the scientific consensus is that genetically modified foods do not. In conclusion, Ms. Marapesi's testimony presents an incorrect assessment of economic reasonableness. Scholarly literature provides evidence that consumers value and benefit from labeling. There's no basis to claim labeling costs will be astronomical. The cost estimate relies on a flawed extrapolation that was not tailored to the proposed rule. When I transfer and scale estimates of mandatory labeling benefits to the New Mexico context, using established economic methods, the benefits outweigh Ms. Marapesi's own cost estimate, even though the benefit estimate is deliberately conservative. Thus, it is in my opinion that the proposed rule satisfies economic reasonableness under the benefit cost interpretation. Thank you for your time.
Thank you, Dr. Maelstrom. Madam Hearing Officer, Dr. Maelstrom is available for questioning.
Thank you very much, Dr. Maelstrom and Mr. Roseborough. Mr. Trujillo or Mr. Mullenberg?
Good morning, Madam Hearing Officer, and thank you. Dr. Maelstrom, good morning. My name is Dal Mullenberg. I'm an attorney for the American Chemistry Council in this proceeding. Thank you for your testimony. A part of your testimony addressed studies on consumer willingness to pay for certain obligations. You cited a study estimating that consumers are willing to pay $1 to $2 more for a non-PFAS treated version of cookware compared to an overall purchase price of $5 to $6. Is that an accurate statement of your testimony?
Yes, that was a value in this testimony.
So if we compare the upper end of the willingness to pay of $2 with the lower end of the purchase price range of $5, would you agree with me that that indicates consumer willingness to pay up to 40% more for non-PFAS treated cookware?
Well, this value was not transferred in the benefit estimate that I conducted. So I would need more time to consider what the proportional benefits would be of this product attribute.
Okay, fair enough. Do you have any reason to believe that this willingness to pay figure that you've cited here would extrapolate to other consumer goods with a much higher unit cost than cookware?
Okay, this is referring to the cookware benefit
Yes.
estimate? It could be used to extrapolate to other products, yes.
Would you agree that it could be extrapolated to products with a much higher unit cost than cookware?
As you move the extrapolation from one product to another, the quality of the transfer will be a function of how similar those goods are. So it depends on the good that you're transferring it to. If it's a similar good with similar product attributes, then it would be a good transfer. If it is not similar and it has different product attributes, it could be a poor transfer.
Is the willingness to pay approach that you've discussed here any indication that economists recognize that consumers will ultimately pay the costs of regulatory programs such as this one?
The willingness to pay does not reflect what consumers would actually pay.
Are there any assumptions underlying your testimony or the studies you cite regarding how regulatory costs are passed on to consumers?
Not to my knowledge.
You criticize Ms. Marapesi's estimate of compliance costs. Did the department request that you do any independent analysis of the estimated cost of the labeling requirement to manufacturers?
I was asked to review the testimony and provide an assessment of it.
Did the department ask you to estimate the costs of the proposed labeling requirements of NMED's proposed rule to consumers?
No.
Have you seen any studies in your literature review addressing the cumulative cost impact to consumers of multiple new regulatory programs?
No.
In your literature review, have you seen any studies of how mandatory labeling requirements imposed by one state might affect manufacture or distribution of products in that state?
No.
Thank you, Dr. Maelstrom. That's all my questions.
Thank you, Mr. Molenberg. Ms. Feebig?
Yes, good morning. Good morning, Dr. Maelstrom. I'm Rebecca Feebig, and I'm representing the Complex Products Manufacturers Coalition and the Alliance for Automotive Innovation. And I just have a few questions about your testimony. First, I wanted to clarify a statement in your written testimony. You indicated you were retained to rebut 3 claims made in Ms. Marapiz's testimony, right?
That's not accurate. I was not asked to rebut 3 claims. I was asked to review the testimony and provide my opinion with respect to that testimony.
Okay. And you highlighted 3 particular areas of concern at the beginning of your testimony. Is that in bullet points on page 3?
That's correct.
All right. And the first one is that there are no consumer benefits from labeling.
Yes.
And I presume you've read Ms. Marapiz's testimony in its entirety, right?
Yes.
And I was unable to identify anywhere in Ms. Marapiz's testimony where she makes the claim that there are no consumer benefits from labeling in general. Could you direct us to the area that you're focused on for that claim?
I don't have the testimony in front of me. I would need to take some time to get that testimony and point to the specific location. But there were several paragraphs that described medical studies that indicated that there were minimal health risks, and that implied that the benefits to consumers would be minimal. That was the implication in the
Okay,
testimony.
so would it be fair to say that this was kind of a paraphrase of the area in her testimony where she compares the benefits and risks under this particular proposed rule?
Yeah, it is, in my opinion, that was the implication.
Okay. So the statement that you're most focused on is the statement that the rules labeling proposals for exempt complex durable goods are unduly burdensome, as the economic impacts of compliance for complex durable goods manufacturers will be dire, while the scientific evidence shows that benefits to consumers will be minimal. Is that the conclusion that you're most concerned about?
There may
in Ms.
have been
Marapiz's?
other, as I recall, there were other instances in the testimony, but that summarizes it, yes.
Okay, so you quote that same provision from Ms. Marapiz's testimony twice in your report as kind of claim 1 and claim 3. Does that sound right?
I don't recall directly quoting, okay. In my written testimony,
Yeah, on pages
in
4 and on.
italics, these are directly taken from Ms. Marapez's testimony.
Did you say they are or they are not?
They are.
Yeah.
Yes.
Okay, and it's the same statement is claim 1 in
Mhm.
your report on page 4
Correct.
and claim 3 on page 8. It's the same quote, right?
Correct.
Okay, so obviously you've lodged a number of criticisms related to that claim that Ms. Marapiz made in her testimony.
Mhm.
All right,
Yeah, so
and the
I
first,
scaffolded my response to that claim. So the first is acknowledging that, in fact, there are benefits. And then in the second instance, it's me moving to quantify potential benefits.
okay. So the first, one of the criticisms that you raise is that you don't believe that medical risk or lack thereof is a proxy for economic benefit because consumers care about things other than their health, right?
Correct.
And the proper measure of the benefit of the label, in your view, is the consumer's willingness to pay for it, right?
Yes.
And you cite to 2 studies that show consumers are willing to pay more for products that don't contain PFAS, right?
Yes. There are a number of studies that provide evidence that consumers and households are willing to pay to avoid PFAS.
But neither of the studies that you cited look at complex products, do they?
They do not.
They both involve products with readily available alternatives, right?
To my knowledge, there have been no studies done on willingness to pay or complex products with respect to PFAS, to be clear.
Right. Okay. And the 2 studies that are looking at willingness to pay are focused on a category of products for which there are readily available alternatives that do not contain PFAS, right?
That's correct.
And both of them involved products that directly expose consumers to PFAS, right?
I'm not sure how consumers would interpret their exposure to the studies that were done.
Okay. So one is on disposable cookware or disposable dinnerware, I think, right? Plates.
Yes.
So, and the PFAS in that product would conceivably come into contact with the consumer?
Conceivably, I don't know how consumers might interpret their exposure.
Okay.
We do have evidence that they change their purchasing behavior in response to information about the presence of PFAS in the product.
Okay. But a plate wouldn't have necessarily an internal component that would contain the PFAS. I mean, the plate itself, it's kind of one thing, right?
I understand what you're getting at, but what I'm also thinking of, there are other pathways that could affect the consumer demand. So it may not be just personal exposure that they're concerned about, but how the product, once it's disposed of, affects the environment. They could also be concerned about impacts across the supply chain. Workers that produce the product could be at risk of exposure, and that could also affect consumer behavior.
Right. And I completely understand all those points. But my question is just the nature of these particular products. They are products that potentially do pose a risk of direct exposure to the PFAS in the product. In addition to all those other concerns, but that is a fact about these potential products.
Madam Hearing Officer, I'm going to object. He said that, he's an economist. He doesn't understand exposure or how it might come into contact with consumers via various products.
Right. You may have reached the limits of his testimony there, Ms. Feedback.
Okay, that's fine. I'll move on. I understand your position that health concerns are not the only motivator, but if consumers do care about health and are motivated to pay more because of health concerns that turn out to be unwarranted, do you consider that still to be a benefit to the consumer?
It's a benefit to the consumer.
Okay, and
consumers
same question.
reveal their benefits.
Same question for environmental benefits. If the consumer pays more for a product due to unfounded concerns about environmental risks, is that a benefit to the consumer?
Consumers define what is beneficial to themselves. If the consumer benefits and they provide information that indicates that they're willing to pay is positive for a product attribute, regardless of my opinion or the opinions of others about what the impacts would actually be on the consumer or other individuals, if they provide information that indicates they have willingness to pay, then they benefit.
Okay. And you don't quantify the benefit to consumers under the proposed rules labeling requirement by extrapolating from the PFAS related studies, right?
I do not.
Instead, you rely on a willingness to pay study from 2004 that deals with the GMO labeling as a proxy, right?
That's correct.
And you also criticized Ms. Maripes for relying on a Prop 65 labeling information to calculate labeling costs, right?
That's correct.
All right. In the GMO study, the authors found consumers were willing to pay $81 per year to avoid products associated with environment and health concerns, right?
Yes, this study provided a number of benefit estimates. I selected the lowest one.
Okay. And you translated that to 145 in today's dollars?
Yes,
And you assume that consumers would ascribe the same value to avoiding PFAS, right?
it's not clear what the value would be in the PFAS context. It would likely be higher, in my opinion, because the study that I'm transferring the benefit estimate from reflects only a portion of the variety of products that would be affected by the proposed rule.
And you assume that New Mexican consumers are able to pay an extra $145 to purchase products that don't contain PFAS, right?
Well, the study was done and found that consumers would be willing to pay that, which reflects their ability to pay.
Well, for GMO products in a different jurisdiction, right?
It was for GMO products in Colorado.
Did you do any analysis to see how that might translate to a population of New Mexico consumers?
Well, they are geographically proximate, which would increase the accuracy of the transfer.
Are they economically approximate?
Yeah, that's a good question. So between 2004 and today, typical incomes have increased slightly above inflation. So if anything, we would expect that willingness to pay could be higher today.
You have about 3 minutes, Ms. Febeck.
Okay. You also criticized Ms. Maripes for extrapolating from the Prop 65 labeling cost study to estimate the cost of changing the labels for complex products, right?
Correct.
And one basis for that contention was that the Prop 65 regulation, in your view, was more extensive than the proposed regulations here?
Proposition 65 is not targeting a specific class of chemicals like PFAS. It's targeting a much broader range.
Are you aware of the number of chemicals that would potentially be covered by this regulation if it is enacted?
That goes beyond the scope of my expertise.
Do you know how many were covered by Prop 65?
No, I cannot tell you the specific number.
If I were to tell you it was about 900 for Prop 65 and 14,000 for this rule, would you have a basis to disagree with that?
Are you saying there's 14,000 products that are going to be affected by the proposed rule?
I'm saying there's 14,000 chemicals.
It's beyond my expertise.
Okay. The last question I have is your focus on Ms. Maripes's estimate of the costs was limited only to the Prop 65 comparison, right?
Yes.
Did you review her conclusions regarding the EPA studies and the impacts on costs that would be associated with additional compliance burdens?
No.
Okay. Thank you very much, Dr. Maelstrom.
Thank you, Ms. Febeck. Mr. Harris, do you have questions of Dr. Maelstrom?
No, Madam Hearing Officer.
Mr. Harris declined. Mr. Weatherby, do you have questions of Dr. Maelstrom?
No questions, Madam Hearing Officer.
Thank you. Redirect, Mr. Roseborough.
No redirect, Madam Hearing Officer.
All right, we will turn to the board. Vice Chair Sweeney, do you have questions of Dr. Maelstrom?
I have no questions.
Chair Ely?
No questions.
All right, on the platform, Member Bitzer.
I have no questions. Thank you.
Thank you. Member Carrasco? Member Curry?
No questions.
All right, thank you very much. Thank you, Dr. Maelstrom, very much for your testimony. Mr. Roseborough, do you have exhibits?
Yes, I hereby move the admission of all exhibits associated with Dr. Richard Maelstrom.
Right, are there objections? Nope. All right, thank you very much. They're admitted. And again, thank you, Dr. Maelstrom. Our good luck is holding. Mr. Smith here or Mr. Roseborough? Where are we going next?
NMED would like to call Cabinet Secretary James Kenny to the stand. Please.
Terrific, thank you. Mr. Secretary, would you spell your first and last name, please?
Sure. It's James, James. Last name is Kenny, Kenney.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Smith.
Secretary Kenny, where are you employed?
The New Mexico Environment Department.
And how long have you been employed there? And what is your current position?
7 years, just over 7 years, and current position is Cabinet Secretary.
Can you briefly describe your education and professional qualifications for us?
Sure. As indicated on my resume, I hold a master's in environmental engineering from Temple University in Philadelphia, a Bachelor of Science in Environmental Engineering and Technology, also from Temple University. In terms of my professional qualifications, I have 3 decades of federal and state regulatory experience in developing and implementing laws, regulations, policies, and budgets. My professional experience stems from over 20 years of employment at US EPA, but I've also worked as a consultant to the US Department of Justice Environment and Natural Resource Division, as well as an environmental consulting firm in Denver, McCoy and Associates.
Thank you. Did you file direct and rebuttal written testimony in this matter?
Yes.
And do you have any corrections that you'd like to make to that written testimony?
No.
Do you adopt that written testimony as your testimony here today?
Yes.
Thank you. Will you please provide us with a summary of your written testimony?
Sure. In summary, my written testimony focuses on 3 broad areas. First, the testimony makes the case for turning off the spigot to protect public health, the environment, and our economy. The PFAS Protection Act and the rebuttal rule target the sources of PFAS pollution by phasing out and prohibiting the sale of consumer products containing intentionally added PFAS, such as cookware, textiles, and furniture. Without stopping PFAS contamination at its source, the state will likely continue to incur greater liabilities. Second, my written testimony focuses on safeguarding New Mexico's economy. PFAS contamination risks New Mexico's $3.7 billion agricultural industry, our $2.4 billion outdoor recreation industry, and the municipal and private sector infrastructure related to drinking water, wastewater, and waste management. Third, my written testimony focuses on the implementation and administration of the Act and Rebuttal Rule. Consistent with state law and budget direction, NMED is pursuing a fee-based approach to ensure that manufacturers rather than taxpayers cover the cost of implementation.
Thank you. How has the department changed during your tenure relevant to the implementation of this rule?
The department has changed significantly over the last 7 years. Our budget has grown from 90 million in 2019 to over 235 million currently. Our workforce has also grown from over 500 employees in 2019 to close to 700 employees today. The budget and staffing increases reflect an expanding mission of the department through an increase of federal programs and an ever-expanding breadth of state programs. The increases in the budget and staffing also reflect the urgency by which the governor, the legislature expect the department to take proactive approaches to protecting communities and our economy for current and future generations. To do so, the department has developed advanced new laws, rules, and programs, all while modernizing its operations to improve our performance. And this modernization, these modernization efforts include things like paperless processing to expedite services we render, rulemaking efforts, report submissions, fee payments, and public record requests, just to highlight a few.
Can you tell us why NMED is focusing specifically on consumer products rather than just cleaning up existing water contamination?
Yes, and to use a term that we've heard a lot this hearing, because turning off the spigot is the only affordable way to prevent PFAS contamination, and the signing of the PFAS Protection Act into law was the endorsement of this approach by the governor and the legislature. Merely addressing water contamination at a home or business is just a Band-Aid. Remediating groundwater does not prevent recontamination of the same groundwater. We must continue to address the source of PFAS contamination.
Can you give the board concrete examples of how PFAS has already harmed New Mexico's economy and its citizens?
Yes, and these impacts are staggering, to say the least. In 2022, a fifth-generation New Mexico dairy farmer had to euthanize his entire herd of 3,600 dairy cows due to PFAS poisoning. Neighbors have literally lost the farm in terms of their property values. In the tourism and recreation sectors, we've seen unprecedented levels of contamination in wildlife around Lake Holloman, impacting areas adjacent to White Sands National Park. Most recently, we've discovered a groundwater plume affecting 1 in 3 homes in La Cienega and La Cienega communities just outside of Santa Fe. And though that plume has devastated the families as well as those home values. In my life, a salesperson, or in my personal capacity, a salesperson at a big box retailer tried to sell my husband and I fabric protector for a rug that we had purchased. After reviewing the material safety data sheets that I'd requested, I realized the fabric protector contains PFAS at concentrations 50 times the US EPA's drinking water standard. Yet the label on that bottle stated the fabric protector was, quote, water-based, non-toxic, and non-hazardous. Later, the department visited the warehouse where the fabric protector was applied locally. Empty containers were discarded with municipal waste, and equipment and the shop floor were rinsed into the sanitary sewer, which ultimately reaches the Albuquerque-Bernalillo County Water Utility Authority. We continue to see PFAS showing up in our drinking water from sources like these. And most recently, we saw PFAS in the Children's Garden Montessori School in Santa Fe, where it was detected at twice the drinking water standard, in Placitas Elementary School in Sandoval County, where it was found to be 4 times the drinking water standard, and at an RV park in Bernalillo County, where it was found to be 6 times the drinking water standard. PFAS are clearly moving through our economy from business to homes, unknowingly impacting people and the environment along the way. And in the last year, the legislature expanded NMED's authorities or duties to provide private well water testing and home filtration systems. We are also administering infrastructure funding to connect homes to private wells to public water systems as residential properties values are dropping without safe drinking water. So to date, we have received over $14 million in appropriations, and maybe I should clarify, $14 million in the last year in appropriations for this exact purpose. We're hiring staff and contractors to perform this work, securing in and out of state laboratory services, and working through countless legal issues related to anti-donation and legal indemnification issues.
Thank you. How does the department plan to fund the administration of these new regulations?
The department sought seed money from the legislature in fiscal year 2026 and received $1 million to jumpstart our rulemaking efforts. For recurring costs, the department's rebuttal rule proposes a fee schedule for reporting, labeling waivers, and currently unavoidable use designations. This fee-for-service approach ensures the implementation and administration is paid for by the regulated community and not through general fund, which consists largely of broader revenues from taxpayers. With the fee revenue, the department will hire technical, legal, budget, and IT staff to support the implementation. In addition, we will continue our work to modernize our IT data system. We are using the IT framework developed by Minnesota and will tailor that system to implement the rules adopted by the board. We are planning a stakeholder meeting on that IT system in March and its full launch by July 1 of this year. While we are saving resources and time in using Minnesota's architecture, we need to conform with New Mexico standards. These standards are for data governance, IT security, financial security, records management, audit protocols, and the list goes on. Outside of staffing, contractor support, laboratory costs, there are other associated overhead costs like rent, hardware, software, vehicles, supplies, and shared services for things like human resources, procurement, and other such indirect costs. In summary, annual expenses are estimated at about $5 million per year, with a greater expense in the first year due to one-time cost to build out the data system and laboratory.
Can you please explain the fee schedules in the proposed rule and how it was developed?
Yes, as stated in my written testimony, there are 3 administrative fees in the rebuttal rule. These fees are as follows. First, a $2,500 initial reporting fee that broadly applies to manufacturers offering for sale or distribution a product or products containing intentionally added PFAS. This is a non-recurring fee. If there are significant changes made to that report, or a significant change is made to the product or products contained in the initial report, then a manufacturer must resubmit that report and pay a $1,000 resubmission fee. We estimate this fee structure will generate approximately $5 million in initial revenues from about 2,000 reports and about 500,000 or less in future years. The next 2 administrative fees only apply to manufacturers who are seeking a currently unavoidable use or a labeling exemption. The currently unavoidable use fee is $5,000, and that expires within 3 years. It can be renewed for $2,500. We estimate this fee structure will generate $1.25 million in revenues from about 250 applications in the first year and $625,000 in future years due to declining use of PFAS and/or consumer demand. Currently, unavoidable use designation is available when intentionally added PFAS in a consumer product is essential for the health, safety, or functioning of society. And last is the product label waiver, which applies to a lesser number of manufacturers. The proposed fee is $2,000 per product or $5,000 for a category of products. An approved label waiver application is for a term of 3 years. An approved label waiver application may also be renewed for $2,500. Based on industry feedback, we estimate this fee structure could generate approximately $15 million in the first year, depending on the number and scope of applications, with an estimated $7.5 million or less in year 3, with declining revenues thereafter based on PFAS alternatives coming to market, as well as consumer demand of these products. The proposed fee schedule was developed based on various considerations, mandatory duties assigned to the department, discussions and comparisons with other states implementing similar programs, and New Mexico-specific budget requirements.
What are the services the department will offer the regulated community to implement the new regulations?
The department will educate the regulated community on the rules and maintain the necessary technical and legal staff to ensure continuity of our implementation. We will invest in national communications and targeted stakeholder engagement to reach those entities subject to the rule. This is an incredibly important aspect of implementation to help discern fact from fiction when it comes to what requirements the board adopts. We will finish building out our IT system for electronic reporting, label exemption request, and currently unavoidable use applications. We will hold stakeholder engagement, as I indicated previously, in March of this year, with a final rollout in July. The system we're developing will not just intake applications, but also perform quality control while meeting the needs of the regulated community, meaning the submission of fee payments, the availability of policy guidance and documents, a document repository, applicability determinations, reciprocity information with other states, and other aspects that the regulated community needs to be successful in complying with the rebuttal rule. While the IT system will cut down on staffing needs, it will not replace the need for people to review and analyze information submitted to the department. For most of the submissions under the rebuttal rule, NMED staff will perform the following: submission verification, completeness checks, follow-up requests for additional information if something is complete, and conduct more substantial or substantive evaluation of technical data itself. Technical review may be straightforward and relatively quick, or could be more complex and merit legal review, depending on the submissions.
Thank you. If the proposed rule is adopted, would that be of an economic benefit to New Mexicans?
Simply stated, yes. The adoption of the rebuttal rule would save taxpayer dollars, as indicated by my written testimony and multiple witnesses who presented technical testimony. I already addressed the agriculture industry, outdoor rec industry, municipal drinking water and wastewater facilities, and private drinking water wells. But I want to take an example from my direct testimony and just share it here in my oral testimony. The Environment Department spent 5,259 hours, or almost 132 weeks, simply addressing PFAS contamination at Cannon Air Force Base. So the point here is that there are economic savings both to the taxpayer through the industries this rule will help support, as well as the department, so that we can continue onward in our mission in other areas as well. And finally, I would be remiss not to mention the economic impact to New Mexicans who explained to me that they cannot make their mortgage payment because their property no longer has any value due to PFAS contamination.
Finally, will you please tell us how the rule interacts with the current federal regulatory trends?
Yes, while EPA is generally upholding PFAS standards as it relates to drinking water, they are simultaneously proposing disclosure exemptions for products containing less than 0.1% PFAS. This is dangerous because even small amounts in items like treated carpets or heavy cookware are not safe or de minimis for the purposes of drinking water. Our rule, the rebuttal rule, helps to fill those gaps to ensure that New Mexican families aren't unknowingly exposed to toxins in their home.
Thank you for that, Secretary Kenny. I'd now like to move on to your rebuttal testimony. Did you review the direct written testimony of Martha Marapese?
Yes.
Did you identify any inaccuracies with respect to that testimony?
Yes.
Will you please describe those for us?
Sure. I respectfully offer the following rebuttal points in my capacity as Cabinet Secretary of the New Mexico Environment Department. Ms. Marapese's testimony was, I apologize. Ms. Marapese herself was not involved in the drafting of the PFAS Protection Act, nor did she participate in the stakeholder negotiations and policy discussions with industry representatives and nonprofit groups that occurred before and during the 2025 legislative session. I also point out that Ms. Marapese is not a registered lobbyist in the state of New Mexico. Ms. Marapese's testimony relies solely on a plain reading of the law and does not accurately reflect the actual intent of the act. I disagree with Ms. Marapese's conclusion that imposing labeling requirements would, quote, frustrate the legislature's intent. Specifically, her claim that products listed in Section 3A must be exempt from labeling is incorrect. While certain categories were exempted from sale prohibitions, it does not follow that they should be exempt from labeling. Suggesting otherwise denies consumers the right to know what they are purchasing. Ms. Marapese has presented no direct evidence that the legislature intended for these products to bypass labeling requirements. Excuse me for one, just coughing. Okay, sorry about that. Her conclusion effectively masked products made with intentionally added PFAS from those products without intentionally added PFAS, which was no such intention of the legislature. And I'm finished. Thank you.
Thank you for that. Madam Hearing Officer, this witness is now available for questions.
Oh, thank you very much, Mr. Smith Care and Secretary Kenny. Mr. Mullenberg or Mr. Trujillo, hello.
Good morning, Madam Hearing Officer. Before I begin, just don't want to make the same mistake I did last time I had a long cross. How much time am I gonna?
You actually have 45 minutes.
So I thought
Yeah.
45 minutes, and just to confirm,
Yeah.
if there's productive questioning, you do have the discretion to allow it to go beyond.
To go longer than 45?
Yeah.
Well, we'd have to talk about it.
Okay.
Would it help though? Let me just ask, because that would take us past our normal break time for the morning. Would it help to take a short break beforehand? Like 10 minutes or so? 10 minutes?
Yeah, I would suggest doing so.
All right, let's come back at 10:10.
Thank you.
We are back after a short break, and Secretary Kenny is back on the stand. Mr. Trujillo, your questions, please.
Thank you, Madam Hearing Officer. Good morning, Mr. Secretary.
Good morning.
I'm going to start at the end of your direct testimony and some of what you covered in your rebuttal, where you discuss turning off the spigot. In terms of percentages from 0 to 100, if you were to implement the proposed rule without the labeling requirements, how far do you think New Mexico would get in turning off the PFAS spigot?
I'm not sure that I could answer how far New Mexico could get with turning off the spigot. Yeah, it's hard for me to estimate that. We wouldn't get very far.
Mr. Secretary, let's turn to another section in your testimony. Your testimony indicates that you served as the architect and technical expert for the PFAS Protection Act during the 2025 legislative session. Is that correct?
Yes.
What do you mean by saying that you are the architect and technical expert? Can you give us some more explanation of what that means?
Sure. In 2024, I had drafted, after seeing what was happening nationally and working through my capacity at the Environmental Council of the States, was looking across the country at different PFAS protection acts, and worked with the administration to draft an outline of what a bill would look like, and then worked with various sponsors to bring that bill into the legislative session. And then during that time, during the 2025 legislative session, continue to meet with stakeholders as well as legislators and shepherd that bill, that governor's bill, through the 2025 regular session. Committees, served as an expert witness for the bill, and ultimately helped shape the policy that is contained in that, or all throughout, shape the policy that's contained in that bill.
Thank you for that answer and providing some additional explanation. So it's fair to say that you're familiar with the legislative history dealing with the PFAS Protection Act during the 2025 legislative session, correct?
That is correct.
And the PFAS Protection Act started out as House Bill 212, correct?
Once it was dropped, yes, it was House Bill 212.
And when the bill received its first committee hearing before the House Energy and Environment and Natural Resources Committee, you agreed to a bunch of amendments, and these amendments were put into a substitute bill called the House Energy, Environment and Natural Resources Committee substitute for House Bill 212. Is that correct?
That is correct.
These first set of amendments did not include any language giving the Environmental Improvement Board authority to label products, correct?
That is correct.
The House Energy and Natural Resources substitute for, and I'm going to refer to it as the first substitute, if that's fine with you. The first substitute passed out of its first committee, correct?
That is correct.
And during that committee hearing on the first substitute, was there comments that were given on the labeling provision?
To clarify, we're still in the House
Energy,
right?
correct.
I believe that notably took place on my birthday, February 8th. So it stands out in my mind. But there were discussions by Representative Henry, Representative Montoya, Chair McQueen, and others in the committee about the need for education through labeling.
And after that bill, the first substitute passed out of the House Energy Committee, the next stop for the bill was the House Judiciary Committee. Is that correct?
That's correct.
And during the hearing before the House Judiciary Committee, you agreed to another group of amendments, correct?
That's correct.
And when I say you, I'm saying obviously it's subject to the sponsor of the legislation approving it, but you had the pen effectively to make changes to the legislation, correct?
Given that this was a governor's bill, there arguably were multiple people, from legislators to industry stakeholders to NGOs, as well as a countless number of people who were asking for changes. But I will agree with you that ultimately a lot of that decision making came down to me.
During the hearing before the House Judiciary Committee, you agreed to another group of amendments. Is that correct?
I believe that's correct.
And these amendments were contained in another substitute bill, correct?
Correct.
And the second substitute bill was called House Judiciary Committee Substitute for House Energy, Environment, and Natural Resources Committee Substitute for House Bill 212, correct?
That is all too familiar, yes.
I'm reliving the 2025 session also, Mr. Secretary. It was at this point that the amendment to allow language giving the Environmental Improvement Board discretionary authority to label products was included in the PFAS Protection Act, correct?
That is correct. I believe that's correct. I do agree that the discretionary language, the may was added, and I believe that is when it was added. I have no reason to dispute that.
Violate some of the rules of cross-examination, but I'm curious, so I'm going to ask the question. What were the reasons for you agreeing to the discretionary labeling provision at this point in the process?
Double checking. I didn't get an objection from my own counsel there on your question, but happy to answer that question. I think you accurately captured the history of the bill in the session. As the bill was introduced, it was introduced with a number of agency bills. One other related to PFAS, one related to the circular economy, et cetera. That may ultimately be relevant later, so I just wanted to highlight that now. As those bills started to move through the session and the PFAS Protection Act had its committee hearings, we heard from multiple legislators, in-house energy, judiciary, and others on both sides of the aisle that education around PFAS and consumer products was an essential part of the bill. So working with House minority staff, put together the language that is ultimately in the bill today, the law today. The notion of the shall versus may was a consideration of mine in that anyone can petition the Environmental Improvement Board. It is not simply the department's responsibility. With that in mind, the information related to labeling, I thought better to be a may, because we could achieve the legislative intent of education through labeling, but it would not put the board in the position that should, let's say, an industry group, and no offense to those who are here petitioning today or a part of this hearing, wanted to petition a different label before the board. It being a may not shall would put the board in a more favorable position to exercise discretion outside of adopting multiple proposals or unfavorable proposals related to labeling.
Thank you, Mr. Secretary. But just to be clear, you personally didn't feel that labeling was important enough to put in the original draft of the bill as it was first introduced when the legislative process began, correct?
I'm sorry, could you, I just didn't hear the beginning.
I said you personally didn't feel that it was important, the labeling requirements were, or discretionary labeling authority, excuse me, was important enough to put in the original bill as it was dropped, correct?
That's not correct. The department has sought to include education through labeling or envisioned that to be a core component of the bill from its inception. And the reason it wasn't explicitly stated is because there was a generic component of the bill that said effectively, and I'm paraphrasing, that the board could adopt rules to implement the law. So it was a broad statement. In working with, again, House majority, minority, there were concerns expressed from the minority that while labeling was important, that opening up too broad of an authority to the EIB was not something that their caucus would want to see happen. So we added the provision of labeling and sort of created more of a finite duties of the board as opposed to an expansive duties of the board. But again, I just want to return to the premise of your question. Labeling was always a component that the department felt was necessary, and that was only amplified by the legislature.
And after, let me take you back real quick in terms of the process. So the bill went to the House Judiciary Committee, the second substitute, correct?
Correct.
And then as the bill then progressed to the House floor for consideration by all 70 members of the legislature, correct?
It did progress to the House floor, but I don't believe all 70 were sitting that night on the floor. So I just want to be cautious about agreeing to 70 people voted on it.
But the bill didn't get heard for a while, correct?
I'm not, it sounds like you know the time between the judiciary and the floor. I don't have a specific recollection if it was a while or not. Maybe that's subjective.
I'll help you out a little bit.
Okay.
So it was on the House floor calendar right after the second substitute went to the House floor calendar, correct?
Yes.
And then all of a sudden, a while passed and it got referred back to the House Judiciary Committee, correct?
Yes, that is correct.
And why did it get referred back?
I believe to make it's actually, now it's coming back to me, so give me a moment to recall. There were provisions that there were still more amendments that needed to be made to the bill. And legislative leadership, this is not my area of expertise, by the way, felt that the appropriate path was to make those in a committee through a committee sub as opposed to floor amendments.
And that's your understanding of why it was held up on the House floor?
That's my recollection.
Okay. And then it went back to the House Judiciary and a third substitute bill was created at that point, correct?
There were amendments at that point, and I believe it was a committee sub ultimately that went back to the floor then.
And then I'll make the rest of the legislative history easy for you just to finish off the thought process. It went back to the House floor, passed the House floor, went to one committee in the Senate, passed, went to the Senate floor, passed, correct?
Correct.
Thank you. Mr. Secretary, are you aware of the position of my client, the American Chemistry Council, is that those products that are exempted from reporting and prohibition section under the PFAS Protection Act should also be exempt from the proposed mandatory labeling requirements?
Yes, from conversations that we've had during the legislative session and then subsequently through the proposed rule and the rebuttal rule, we've met numerous times with the American Chemistry Council regarding their concerns, including that position.
Mr. Secretary, so there is a total of 16 exemptions that were set forth, and let's call it the prohibition section of the statute. Does that ring a bell to you?
I think you're referring to the exemptions for products that are prohibited for sale at the, yes, 16, I think ultimately in the final rule did not start out that way.
Correct. I'm gonna try this exercise once because I don't want to go through all 16, but let's see how we do and how expeditious we can be here. So let's take the first one, for example, the first exemption in the statute. So pursuant to section 74-15-3A1, a product for which federal law governs the presence of per or polyfluoroalkyl substance in the product in a manner that preempts state authority is exempt from the prohibitions, right? Due to the prohibitions.
I'm pulling up the bill or the law. If,
I read from it directly. I'll save you time. I'm quoting directly as to what that particular section says, if it helps.
okay, so you're asking me to agree that that's what it says?
So, yeah, assuming I'm correct, then my question is.
Objection, Your Honor. He can consult the document himself.
That's fine.
Yeah, if you're going to ask him a question about it, he ought to be able to read it.
Absolutely.
So can you just direct me? You're in section 3, you said?
Yeah, section 3.
And can you give me, can you tell me where you are specifically? Section 3?
A1.
A1, okay. And you're asking me to confirm what that says?
Correct.
A product for which federal law governs the presence of a per or polyfluoroalkyl substance in the product in a manner that preempts state authority. So yes.
As the architect of this act, why did you agree to this exemption?
I do think this is based on conversations with our council about federal requirements. So I would, on the advice of council, included this.
And my next question for you, related, what benefit will New Mexico get from requiring these products to be labeled even though they are exempt from the PFAS prohibitions?
Objection, Your Honor, calls for a legal conclusion.
Mr. Secretary, same caution I've given earlier witnesses. To the extent you can answer as a regulator, terrific. If not, we know you're not a lawyer.
Thank you for the clarification, Madam Hearing Officer. Is there a particular product that you could use as an example, or are you just, a range of products could fall into this category? Is there a particular product?
Overall,
and your question is, what benefit would there be to New Mexicans by requiring a label on a product that's exempt pursuant to this
correct.
piece? So with respect to agriculture, I think that would fall under this category in terms of maybe a pesticide where there are federal requirements placed on the label, and therefore it would otherwise be exempt. And if I have that construct correct, then the benefit to New Mexicans, and I'm thinking of the many farmers that I've sat around their kitchen tables with down in Clovis and Curry County, who express concerns to me that they're unaware of, they're aware of PFAS in their community, but they're not necessarily aware of what added PFAS might be affecting their family, their farm, etc. So I think there's a benefit there to that product still having a label requirement.
And the having that label requirement on there for the pesticide. Well, the pesticides, I probably should have stopped you. It's a bad example because it was further down in the bill. There was actually a 17th exemption, correct? That was included in the ag consultation provision. Is that correct?
There is a separate section of the law that addresses ag pesticides, so I agree.
And the pesticide issue is a distinct issue because it's arguably, and I think it is, preempted under FIFRA that the state can't change the labeling requirements, correct?
Objection, Your Honor. That's another request for a legal opinion.
Same caution.
That is my understanding.
Is there another example you can think of?
Give me one moment because I have one in mind, but I just want to double check the other exemptions to see if it's the same pathway that I'd be going through.
I'll actually save you some time. We're going to go ahead and switch topics right now.
I was thinking pharmaceutical. But if you want to switch topics, fine.
Yeah, let's go ahead and switch topics right
Okay.
now. Mr. Secretary, in your testimony, it includes information on. Someone say something?
I'm not sure about the interruption. Sorry, go
No
ahead.
worries. In your, Mr. Secretary, in your testimony, it includes information about NMED's budget, correct?
Yes, it does.
The sources of NMED's budget consist, according to your testimony, of 34.9% coming from federal funds and about 31% from special revenue funds, and the balance coming from special appropriations and the state general fund, correct?
Correct. And I believe my testimony also lists recurring and non-recurring funds, or differentiates a little bit there in that section as well.
Correct. So NMED is mostly dependent on revenue from on federal funds and programmatic fees, correct?
Correct. Our historical budgeting is around 18% general fund, and the balance being federal and effectively permit fees.
Mr. Secretary, do you have your direct testimony up there, NMED Exhibit 57?
57? I do have my direct testimony open, but let me go, oh yes, I'm looking at 57.
Okay, sounds good. If you go to page 6, and I'll be referencing page numbers to help you if you really want to look at the language, but NMED Exhibit 57 at page 6, you note that during the 2025 legislative session, when the PFAS Protection Act was passed, NMED estimated that implementing the new law would require 10 new full-time employees and cost approximately $1.4 million. Is that correct?
That's correct at that time.
And just to be clear, the 1.4 million was just to implement all aspects of the PFAS Protection Act without the additional requirement of labeling, correct?
I would need to confirm that the fiscal impact report we submitted was not updated post the revision to the committee sub, in order to line up your question about the 1.4 million and when labeling was required. Now that I'm saying that out loud, it probably, well, I'm not going to speculate. I would just need to verify.
I believe if I represented to you that the FIR was updated and went from 1.4 to 1.8 million, would you have any reason to disagree with me on that?
Objection calls for speculation.
You're right. I mean, he's already said he can't speculate.
At that point in time, did you have an estimate that you gave to the Legislative Finance Committee as to what it would cost to implement the labeling portion?
We tend not to, we provide a fiscal impact report based on the totality of our understanding of what the act says and not portions thereof. So I wouldn't be able to break down the labeling portion separate from the total, the act itself. And I don't believe I included our fiscal impact reports as part of my testimony, and I don't. So I'm. It's probably as far as I could go on the fiscal impact report, and its broad statements related to the act as opposed to portions thereof.
In Exhibit 57 on page 6 and 7, you indicate that the legislature did not provide you with recurring general fund revenue to implement the PFAS Act. Instead, the legislature provided you startup funding. Is that correct?
That is correct.
And it was for $1 million to get things set up. Is that correct?
That's correct.
Is this rulemaking going to cost you $1 million?
Maybe it depends how long this goes on for. Yeah. No, in all seriousness, with the appropriation we received, you heard a number of people moving into new roles, experts. You heard from Dr. Eric Chapman, who was a hire that got started under this money. We have an ERG contract that got started under this funding to build the IT system. This hearing would be inclusive of paying for that. The work that our team has done to go across the country and meet with leadership in Minnesota and have discussions with those in Maine is part of this. So this $1 million. So the $1 million is not solely for a hearing or explicitly for the development of the rule. What it is for the rule, but it's all the ingredients thereof that got us to this point.
Mr. Secretary, on NMED Exhibit 57 at page 7 this time, you currently claim that NMED estimates the PFAS program will require 15 to 20 employees and cost between 2.1 and 2.8 million for personnel costs. Is that correct?
Let me just double check the numbers, but I believe that's correct. You're on page 7?
Yes.
Yeah, there, I see it. Yes, 2.1 to 2.8 million for approximately 15 to 20 full-time positions, correct?
So comparing your 2025 estimate to a year later in 2026, you're claiming that instead of needing 10 employees in 2025, now you need 15 to 20, correct?
Correct.
And also you're claiming that instead of needing 1.4, now it's been doubled to effectively 2.8 roughly, right?
Correct.
So is the doubling of the amount of employees and the doubling the amount of personnel costs due to the fact that in 2025, when the act was introduced, you did not contemplate the need for personnel with labeling. And then once the bill passed, you then decided you needed personnel now to do and fulfill the labeling requirements that you're proposing?
No, there are multiple reasons why we refine or how we refine our cost estimates for implementing the law and the rules. While we had been working on this and contemplating what the cost would be, let me rewind for just a second, because I think it would be helpful to say that when an agency is contemplating legislation, you tend to provide that outline of what the legislation will be from both a policy and a budgetary aspect in the spring. And then in the fall, your budget is due to the legislature by September 1st. And then once you're still refining the law, and then you get into the legislative session and you start providing more cost estimates, those fiscal impact reports that we talked about before. As the law evolves and shapes and the contemplation of the rules are needed to implement it, you continue to refine what your cost estimate will be. And our consultation, if you will, but with other states, our deeper understanding of what analytical costs are, and all the things that go into a more refined cost estimate are what took place between 2024, 5, and now in 2026 to give rise to a more accurate number. It's not simply labeling that merits the delta between 25 and calendar year 25 and calendar year 26.
Was labeling a portion of that delta?
Yes.
Thank you. In addition to the 2.8 million in personnel costs, you also now indicate that, and I'm going to do these quickly, you have 25,000, you need an additional 25,000 annually for computer software, office space, another 1.6 to cover increases in contractor support, compliance assistance, public education, and other materials. and an additional 6 million and 800,000 annually thereafter for building an in-house laboratory services related to PFAS testing. Is that correct?
That is correct.
And these estimates were not included in your 2025 estimate, correct?
They were not accurately included as they were in my testimony.
So basically, Mr. Secretary, NBD went from needing 1.4 million in 2025 to now needing more than almost 7 times that amount and a little more than three times the 2025 amount for every year after the initial year of this program. Is that correct? Roughly in those numbers? Does that sound about correct?
I don't know that I would agree with that. I think what we've identified is that the full-time equivalents, meaning, or the FTEs, the people we need, went from, as you read in my direct testimony, roughly 1.4 to 2.2, somewhere in that range. The overhead costs, or the costs for things like contracts, as well as one-time capital cost, meaning for laboratory equipment, et cetera, are reflected in the direct testimony as a result of the bill passing and contemplating the rebuttal rule. Currently, New Mexico sends many of its PFAS samples out of state for analysis, whether that's for landfill leachate, as we've done recently, or PFAS blood testing, as you heard about previously. The state has limited PFAS analytical capacity in-house, and it's fully captive to the Department of Health and the Environment Department's regulatory water program.
Mr. Secretary, you also testified that this program is now going to be funded by 3 categories of fees, right?
Correct. The program would be funded by 3 categories of fees.
If you have excess revenue in one of those categories of fees, do you plan on allocating that excess revenue to pay for any shortfalls in fee revenue pertaining to the other 2 categories?
I want to make sure I understand your question. So if we were to collect fees for reporting and we had, as you described, shortfalls in fees from CUUs or labeling requirements, I don't think I guess the premise of your question is hard for me to understand because you don't budget program implementation based on reports or program implementation based on CUUs or program implementation based on labeling exemptions. The program is the program, and those are the separate fee structures that give rise to the program.
So in your accounting of the fees generated, the revenue from the fees, you don't keep them segregated. You consider the entire pot of money as the revenue for the program, and you can spend whatever that fee was on other types of services related to the other fees.
So again, you're asking me, if the reporting fees come in, let me just make sure I understand your question. The only requirement for all the regulated community is the reporting requirement. And that fee would cover the review and all the processing of that report. If an entity was eligible and wanted to submit for a CUU,
I think we're a little off. Let me make it simple and then I'll move on here in a second.
Okay.
So the reporting fee, you collect, say, $2 of the reporting fee, correct?
It's not $2.
Well, I'm just saying hypothetically, let's say you collect $2 on it, correct? And the cost of reporting to administer the reporting requirements under the program costs $1. So it's generate $2. You have $1 of cost, what do you do with that extra dollar? Are you allowed to use that dollar, or do you plan on using that dollar to support label registrations and renewals and other stuff? Or that $2 that's generated is just going to be dealt with for reporting requirements?
I think it's a simplistic and theoretical view of how government works that doesn't lend itself to an answer to that question, because there are multiple complicating factors with respect to revenue generation and running a program, both direct and indirect costs, as well as minimum residuals that the Department of Finance and Legislative Finance Committee required that you have to show that you have a fluid program for the next fiscal year. So it's not a situation where dollars are fungible in the way you're describing it. They are fee for service, as I think my testimony indicates, and that's the service we will perform.
I'll move on to some other question. I was just trying to, it sounded like the answer to my question was, yes, you do plan on, if there's excess revenue, using it for other aspects of the program other than reporting. Is that correct?
That's not correct.
Will you reduce the fee cost then if you continue to generate excess revenue that's excess to cover the cost of the reporting requirements?
The challenge inherent in your question is your definition of excess revenue. Can you define what excess revenue means to you so I understand how you're asking the question?
If excess revenue is the total revenue generated from the reporting fee minus the administrative cost of dealing with reporting.
That would not be a budgetary definition of excess revenue for the state of New Mexico. So it doesn't track with the way the state agency is required to budget itself.
That's fine. Thank you. So the answer is yes, based on your understanding of the budgeting requirements.
I think I answered no.
No, I'm sorry.
Again, the fees that we collect would be for the services we provide. To the extent that we are required to have reserves in order to budget for the Dr. Eric Chapmans and others who work in the program the next fiscal year. So if your clock inherent in that question is, do you have excess revenue in the calendar year? You have to have excess revenue within the calendar year in order for you to have a program the next fiscal year. So there will always be a remainder in any state program in the 26 special revenue funds we administer that is required for auditing by our accountants, by state treasury, by DFA, by LFC.
Are you aware that there's a difference between a tax and between how you spend fee revenue versus how you spend tax revenue?
I am aware that you have raised this question in multiple hearings that I've either been directly involved with or sat through. But I am not a tax expert, so I don't feel that I could answer that and say yes in a meaningful way or no in a meaningful way. And I just also want to say that I understand the line of questioning. We have not heard this question about fees come up in any of the conversations I alluded to earlier with your clients. So trying to contemplate the questions that we have engaged or the discussions we've engaged with them on, and make sure that I don't misrepresent both what's in my testimony with conversations that are outside of my testimony. So I just want to say that I've not heard this line of questioning from them.
Correct. And my client obviously won't be aware of how you intended to spend it until this particular proceeding and your direct testimony, correct?
Well, again, they've had multiple opportunities to raise this line of questioning in the discussions we've had with them in the session, but more, maybe to your point, more with respect to the rule because that's where they saw the fees for the first time, but they've not raised it. So
We're raising it now.
I understood. I hear you.
I'm going to switch gears real quick, and talk about you had a section dealing with federal regulatory changes. Let's see if we can do this quick. I read your testimony to claim that the federal government's efforts to modify POSCO will increase PFAS containing products in New Mexico. Is that correct?
That is correct.
It is my understanding that despite concerns expressed in your testimony, the POSCA 8A7 rule contains no provisions related to restrictions. Rather, it's about reporting and record keeping, correct?
Objection calls for a legal conclusion.
Same caution.
Yeah, I would disagree.
Okay, thank you. It is my understanding that, well, I'm going to skip to the next one. Mr. Secretary, Dr. Staggs deferred a question to you. I was questioning him on administrative costs. He had, in his testimony, said administrative costs may be recovered for enforcement work for every day the violation occurred and would be assessed separately from the penalty. This will be calculated based on staff time involvement, including overhead costs. Are you familiar with this testimony?
I am.
In NMED 57 at page 7, which is your testimony, you indicate that NMED will incur overhead costs of approximately $25,000 annually, which include costs of inspections, civil enforcement, which will be paid for by the 3 administrative fees in the proposed rule. Is that correct?
Just page 7, last paragraph. Is that where you are?
Roughly, yeah. I was summarizing it for you. You need to take a look at.
Okay, I see the sentence.
So let me ask the question I asked yesterday.
Yeah.
The way I understand it, again, is that if, as a part of the fees, you're gonna pay for overhead with the fees that are collected. Is that correct? Oh, I'm sorry. Is that correct? Let me restate the question.
Please.
So if I understand correctly, you intend on collecting fee revenue and paying for using that fee revenue to pay for a portion of overhead costs, correct?
Correct.
And you're also now, if you get penalized or a penalty is assessed, you're going to also charge and assess cost for overhead, correct?
No, that's not correct.
Why is that incorrect?
So, it helps to indicate that there's a sort of a bright line between the Office of Strategic Initiatives, who's sort of going to implement the IT system and some aspects of the role, and the Compliance and Enforcement Division that will implement other aspects of the role. The fees that are generated from the 3 reports that are in my direct testimony would go for running that program all the way through to the point of compliance assistance, compliance inspections. Okay. So, to the extent that there is a violation that occurred and a penalty was warranted, then the staff time that is related to the pursuing of returning that company to compliance would be borne by that company, the civil penalty plus the fee. The idea being that the broader regulated community should not be paying for one such bad apple to be returned to compliance. That is borne by the violator itself.
And maybe this goes to a question that Chair Yui indicated to a different witness, and maybe this is where the confusion is. So you have a separate now enforcement bureau, or I'm sorry, division, I think is what you call it. Is that right?
It's a division, correct?
So that division is going to get none of the fees, none of the revenue from the fees that are collected in the separate program that's separate and apart from that particular division?
No, they will get fees from that, they will get revenue from the fees collected. The distinction of where additional fees would be collected or the administrative compliance costs would be collected would be related to once a violation is established. In other words, the base program of everybody paying fees would not be, let's say Kyle Staggs is working on that matter. He would then, his time would be paid for by the fees related to returning that entity to compliance.
Mr. Trujillo, please wrap up.
Mr. Secretary, would you agree with me that the simplest way to get the most buy-in with respect to the revised proposed rule and its labeling requirements is to not make the new labeling requirements applicable to products that are otherwise exempted from all reporting and prohibition?
Objection, Your Honor. We're at 47 minutes now.
No, I understand.
Okay.
That was
Just answer this last question and we'll move on.
Yeah, I'm not saying yes to answer your question. I'm thinking your question through. I don't believe that New Mexicans would buy into that proposition.
Well, let's narrow it down just to this is my last follow-up question on this. Isn't really that's where the bulk of the issues are with respect to is the labeling of the otherwise exempted products?
Same objection. We're over time.
I understand. Go ahead, Mr. Secretary.
I think that is one of the areas in which there are objections or concerns related to the rulemaking, but I also, there's legislative intent, there's the work that we've done through the legislature, the work that we've done with communities and the regulated community itself. And I don't think that removing the educational requirement through labeling implements the law or the rule or even serves the purpose of educating New Mexicans on what they're bringing into their homes. So I would vehemently disagree.
All right,
Thank
thank
you.
you. Thank you, Mr. Trujillo. Ms. Vivek, do you have questions of the secretary?
We do not have any questions for the secretary. Thank you.
Thank you. Mr. Harris.
No questions, Madam Chair.
Thank you. Mr. Harris said no questions. Mr. Weatherby.
Yes, I do, Madam Hearing Officer. May I go ahead?
Yes, please go ahead.
Thank you very much. First of all, thank you very much, Mr. Secretary, for the work you've done on this. I know this has been a significantly important matter that you've kind of spearheaded for the state for the last few years. So, and a very important one. So thanks very much for that. I do have some questions relative to, they're in a few areas. First of all, most of the budget questions that I was going to ask the previous witness, you've answered. So thank you for that. I do have some questions relative to staffing. As I'm looking, I typically review organizational listing reports for state agencies on a monthly basis. And one of the things that's concerning, and maybe you can assuage this concern, is the degree of vacant positions in the agency. You mentioned, if you could tell me again how many people that, I think in your testimony you stated that there were 700 and something employees that are currently at the department. Can you confirm what that number was again?
Thank you for your compliment of the agency and the work we're doing. The number of employees, while not in my testimony, that we have today is close to 700, probably about 685. somewhere in that range. We are budgeted, we have this gets complicated with budgets, but I'll let you continue with your questioning and then I'll try to answer more of your questions around staffing.
Okay, so um, uh, we look at organizational listing reports, but we also look at every few months we get a printout from SPO of the actual employees of every state agency, and they comport with pretty accurately with the organizational listing report, which does cumulative. It's also a list of employees by name, by salary, and the like, and it cumulatively identifies the number of positions within each division. And overall, for the agency NMED, give you an example. The February 2026 shows 820 positions that are allotted to NMED, and 688 are filled and 135 vacant. 1225, it was 859 positions available, 668 filled, 191 vacant. Going back to last summer, it was at 838 positions with approximately 198 vacancies. And again, going back to January of 2025, there were about 210 vacancies. I'm looking at also the most recent one, and I would like to ask you if that's going to be a problem with, I know you're budgeting new positions for compliance. Is that going to become a problem filling those positions? Because there seems to be an ongoing problem with the overall meeting of the agency's needs with positions.
Objection just to the compound nature of that question. That was
Okay. Okay, and that's fair. And I'll try to. Given the relatively high vacancy rate within the department, are you anticipating being able to staff up, first of all, sufficiently to enforce the new rule, assuming it gets approved?
Yes, and again, let me take that question apart a little bit and try to answer it as in a layman's way. I agree with the numbers you provided, roughly, that we are budgeted according to State Personnel Office data around 800-ish employees, and we 820, somewhere in that range, 840. And we are at a staffing level of about 689 right now. So that it does appear on paper and in reports that we have a lot of vacancies. What is not reflected in that information is the agency is required by the Department of Finance and Administration to, and this sounds odd, but to maintain a vacancy rate. And what I mean by that is we are not appropriated the budget to get us to 0% vacancy or 100% fill rate. So we are appropriated for a lower amount of people than is authorized by law. And that usually accounts for things like attrition, where the analysis on the workforce might say that 3 to 4 to 5% of your workforce may leave in the coming fiscal year. So they build in a reduction in your dollars that would appear on paper. We have the money and the positions, but we don't have that. So what's more important to me as a cabinet secretary is the budgeted vacancy rate of the dollars we actually have from the legislature in state treasury that we can spend today. What is our vacancy rate? And our vacancy rate, when you look at that, is sub 5%. I would venture to say it's probably about 2% right now. And when we conduct rapid hire events, which is where we post positions, typically 20 to 30 positions around the state of New Mexico, and ask people to come to like Expo New Mexico and conduct interviews, we tend to get 12 applicants for one position. And beyond that, the Environment Department has been a little bit of space limited as well. So we have now leased a larger space to ensure that we can get that 5% vacancy rate, if it is that high, and I don't think it is, down to even lower numbers, basically to utilize even more of the money that is budgeted to us and more of the money that's available to us through permit fees that we're allowed to tap into outside of legislative appropriations. So I think on paper it's misleading, and in budget reports it's misleading, but what's really important is to know that we're hiring people in 30 days. Our vacancy rate is sub 5%. We have 12 applicants for every one position, and we have a much bigger office space that we are hoping to be into very soon in Albuquerque, where we anticipate we'll have about 350 employees located there.
Okay, thank you very much for that response. Do you feel that the compensation or the classification compensation that's provided under the current system is sufficient to attract and keep the staff that you're going to need?
Objection outside the scope of Secretary Kinney's testimony.
Mr. Secretary, if that is outside the scope, you can certainly say so.
While outside the scope, I would love to answer it.
I'd be very happy for an answer.
Yeah, I think in 20, I think I could define my tenure as before July of 2025 and after July of 2025. And the vacancy rate, the morale, the ability to attract and retain talent was challenging prior to July of 2025. And on July 1, 2025, we received about $6.2 million from the legislature in general fund, specifically for salaries, to appropriately place our staff. That was and then what that did was allowed us to tap into federal funds and other state funds, other permitting funds in the amount of about 3.9 million. Effectively, what we did was on July 1, everybody who had been underpaid and asked to do more than one job prior to that time was now fully compensated with respect to the pay bands, and many were exceptionally happy that they were finally getting paid based on their education and experience. And we had stories of employees saying, like, I'm no longer renting, I'm buying a house, I'm no longer putting groceries on credit cards, I'm paying cash. And it was remarkable. So post-July 2025, I think the compensation is appropriate. People are paid for again, the value they bring to the agency. And we are attracting people away from other agencies or maybe the Department of Energy, et cetera, where we were losing them before. So to wrap up my comments, I think state employees could always be paid more. But that's no longer an obstacle because we've modernized and brought people up to exactly where they need to be.
Okay, thank you very much for that. Let me just check my notes here. I do have some other questions. You mentioned let me pull up your testimony and find the page. Can you, shifting gears a bit, can you describe what you consider to be a consumer-facing product?
Objection calls for a legal conclusion.
Same
Well, it's in
caution.
his and it's also in his testimony. He makes reference to it.
Yes, and I just would highlight that I believe that's defined in both the statute and in the rebuttal rule. So I don't think I'd have an answer different than what we've codified or proposed, I should say.
So you're saying, okay, when you say it's in the rule, I'm going to pull up, is in the statute as well?
I'm checking. I'm looking at the version of the statute on the legislative website, which takes me to page 2, line 13, and consumer product is defined there.
And, but, okay, my question was about a consumer-facing product. That's what I was trying to determine. What you mean by a consumer-facing product?
Same objection.
Well,
Do you
it's-
understand the
it's-
question, Mr. Secretary?
I think the terminology is synonymous, but I don't have any distinct definition to offer.
Okay, would, in your opinion as a regulator, would building materials for construction purposes be considered a consumer-facing product?
Same objection calls for a legal conclusion.
Same caution, Mr. Secretary.
And to the extent that there is vagueness in the law or the rebuttal rule, I think we would have to evaluate those on a case-by-case basis. Certainly and maybe practically speaking, what's sold at Home Depot to weekend warriors versus what's sold to commercial builders like I-beams may have different answers to that question.
Well, let's say, for example, roofing materials are sold to both do-it-yourselfers and to contractors at a Home Depot or a Lowe's big box store. They're available to whoever has the green money to buy it. So would that be considered a consumer-facing product?
Same objection calls for a legal conclusion.
Same caution.
And I'm going to express that I'm going to follow my counsel's advice because I don't want this hearing to be a listing of what the department secretary said it is or is not in the rule. I think it merits a more in-depth conversation and understanding.
Okay, that's fair, but it's also fair to ask because something along these lines, because you brought up the example of you and your husband's purchase, I believe, or about to purchase a carpet. I'm assuming that was probably at one of these types of stores. Maybe it wasn't, but how is that different than, say, somebody buying a bag of cement or a bag of treated grass seed or something like that at one of these stores in which a consumer would go in and purchase it versus a landscape company or a general contractor?
Objection, it's a compound question and it also calls for a legal conclusion.
Secretary, if you have something to add to what you've already said, go ahead. Otherwise, if you don't have an opinion on the particular questions being posed just yet, that's fine too.
And can I just ask a clarification about the question
Sure.
before I give an answer?
Certainly.
Are you asking the question related to strictly what meets the definition of a consumer product? Or are you asking it in the context of exemptions, labeling? I just want to make sure I understand the context.
In the context of labeling, would those, the examples I just gave, would they qualify for labeling?
Same
Under the
objection
rule.
calls for legal conclusion.
Same caution.
So would a bag of cement with intentionally added PFAS require labeling? Is that the question?
Correct.
As the rebuttal rule proposes, unless it received, I'm thinking through the mechanics of how the proposed rule, the rebuttal rule would work. And I believe it would require a label. But again, that's with one caveat that I'm thinking I would need to read both the rule and the statute to make sure that my answer here would be reflected or supported by what the board adopts and what the law states.
I understand, and I'm not trying to make it difficult. The reason I'm raising this issue, Mr. Secretary, is you can go into a Home Depot or Lowe's or someplace like that, and you can buy cookware. One of the items that you and others, and myself included, feel people should know more about as it relates to PFAS. In the same store, if you're a worker and you've just bought a Teflon coated set of cookware, and are you going to be given the same, are you going to be afforded the same type of information for a product that you're going to be using in your workplace, and which would theoretically expose you to PFAS if it's in that product? That's why I bring this up, and I realize it's going to this question, and I'm sorry it's taken me long to get to it. Do you feel that what this proposed rule is doing is setting the groundwork for something that will become an ongoing updating as it relates to PFAS materials in products that the public consumes?
Objection outside the scope of his testimony.
Right. It sounds though, Mr. Weatherby, as though you're asking about the future. That is to say, what this rulemaking would lead to in the future, if I heard you correctly.
Well,
And
I guess it could be interpreted that way, Madam Hearing Officer, and I'm sorry that I'm not doing that great a job at explaining it, but what this rule, as its opponents seem to be identifying certain areas that are exclusive of products versus products that are inclusive in the rule, they all have an impact on the general public. And I'm trying to find out if they aren't delineated specifically, where is the decision making going to take place by the department in determining what is going to be something that informs the public of what's in it versus what's not going to be inclusive. And I guess that's
okay, I think I understand better. Mr. Secretary, again, if you have something to add to what you've already said, that's great. And if you don't have an answer sitting here before the program would be adopted or implemented, that's fine too.
Yeah, and with all due respect, it's not, I'm just not clear about the question at the moment, so I think I'm going to refrain from speculating further.
okay. Maybe I could get to it this way. Can you give an example of something that someone might buy at a big box store that would not be included in the labeling that is a building material for that matter?
Objection outside the scope.
Mr. Secretaries, Mr. Weatherby, I'm not sure I understand what you're asking the secretary to do here.
Well, we had an example earlier of that one of the things that kind of brought the secretary's attention to wanting to do this, or his personal experience of going out and buying carpet. Are the other things that are sold in these stores going to receive the same kind? Carpet is mentioned in the rule. Is that not correct, Secretary?
That's correct.
Is
It's
there a
mentioned in
reason?
the law.
It's mentioned in the law. And were there, okay, well, let me ask this question. Were there, you were involved intimately with the creation of that law, is that correct?
That's correct.
So during the course of the lawmaking that took place, did parties that you're aware of move to exclude specific types of consumer products, particularly building materials?
Objection outside the scope of his testimony.
I don't think it is, actually. He was led through a lot of the legislative process by Mr. Trujillo. If you have a memory, go ahead.
Yeah, I think maybe I'm hoping this is sort of getting to the last few questions. The exemptions that were, so to be direct, the answers that were, or the exemptions that are placed into law were both were negotiated or discussed with many different organizations. But coming back to this notion of a big box store and what maybe doesn't have a label, I think it would be clear that products that don't contain intentionally added PFAS that are sitting on the shelf would not obviously be labeled or even subject to this law or rule. And big box stores like Home Depot, Lowe's, Home Goods, a number of fast food restaurants, etc., have all committed to be PFAS free in terms of many of their products, packaging, etc. So those would not be caught up in the reporting or CUUs or labeling portions of the rule.
Okay, Mr. Secretary, you said that they've committed. That's nothing that they're required to do, though. Is that correct?
Correct.
Okay. And Mr. Secretary, your agency also oversees, or actually is in charge of enforcing the OSHA laws, the federal laws, as well as the state laws under the Occupational Health and Safety Division. Is that correct?
That's correct.
So given the expertise that exists within your department in that area, was there any effort made to determine whether workers exposed to PFAS in the workplace, particularly as it relates to construction, were materials that they would come in contact with looked at as a potential product that should be labeled by your agency?
Objection outside the scope.
Yeah, Mr. Weatherby, what I believe you are asking about is perhaps a different potential rule that would come under the OSHA authority. And
well, I'm asking about its labeling, Madam Hearing Officer, with all due respect. I'm asking about a product that, on the one hand, you can go into aisle 7 and pick up cookware, and you can go into aisle 35 to go buy some other product that has materials that PFAS is a component of, and I'm trying to find out whether they looked at that.
okay, so perhaps I could help with a little bit of rephrasing as to whether this rule was meant to address worker safety, I guess, health or safety in the workplace.
So the rule has the labeling requirements in the rebuttal rule have the benefit of educating consumers, New Mexicans, irrespective of where they work. And that has the collateral benefit of educating those who may be in the occupational health and safety arena as well.
So it was not in, so are you basically saying that the agency did not look at this as a potential, as a class of products that could be included in the rule?
I would say there is not one bureau in the Environment Department, including the OSHA Bureau, that has been immune to looking at what their authority is related to PFAS. So while that is not reflected in the statute or the rule, our OSHA program is a inherent part of our PFAS action team that OSI convenes, Office of Strategic Initiatives, convenes. And they have looked at general duty clause under the Department of Labor statutes that the Environment Department administers to see if acute or chronic exposure to workers could be rise to the level of a general duty violation. So while not reflected in this proceeding, it is very much reflected in the fabric of what we're doing.
Okay. Well, thank you for that. And the last question is something that actually was brought up with an earlier witness by Chair Ely. And in your expertise is the PFAS that is contained in produced water or fracking material at all concerning to the agency, and is it covered by this rule? Two-part question.
Objection outside the scope.
Sorry, rephrase your question, Mr.
Okay.
Weatherby.
Earlier, I believe it was Chair Ely had raised the issue of whether PFAS was contained. I can't remember. I wish I had the transcript here, but she brought up the issue of its relevance to fracking fluids. And I was asking the secretary if that is covered here at all.
Objection calls for a legal conclusion as well.
All right, same caution as before, Mr. Secretary, and I'm afraid I don't remember Chair Lee's line of questioning that way, but if you have an answer, you can offer it.
I think the question would distill down to, are fracking fluids with intentionally added PFAS considered consumer products? And that question has not been posed or answered through the law. So I think it would be hard to, as I sit here, it'd be hard to speculate how that would conclude at the moment. And maybe back to the other question, any PFAS moving through our economy, through the environment, is of concern to the department if it's not properly managed. And it's probably important to note that PFAS have many positive aspects related to the exemptions that are in the bill and then followed through the rules. So we've always focused on chasing the risk and making sure that we're minimizing them moving through the environment. But again, I don't know that I can be more helpful at the moment on the question of frac fluids.
Well, do you believe that you mentioned that many PFAS have, or that some PFAS have a positive benefit. Are you suggesting that that's the case as it relates to PFAS that is contained in fracking materials?
No, I'm not suggesting that.
Okay. All right. Well, thank you, Madam Hearing Officer. Thank you, Secretary Kenny. And again, thank you for bringing this rule.
Thank you, Mr. Weatherby. Mr. Smith, care to have redirect?
Yeah, just one question. Secretary Kinney, the rebuttal rule, as you understand it, does not require the labeling of products for which labeling is preempted by federal law. Is that correct?
That's correct.
Okay, thank you.
I'll turn to the board. Vice Chair Sweeney, do you have questions of the secretary?
Yes, I do. Sorry, I'm trying to get my thoughts here together. Give me a second. Um, um, First of all, thank you so much, Secretary Kinney, for attending the hearing and then your testimony this morning. And I appreciate the attention that you've provided this through this hearing process. I wanted to go back to for my understanding, some of, I guess, to what Mr. Trujillo was bringing up, the evolution and all of the work that's been done in regards to the PFAS issue. And so, apologize, I'm trying to get to my questions here. Can you share more details about the work done after the act was passed and the outreach, in particular with the regulated community? I think in your verbal testimony this morning, you touched upon the outreach and how if there was any engagement from the regulated community, I guess the different citizens in New Mexico that were concerned about PFAS. And can you share a little bit about what the department did and maybe in particular yourself did in maybe enlightening us as to where we got today with this, the current revised or rebuttal rule? Thank you.
Thank you, Vice Chair. I appreciate that question. So we've lent a strong voice to the collaboration effort and have worked with industry stakeholders, NGOs, both trade associations as well as environmental associations. We've been into multiple communities throughout the state. Personally have invested a lot of my time. I joke that I now vote in Curry County, but spent a lot of time in Curry County, Santa Fe County, sitting around kitchen tables and talking to community members afflicted with a host of different economic or health issues associate which they associate with, and I'm not disputing it, but I don't have evidence to support it. PFAS related issues, and have met with tribal leadership and explained to them what we're doing with respect to PFAS. There's been incidents around the state where public water supplies have been contaminated with PFAS. Ski Apache comes to mind down in the Mescalero region, and other places throughout the state of New Mexico where we have either engaged affirmatively, again, at the state and national level with different associations and industry stakeholders, or we've been pulled into discussions because of what communities are going through with respect to their experience with PFAS. We've worked with them to understand their concerns and make sure their voice is reflected in both the bill and then, as you point out, post the bill becoming law into the rule itself, and have offered, again, more formally, tribal consultation on the rebuttal rule with all 23 tribes and pueblos throughout the state of New Mexico. So I, there are always someone who say we haven't talked to you yet, but I find it hard to believe someone is unaware, although maybe they are, of the work that we're doing to try to prevent PFAS from moving into their community, or once it's there, how to remediate it. I would be remiss if I didn't also mention, with all the municipalities throughout the state of New Mexico, we've targeted our Clean Water State Revolving Fund monies, our Rural Infrastructure Fund monies, towards solving these types of problems as well. There was a reference yesterday to the New Mexican article. We are administering $18 million in grants. More of that money will be flowing from the feds to harden rural and disadvantaged communities from PFAS contamination. I mean, there's good news in that of the 500 plus systems we've tested, 15 had it. So the media may focus on the 15 that have PFAS, but that also tells us that there's hundreds that don't, and we want to keep it that way. So the engagement has been robust. It's been handled by many people in this room. And I think the highlight that the governor's voice has lent to the PFAS issue on a national level has also elevated the discussion in the state as well, with trying to ensure that PFAS is properly managed as a hazardous waste. And we continue to work that through both Congress and through the current administration as well.
Thank you for that. And I guess I maybe want to hear a little bit more. Was there interaction and engagement by the regulated community in the proposed rule and, the revisions? And if so, what did can you share with us a little bit about maybe if there was engagement and if there was anything that the department did in revising the rule based upon that engagement and maybe some concerns and comments by the regulated community?
Yes. So as my colleague, Eric Chapman, I believe it was in his testimony, or maybe it was in Greg Smith-Keir's opening, that we've engaged since the law went into effect and the rules started to come out as a draft. We've engaged with, and their testimony will be the accurate numbers, mine's a recollection of it, but about 100 individuals representing 50-some associations or companies who would be subject to the rule, making various products that have been discussed throughout the proceeding. Again, one of the larger ones is the American Chemistry Council, and I've tried to make sure that I'm attending those meetings. I've attended others, but I've tried to make sure that I'm attending those meetings as they represent a large component of who will be the regulated community. I think the issues that have been brought before the board with respect to testimony that we'll hear for the rest of the hearing are my understanding of the limited issues that they've had with respect to labeling and some aspects of reporting requirements. And we tried as best as we could to limit the scope of the issues that were coming to the board through the multiple revisions of the draft rule to the, I can't remember all the names, but now to the rebuttal rule. We've tried to limit the scope of those issues. And maybe just to show a little bit more good faith on that, one of the revisions that Mr. Trujillo highlighted in his cross-examination of me was the committee subs. And those committee subs, we didn't wait till the law was passed to engage. We engaged starting in 2024 and worked our way through 2025 on that. And we aligned our sunset dates in law for certain consumer products with intentionally added PFAS to mirror what other states are doing so that industry wouldn't have a patchwork of sunset dates, one in New Mexico, one in Maine, one in et cetera. So we try to align, and I think to this day, nationally, states are somewhat aligned in both the definition of PFAS, and they're aligned in the types of products that are caught up in this, and they're also aligned in those sunset dates to kind of streamline a national implementation.
Thank you for that response, Secretary. And maybe I want to understand more about the regulated community and how the rule will impact the regulated community and how the department's going to navigate implementation. And I thought about asking this question of a previous witness, but I thought I'd hold it for you. Given the broad nature, and we've received some public comments, and I know you haven't maybe read all the public comments received, but it's something that just from my background, I had a question about, but now that we've received public comments. So we have, and in particular, we've looked at the issue out in eastern New Mexico with the PFAS, right? And that's my understanding. There is a permit that Air Force Base has already that is separate of everything else. And Los Alamos National Laboratory submitted a public comment. Just my history and my understanding is they have a separate permit. How do for hazardous waste, and then there's a consent order and other stuff, and I'm not trying to go too far, but I'm just providing those data points. How does this rule dovetail into those particular regulated entities? Will it add to what their permits are, or is it separate of the permit? And in particular for the eastern part of New Mexico and that particular area, I just again from comments and from some of the data points presented and information on the surrounding communities and knowing the history of that particular area, but as well as Los Alamos. And as you mentioned, there's fire retardant has been associated with this particular issue, and we've had forest fires and whatnot, and in particular at Los Alamos. So or in and around Los Alamos for the multiple fires there. So I'm just wondering how this would dovetail into, and if it's too far out, I'm okay. I'm just trying to understand it in terms of existing regulatory mechanisms, and then how this rule will interact with it.
Fair question, and it is admittedly confusing sometimes. And let me try to attempt to try to explain this. The good news about the PFAS Protection Act and the rebuttal proposal before you is it's largely consumer products. That's what it deals with. You will soon have before the board another rule related to the definition of hazardous substance and rules that will be coming out of a different bill, a different law that passed the legislature. That was House Bill 140. So that will be more, that will focus in on firefighting foams and PFAS as it relates to the Hazardous Waste Act. So really, House Bill 212 and the rebuttal rule are, even though firefighting foam is mentioned in the rebuttal rule, it is really the next rulemaking that is, I think, caught the attention of Los Alamos or the Cannon Air Force Base, not so much this rule. So Yeah, I think that's how I would answer that. I've not seen the letter. I heard there was a letter from Los Alamos. And I have not read it, so I would need to read that to be more to be able to address their concerns more specifically.
Thank you, Secretary Kenny, and I'm sorry to put you on the spot with that. I've been checking the public comments and I saw it this morning. And just added to my question, so I apologize if that was too far outside what you were prepared for this morning. I think at this point, Madam Hearing Officer, I need some time to go back through my notes here. So I want to pause on my questioning. If another board member can answer some question or ask some questions, but if you can come back to me, Madam Hearing Officer.
All right. Cherry Lee, if you'd like to ask a few questions, and then we do need to take a break for lunch.
Good morning, Mr. Secretary.
Good morning.
I too appreciate your attention and being here all week for this. I know how busy you are, and this is an important rule. In your response to Vice Chair Sweeney, you mentioned that you were working to align sunset dates in the enabling statutes with that of other states. And I know you've had a lot of discussions with other states individually and through ECOS. Can you tell me how many states have similar rules, or even just, are contemplating moving forward with regulating PFAS?
Yes, thank you for that question. I'm going to both answer it and refer to my direct testimony at the same time, because there's an exhibit in my direct testimony that I think would be helpful related to a document that the Environmental Council of the States, ECOS, puts together that indicates the various landscape in state agencies around the country related to their sets of PFAS regulations, policies, guidance, etc. There's also in that document a handy state-by-state fact sheet that shows which states have labeling requirements or sunset dates, etc. So I just wanted to make you aware, because there's a lot of materials, I understand, but I wanted to make you aware that that does exist in the exhibits, and I think that's exhibit 63 in the direct testimony. But if you look around the country, and at the time we drafted our PFAS Protection Act, there was about, I think, 16 states that had, and I'm going to confirm that in my testimony itself. So at the time, there were, so now I'm in my direct testimony on page 7, second paragraph or first full paragraph on that page. There are 16 states that had adopted 22 different PFAS measures, and 13 of those state legislatures had enacted laws similar or in part similar to what we adopted here in New Mexico. That number has grown and continues to be a discussion that we're having at ECOS as to what is the best way to minimize PFAS moving through the economy. And in fact, I'm leading a panel discussion here at the end of March about hazardous substances, Superfund, and PFAS with Senator Capito's lead staffer and others on this exact topic. The other thing, Chair Ely, that I would just add is we've been to Washington, D.C. multiple times to talk about how New Mexico is threading a needle around PFAS, both preventative and reactive. The model that you're going to hear about in a future rulemaking is being looked at as a national model. And Mr. Trujillo and others were instrumental in sort of bringing people to the table and finding a good outcome for the state of New Mexico. So again, we're leading a number of efforts here with this rebuttal rule, but we're not alone. There's many states who are tied into our timeline as well.
Thank you for that. And then, we've heard that many of these, or some of these states anyways, have exemptions in their rules. I'm wondering if those states require labeling for products that are exempt in their rules or statutes.
Again, a number of states require labeling. Whether or not they have, so there is the same construct. A number of states, and I'm thinking of Maine specifically. Maine has a number of the same exemptions that New Mexico has adopted in law, and they have labeling requirements as well. I'm not sure if, as parallel through our rebuttal rule, where we offer a pathway to label exemptions, that they have that in their rule or their law. I'm not sure that they do or don't. Maybe the testimony of Dr. Chapman would address that, but I would have to do a little bit more digging if they have those exemptions.
More specifically, I'm thinking of, the statute and the rule has 16 exemptions, including, for example, medical devices or veterinary products. We aren't requiring labeling in our rule for that, but as an exempted product, would they still be required to add a label, not, submit an application to become exempt from the labeling, but off the top, would they be required to label or not? Am I being clear? I'm sorry. Or maybe I should give a better example.
I just want to make sure I understood your question. So if you could either just repeat it or give me another example, because I think I was not tracking at one point.
Okay. So for example, we have 16, maybe 17 exemptions if you count the FIFRA stuff. One of those exemptions is cooling, heating, and ventilating products or semiconductor products. Do those states require those products that are exemption from the restriction of sale and distribution? They're exempt from that so they can be distributed even though they have intentionally added PFAS, or do those states require those certain products to have a label? Is that clear?
The question's clear.
Okay.
Let me think that through, and I'm not sure that it's uniform across all states, and I would need to double check that.
Okay. If you don't know, that's fine. It's just one of the issues here today is, are these products that are being exempt under the statute and under the rule, will they have to continue with labeling? Will they have to label in order to sell or distribute in New Mexico?
And yeah, I think that's in Eric's testimony, if I'm not mistaken, but I might come back to your question.
We should probably break for lunch. All right.
Well, then I definitely can come back to your question.
We are back after a lunch break. Good afternoon. Pam or Luis, do you need to bring the session back up on the screens?
Yes.
All
One
right.
moment.
We'll give you a moment.
Thank you.
Are you recording?
Is your screen working,
Yes.
Madam Hearing Officer?
Yes, it
Okay,
is.
good.
Thank you, Luis.
You're welcome.
Thank you very much, Pam. All right, it is 1 o'clock. We are back after a lunch break. We have come to the third public comment session. It appears we have public commenters in the room and online. I'm going to start in the room with Senator Stefanix. Just a couple of things. I'll ask you to comment just once, comment no longer than 3 minutes. Any length of written public comment is welcome. We are making a transcript, and we do have simultaneous interpretation between Spanish and English and Spanish. Ms. O'Grady, if you would, please.
Thank you, Madam Hearing Officer. Si hay alguien aquí presente en la sala de audiencias que quisiera hacer su comentario público en español, por favor, que nos avisen cuanto antes. También para los que están en la plataforma, si alguien quiere hacer su comentario en español, por favor, que nos avisen para que estemos listos.
Thank you, Ms. O'Grady. Just 2 more things. I will ask you pursuant to the board's rules to spell your first and last name, and if you would swear or affirm that you will tell the truth. Now, Senator.
Where do you want?
That stand right there, and it appears the microphone is on. With that green light. If you would please spell your name.
Thank you. My name is Liz, L-I-Z, Stefanix, S-T-E-F-A-N-I-C-S, and I can leave a written statement as well.
All righty, and do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead.
Good afternoon, members of the Environmental Improvement Board and Hearing Officer. My name is Liz Stefanix, and I serve as the New Mexico State Senator representing 4 counties in the state, parts of 4 counties, San Miguel, Santa Fe, Torrance, and Valencia. I am providing public comment today in strong support of the New Mexico Environment Department's proposed rule. I was a co-sponsor of the governor's PFAS Protection Act legislation that the New Mexico Environment Department worked so hard on. They drafted a reasonable approach to reduce PFAS that garnered bipartisan support of both chambers. Phasing out PFAS in everyday consumer products is the only affordable way to address this contamination. And I would like to tell you 2 reasons that I'm very concerned about this. First of all, I represent the community of La Cienega, which has had PFAS in their wells and their water system for their community. These are people who have inherited land or who have moved there for an agrarian form of life. And now they're having to worry about, will I get cancer? Can I get pregnant? Will I have birth defects in my children? Do I need to move away? Do I need to spend thousands of dollars on the systems to clean out my water? Or do I need to continuously buy water for my family and my household? Secondly, the reason I'm here is for the future of the state of New Mexico. It's not for my generation. It's for the generations following us. And oftentimes we at the legislature don't just look at appropriations or things that we would like. And of course, I would like many things to happen. It's really for the people who are growing up and who are going to take over and run this state. So I hope you will take this very seriously. We are spending millions of dollars in the short term for fixes. Some of that money is coming from the federal government, but some of it's coming from the state government. And we would like to be able to help all communities in our state. But if we can phase out this noxious product, which I have in many of my products in my home, and I understand it won't be easy to all of a sudden get rid of certain carpets or certain types of toothpaste or certain kinds of dish detergents, but we all could be educated to start doing that. And having rules in place for all the products that come into our state would be very helpful. So I hope that you will look at the rules, look at all products that are imported, and determine what can be affected by the state in an effective manner. And I'm happy to leave a copy of my comments. Thank you.
Thank you very much, Senator Stefanix. I believe I saw Senator Steinborn on the platform. Is that correct?
Indeed, I'm here.
Terrific.
Can you all hear me okay?
You're a little soft.
A little soft. Okay, well, I will speak up a little bit and sorry my video is not working, but hopefully audio suffices.
Yes, we can hear you much more clearly. Thank you. Would you spell your name, please?
Sure. Steinborn is Steinborn. First
Do you
name
swear
Jeff.
or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Yes, thank you so much for your time today, Commission. I am Senator Jeff Steinborn from Las Cruces, and I was one of the sponsors of this legislation. And I just want to urge you all to adapt kind of a robust application of what the law lays out for this next phase of implementation. I think knowing information and being empowered to make choices that can protect our health are super critical. And without it, it really kind of leaves a little bit hollow the protections that are envisioned in this law. So I want to ask you all to very much support the robust labeling requirements, as well as the fee recovery that's needed to help regulate this program of those that sell these products. We know that PFAS has a very long persistence in the environment, in human health, that can be cancer causing. And so I really applaud the Secretary and the Governor for helping to lead the way on this to protect our health here in New Mexico and our environment, and just urge your full implementation of the law as proposed by the rule. Okay, thank you all very much for your time.
Thank you, Senator Steinborn. I understand Senator Pope is on the platform.
I am. Thank you.
Hello, would you spell your name, please?
Sure. Harold, Pope, and JR for Junior.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Thanks. I just want to call in full support of the rule and what we're trying to implement here. PFAS is just so prevalent in so many of our consumer products. And the only responsible way to address this is to really remove this from the products and access to consumers. Right now, we are already spending millions from the general fund to do short-term fixes when we talk about whole house water filtration systems because of the contamination that we are already dealing with. We need to continue to have decisive action, or else we're going to continue to be spending millions and possibly billions in the future on trying to clean this up if we continue to allow these products to be continually introduced into our environment. This PFAS Protection Act that we passed in the legislature establishes a clear timeline to phase out categories of consumer products containing these forever chemicals that we know are impacting the health and lives of people in our community and our environment. And this rule today will do more to really carry out the remainder of this law and what we've envisioned in the legislature. And I want to make sure that we continue to pursue things like mandatory labeling, because this is an essential step to continue to educate the public, be transparent, and really give our consumers the choices that they need to make when they are buying products. More importantly, the rule also ensures implementations and the costs are being covered, and these fees are being paid by the regulated community and not taxpayers. And I just appreciate all the work that you're doing here today, and just want to be really supportive of this rule. Thank you.
Thank you, Senator Pope. Let's see, is Sanders Moore either in the room? Oh, I'm sorry, I didn't see that. Senator?
Senator Charlie.
Senator Charlie?
I am here. Can you hear me? I apologize for that.
Yes, I can. Thank you. I can hear you. I couldn't see you on my screen.
Okay.
Hello. Would you spell your name, please?
Sure. Angel, Angel, Charlie, Charley.
And do you swear or affirm to tell the truth?
Yes.
Thank you so much. Please go ahead.
Thank you. Good afternoon, members of the Environmental Improvement Board and Madam Hearing Officer. My name is Angel Charlie, and I represent Senate District 30, including communities across Cibola, McKinley, Socorro, Valencia, and a little bit of Bernalillo County. I'm here today in support of the New Mexico Environmental Department's proposed rule. When the PFAS Protection Act moved through the legislature, I raised during the conservation hearing the importance of education through labeling. The department's proposal to use clear symbols is a practical and accessible way to reach New Mexico's diverse populations across languages, literacy levels, and rural geography. As a matter of fact, today I am calling in from Alamo Chapter House, where everything that I say is translated into Navajo because that is the language the community speaks. So we have to meet New Mexicans and tribal communities where they are, not where other states are, and not where outside associations suggest we should be. Labeling gives consumers transparency about products entering their homes and communities. In rural New Mexico, where private wells and septic systems are common, this transparency may be one of the only tools that families have to protect their health and property values. Transparency strengthens consumer choices. It also encourages innovation and investment in safer alternatives. So with that, I respectfully ask the board to adopt the department's proposal so we can continue preventing PFAS contamination while the legislature continues addressing its harms. Thank you so much for your time and centering the communities that we represent.
Thank you very much, Senator Charlie. Sanders Moore?
Yes, hello, good afternoon. Can you hear me?
Hello. Yes, would you spell your name, please?
Yes, Sanders Moore, SANDERS MOORE.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Please go ahead.
Good afternoon, EIB members and hearing officer. My name is Sanders Moore. I am Chief of Staff to Senate President Pro Tem Mimi Stewart, and she was the Senate sponsor of the recently passed House Joint Memorial 3, which urged a strong adoption of a strong rule by the EIB to protect New Mexicans from PFAS. And I'm here, one, to encourage you to do that. We have submitted, she has submitted public comments, written public comments, but I also just wanted to speak from a personal perspective. I'm a mother of a 3-year-old and a 5-year-old, and I know the dangers of PFAS chemicals, the forever chemicals, for many of the reasons that the senators who have spoken before me have mentioned. And as a consumer and a mother, I do my best to protect my family from these forever chemicals. And it's not always an easy task. I've looked for cookware, I've had to call companies, I've had to look on their websites, trying to comb through, where's the information that tells me what type of chemicals are in a pan. It took me over a year to find furniture for my living room that did not contain PFAS chemicals. And I wanted to do this to ensure that my children are not exposed to these chemicals that we know have long-term impacts on their health. And I'm fortunate to know that I need to do that research, but not everybody in New Mexico does know that. So I urge you to please adopt a strong labeling rule so that other New Mexicans and other families like mine here in the state can protect their families and have an impact so that we can ensure that our children are growing up healthy and strong. Thank you.
Thank you, Ms. Moore. I believe I saw Representative Lujan on the platform. Can you unmute yourself? Representative Lujan? Pam or Luis? Does she have permission to unmute?
Yes, yes, she does, Madam Hearing Officer.
Okay, well, she may have stepped away. Let's see. Jean Harrington is another name that I was provided. Mr. Harrington?
Hello, did you want me to spell my name?
Yes, please.
So, Gene, Gene, Harrington, Harrington.
Do you swear or affirm to tell the truth?
Yes, I do.
All right, I'll start your time. Thank you.
Good afternoon, Madam Hearing Officer. My name is Gene Harrington, and I am the Senior Director of State Affairs for the Animal Health Institute. I appreciate the opportunity to speak today to urge the Environmental Improvement Board to retain the exemption for veterinary products from the labeling requirement that is contained in the revised proposed new rule put forward by the New Mexico Environment Department when the board adopts the final rule implementing House Bill 212. The Animal Health Institute represents manufacturers of animal biologics, diagnostics, medicines, parasitides, and feed additives used to maintain the health and productivity of U.S. livestock, service and companion animals.
When?
The animal health industry serves to improve the health and welfare of nearly 10 billion service, companion, and food-producing animals in the United States, resulting in significant health, economic, and social benefits for Americans. The livelihood of farmers and ranchers depends upon their ability to prevent disease and keep their animals healthy, and the human-animal bond is strengthened due to the development of innovative products that improve our pets' quality and length of life. The Animal Health Institute appreciates NMED, including an exemption for veterinary products in the updated version of the proposed rulemaking, specifically proposed 20.13.2.13b3 on page 8, lines 41 to 43. This exemption is an acknowledgement of the strong label preemption in the 3 federal laws, the Federal Food, Drug, and Cosmetic Act, Federal Insecticide, Fungicide, and Rodenticide Act, and the Virus, Serum, and Toxins Act that govern veterinary products such as animal biologics, drugs, devices, and parasitides. Said label preemption has been recognized by the U.S. Supreme Court, various federal appeals courts, and federal agencies. It should be noted that the Federal Food, Drug, and Cosmetic Act, Federal Insecticide, Fungicide, and Rodenticide Act, and Virus, Serum, and Toxins Act are administered by the U.S. Food and Drug Administration, U.S. Environmental Protection Agency, and U.S. Department of Agriculture, respectively. The Animal Health Institute also believes the exemption for veterinary products from the labeling requirement is consistent with the spirit and intent of House Bill 212, which contains an express exemption for veterinary products. This exemption is very similar to the ones contained in Colorado, Maine, and New Jersey PFAS laws. As has been discussed at length, House Bill 212 grants the board much flexibility and discretion in adopting a labeling requirement. Accordingly, the Animal Health Institute respectfully asks the board to include the language in proposed 20.13.2.13b3 on page 8, lines 41 to 43 in the final PFAS rulemaking it adopts. Again, I appreciate the opportunity to comment. Thank you.
Thank you, Mr. Harrington. I believe Representative Lujan may have been able to unmute herself. Representative?
Actually, can you hear me now?
Yes, I can. Thank you so much.
Thank you so much. This is Representative Tara Lujan. I represent House District 48 in Santa Fe, and I'm here for public comment.
Yes, I'm sorry. I have to ask if you swear or affirm to tell the truth. All right,
do.
thank you. Go ahead.
Great, thank you. Yes, I'm here to support the rule that we have put in place through the legislation that we had passed last year for the PFAS regulations, and seeing where we are today and understanding what detrimental effects PFAS has had on us and our environment. I fully support that we implement the rules for regulation. Thank you.
Thank you very much, Representative. Camilla Fiebelman?
Thank you, Madam Hearing Examiner and members of the committee. I'm Camilla Feibelman. I'm the director.
I'm sorry. Would you spell your first and last name, please?
I was just about to do that. Great. It's Camilla. Last name is F as in Frank, EI, B as in boy, ELMAN.
Thank you, Ms. Feibelman. Do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Great. Well, I am the director of the Sierra Club's Rio Grande chapter, and I actually just wanted to start my comment with a little non-topical thank you. I've just been watching the Environmental Improvement Board, its members, its staff, do one profound technical expert-based rulemaking after another. And I don't know how many hours or how many days of a full year you have spent doing that on everything from clean fuels to PFAS. But if somebody hasn't said thank you, I thought this would be a good day for that. So thank you. And I think it's just important for members of the public to understand that, you know, the legislature sets parameters of where it wants us to go. But legislators don't have time to think through every chemical, every industry that might use them and for what reason. And so having this expert technical board at the service of New Mexicans to help make sure that our lives are safe and healthy, and the way that we do it, almost in this trial-like format, is different from many other states, and I think merits some recognition. So again, thank you for that. The second thing I wanted to do is to thank the legislators who brought this legislation in collaboration with the Environment Department. And I think that it's a really good start. I think all of us are very nervous about what PFAS imply for our own health, for the health of our kids and families, our drinking water. You can't watch the stories coming out of southern New Mexico without heartbreak about the fear that people must have to know how profoundly exposed that they've been. But I do want to flag this is a start. I think that we are going to need to go back to the legislature and make sure to include fluoropolymers. You know, this is just another set of PFAS that's in our cookware, and it is being exempted in this rulemaking. Fortunately, you all are within your rights and the parameters of the law to label every product with PFAS in it, whether it is going forward banned or not. And so I and the Sierra Club recommend that you limit to the extreme amount possible what products will be exempted from labeling. Every industry will have their reason for claiming that their PFAS shouldn't be labeled. But all PFAS, no matter what they are or where they're produced or for what purpose, are dangerous to the people who are exposed to them. So while we here in New Mexico might not be producing fluoropolymers, people in West Virginia and North Carolina are exposed to those substances when they're produced where they live. So I view it kind of like pesticides. Who knows if not having pesticides on our food is safer? I just don't want them on farm workers, right? So I think we need to take great care in what industries are being exempted, both from the phase out of PFAS and from the labeling requirements. And so I'm calling on you to limit and take deep care in who is exempted and why, and then call on the legislators in the room to come back to the table, include fluoropolymers. Thank you so much.
Thank you very much, Ms. Feibelman. Let's see. Emily Jones? Emily Jones?
Yes. Can you hear me?
Oh, yes. Hello. Would you spell your first and last name, please?
Yes. Emily is Emily, and Jones is Jones.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Good afternoon, Madam Hearing Officer and members of the Environmental Improvement Board. My name is Emily Jones, and I am the Director of Energy and Environment Policy for the Alliance for Automotive Innovation, representing America's auto industry. As a party to this hearing and an engaged stakeholder, we have, through our attorneys and written comments, shared our significant concerns with the implementation of these regulations as they apply to motor vehicles. In my brief time today, I would like to highlight a couple of top-level issues that remain significant difficulties for our industry, and I will submit a copy of these comments as well as written comments. First, with regards to labeling, we remain concerned that this label provision, even as amended, does not present the consumer with purely factual and uncontroversial information. As a complex durable good, automobiles contain over 30,000 components, many of which the consumer will never interact with, including fuel lines, brake liners, circuit boards, and coated wires. Motor vehicles were generally exempt from the reporting and phase-out provisions of the law, and even the regulations provide an exemption for labeling internal components that the consumer is unlikely to come into contact with. Per the NMED website, the legislation contained, quote, important exemptions and enforcement provisions where PFAS is essential and does not pose serious harm to those using the products. The regulations as drafted create a piecemeal framework that we believe will cause much more confusion than education. Accordingly, we believe that vehicles should be exempt from the labeling requirements. Second, regardless of the final text of the label, the auto industry produces a highly complex product through a network of global supply chains. As global manufacturers, we are required to meet an extensive number of jurisdictional requirements, including Federal Motor Vehicle Safety Standards, or FMVSS, promulgated by the federal government, meaning that any changes we make, including to something like the owner's manual, cannot be done without a significant amount of lead time. While the final text of the label requirement remains unknown, automakers need at least a year from finalization of the rule to implement any change to the owner's manual, and more for changing or labeling any aspect of the product. Finally, I would like to highlight the significant compliance risk created by the lack of a clear definition of textile articles. The legislation only defines textiles and textile furnishings, but refers to textile articles in the vehicle as subject to various provisions of the law. We have raised this issue to the department, and while we recognize that this was a legislative directive that they cannot override, we ask that the board delay any requirements related to that provision until the legislature is able to provide a clear definition to clarify compliance related to the phase-out and reporting provisions of the law. Thank you again for your attention to this important matter. We look forward to our continued engagement with the department and the board on the implementation of this law.
Thank you, Ms. Jones. John Keene?
Yes.
Hello.
Hello.
Would you spell your first and last name, please?
Yes, John Keene, John Keane.
And do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Good afternoon, Madam Hearing Officer. John Keene with the Association of Home Appliance Manufacturers, or AHAM. AHAM is a trade association representing major portable and floor care appliances in the United States and Canada. The total economic impact for the home appliance industry in New Mexico is $560 million. Related to House Bill 212, AHAM was very involved in legislative discussions, including meetings in Santa Fe, to deal with issues related to our products. I'm here to lay out several issues related to the labeling proposal specific to appliance manufacturers. First, with the inclusion of all PFAS, including exempted categories with differing characteristics across all products, we raised concern around consumer awareness through a label where many products would be labeled at a retail store, potentially confusing consumers about products being safe when appliances are bound by national safety standards. Second is around the compliance timeline with expected compliance 2027. AHAM surveyed our members. We expect around 2 years to typically label, which includes designing, printing, packaging, and then distributing out into the market. So the major issue around timing for our manufacturers. Third, there's a distinction around complex durable goods and non-complex durable goods in terms of labeling requirements for appliances, from your stove to your coffee maker. There's uncertainty where products would fit, including appliances would include extra trays or racks, each of them required to label multiple times for one single product. Some AHAM products, including cookware, are bound by PFAS labeling requirements in other states. There's uncertainty around having to provide multiple labels doing very, very similar things. Additionally, for non-complex products, anything embossed into the product creates significant compliance challenges. The department may waive the obligation for manufacturer label if the product's material not come in direct contact with the consumer. With that standard, there's a very unclear standard about what product will be direct contact. There's many with appliances during repair, maintenance, or cleaning. There's every part of the appliance would be impacted by this, which means you have to disclose for all things in your appliance. There also needs to be consideration around spare parts, replacement parts within the labeling requirements. Finally, I want to call out the issue around cost, specifically around the waiver application process. All the issues we mentioned previously would result in hundreds of exemption requests, which would be a significant cost to manufacturers. With this, we would encourage EIB to not pursue labeling requirements until these issues have been resolved. Thank you so much.
Thank you, Mr. Keene. Representative Hernandez? I believe you've joined us on the platform. Representative Hernandez? Palmer Luis, can Representative Hernandez unmute?
They just dropped off the platform, Madam Hearing Officer.
Oh, all righty. Let me ask then if there's anyone else in the room who would like to offer comment during this session. No? Is there anyone else on the platform who would like to offer comment during this session? Please raise your digital hand. Debbie Saranana, if I'm mangling the pronunciation of your name, please let me know. Can you unmute yourself?
Yes, I have.
Oh,
Thank you.
Great. If you would please spell your first and last name.
Sure. It's Debbie Saranana.
And do you swear or affirm to tell the truth?
I do, yes.
Thank you. Please go ahead.
All right. Good afternoon, members of the Environment Improvement Board and Hearing Officer. My name is Debbie Saranana. I serve as a New Mexico legislator representing House District 21 in Bernalillo County. I am providing public comment today in strong support of the New Mexico Environment Department's proposed rule. As a co-sponsor of the PFAS Protection Act legislation, with the guidance of New Mexico Environment Department Secretary Kenny, the act is a reasonable approach to reduce PFAS. Phasing out PFAS in everyday consumer products is the only affordable way to address this contamination. We are spending millions of general fund dollars for short-term fixes, like whole house filter systems, and will spend billions in general fund for capital infrastructure, like drinking water system upgrades, unless we adopt this rule as drafted. The PFAS Protection Act establishes the timing for the phase out of various categories of consumer products containing PFAS. The department proposed rules before you implement the remainder of the law as envisioned by the legislature, by the law we passed. This includes the labeling of all products containing PFAS, which is essential for public education and disclosure. Also ensuring the department's implementation costs are fully covered by fees paid by the regulatory community as opposed to taxpayer-derived general fund appropriations. As appropriators, we cannot afford to only react to PFAS contamination. We must stop it from coming into our state. Last week, the New Mexico legislature passed House Joint Memorial 3, which is a further mandate to the board and department taking bold action to implement the PFAS Protection Act. The outcomes of this hearing will help determine what, if any, changes are needed legislatively in the next session. Thank you to the Environment Department for drafting the rule that complements our legislative intent, and thank you to the board and hearing officer for your commitment to protecting the health of all New Mexicans. Thank you.
Thank you very much, Representative. Is there anyone else online who would like to offer comment during this session? Oh, I think I see Representative Hernandez in the lobby again. Let's wait a moment.
Yes, this is Representative Hernandez.
Yes, hello. This is Felicia Orth. You've joined us here at the PFAS hearing. Do you swear or affirm to tell the truth?
Yes,
All right, if you'd state your name and proceed.
thank you. Again, I do apologize. I'm calling from Shiprock on the Navajo Nation, and my signal isn't that well. My name is Joseph Hernandez, and I'm a state representative for New Mexico House District 4. Did you say spell my name?
No, that's fine. You can proceed.
Thank you. Thank you for allowing me to testify. I want to bring my voice to speak in support of this rulemaking, especially when it comes to PFAS. I want to make sure that we are doing everything we can to protect our communities, including these uh, important rules. As we know, at the federal level, there's a lot of pullback on a lot of the federal policies that are happening to protect our communities, especially our waters and our land. And so at the state level, it's really critical that we do everything we can to make sure that protection of our land, air, and water is there for us. And I stand in strong support of these important critical rules, especially as a father of a growing 8-month-old. I want to make sure that we're doing everything we can, make sure the next generation has an ecosystem that is protected. Thank you very much. Have a wonderful day.
Thank you very much, Representative. Do I understand that Representative Ferrari is on the platform, perhaps as a caller?
Yes.
Oh, hello.
Can you hear me?
Yes, I can.
Hi.
Hi, do you swear or
Okay,
affirm
this
to
is,
tell the truth?
yes, I do.
Oh, thank you very much. Please go ahead.
Okay, good afternoon, members of the Environmental Improvement Board and Hearing Officer. My name is Joanne Ferrari. It's JoanneFerrary. And I serve as a representative for House District 37, which is in Doña Ana County. And I am in strong support of the New Mexico Environment Department's proposed rule. And as a sponsor of the governor's PFAS Protection Act legislation, and the New Mexico Environment Department, specifically with Secretary Kinney, who led this effort and drafted reasonable approach to reduce PFAS that garnered bipartisan support in both chambers. As we were moving the legislation along, Secretary Kinney was getting calls and meetings with all kinds of manufacturers throughout the country and New Mexico, which he incorporated their concerns into the draft of the legislation. And so I think he's already, been very responsible or reasonable to the specifics in the bill. And phasing out PFAS in everyday consumer products is the only affordable way to address this contamination. And as chair of the Consumer and Public Affairs Committee in the House, I believe that this is the best way to protect our citizens. And the PFAS Protection Act establishes the timing of the phase out of the various categories of consumer products containing PFAS. And this includes labeling of all products containing PFAS, which is essential for public education and disclosure. And the departments, we need to ensure that the department's implementation costs are fully covered for the fees paid by the regulated community, as opposed to taxpayers' derived general fund appropriations. And we must stop the products. We can't afford to only react to PFAS contamination, but we must stop it from coming into our state. And last week, I think has been mentioned, our legislature passed House Joint Memorial 3, which further mandates the board and department to take bold action to implement the PFAS Protection Act. And the outcome of this hearing will help determine what, if any, changes are needed legislatively in the next session. So I really want to thank the Environment Department, Secretary Kinney, for drafting a rule that complements our legislative intent. And thank you to the board and hearing officers for commitment to protect the health of New Mexicans. Thank you.
Thank you very much, Representative. Is there anyone else online who would like to offer public comment during this public comment session? Our next public comment session will be 1 o'clock tomorrow afternoon. No? All right, I think then we'll return to the technical case. Let me ask council, do we return to Secretary Kenny's cross-examination, or do we move to another witness based on an earlier discussion in which we talked about juggling one of the industry witnesses?
I believe, Madam Mayor, Officer, you are correct. We had talked about having Dr. Basu go. I believe he is online. And if I can check with him if he's got availability, I'm not sure how much longer Secretary Kenny's testimony will take. Dr. Basu, are you online?
Ma'am.
Do you have any time? I would anticipate Secretary Kenny, we're on board questions, right, Madam Chair, since we're left?
At this point, it is board questions. I'm aware that they have some.
Okay. Do you have enough time, Dr. Basu, to wait for about 30 minutes, 45 minutes, I would guess, to be able to do, or do you need to do your testimony right now?
I can wait for another 30 minutes.
Thank you very much. Thanks for accommodating the secretary. I appreciate that.
All right, thank you. Let's see if we can wrap up the secretary's examination in that time. Thank you, Mr. Secretary, for rejoining us here at the front. When we broke, Chair Ely was pursuing her lines of examination. Go ahead, Chair.
Thank you, Madam Hearing Officer, Secretary. Yeah, when we broke, I asked a very poorly worded question about labeling and asking you to compare the requirements in the proposed rule regarding labeling with labeling requirements in other states, if you know them. And in particular, I was interested in whether other states were requiring products that were exempt from distribution and sale to also be labeled. Do you have an answer to that?
Yes. Thank you, Chair Ely, and I appreciate having something to do over lunch. So just a quick synopsis. There are various labeling requirements out there, specifically Colorado and Connecticut might be more analogous. And Minnesota, what am I saying? Connecticut does not have, they have exemptions in statute, and they don't have a pathway like we have through rulemaking to continue to allow the sale of products through any label exemption, or they don't have an analogous pathway. It seems like everybody texts me when I sit down. So they don't have it. So it's not analogous. But the point being is that maybe they don't have labels on exempted products in Connecticut. Okay, and then Colorado, they have approached their law a little bit differently. And I'll take cookware for example. They have required labels on cookware until it sunsets, and then at that point there's no, it's sunset. The difference being that in New Mexico, fluoropolymers and sort of the next generation of PFAS known as fluoropolymers that are added to cookware have that ability to continue to be sold here. Whereas in Colorado, my understanding is that they won't be they are not going to be sold there. So I think there's a distinction between what will still be in commerce here as a new product and what would be there. And maybe one last highlight for you, Chair Ely, to point towards, I mentioned Minnesota by accident, but they do have reporting requirements for all products, even if they're just for all products. And that reporting requirement is a means by which Minnesota is making that information public. So a consumer, as you heard in public testimony, Sanders Moore, would if in Minnesota would be able to look at the Minnesota information and discern what products contain PFAS without having to navigate exemptions and labeling and things like that. And we do anticipate that we'll make all of the information submitted by manufacturers public. However, there is some aspect of trade secret that is, I believe, in the statute itself.
Thank you. Thank you for your answer. Next question is, there are a number of provisions in the rule and the statute that exempt regulation if there's a federal law around that. Can you describe to me how state law and federal law interact in this bill or this rule, and how we will ensure we're not trying to regulate when there is a federal law in place for a particular product?
As a non-lawyer and knowing my counsel's probably nervous right now, I will just share with you that if there is a federal labeling requirement for that is required under FIFRA, or maybe it's required under the pharmaceutical industry, like FDA, let's say, then the department, I will say, has taken the position, but that's probably not accurate, has indicated that federal law would be governing and that requirements would not be imposed upon those labels because we legally cannot do that. So I think that's maybe the extent of my understanding of how the state is not trying to preempt federal law.
So the full intention is not to regulate if there's a federal law that's already in place for that.
Correct, because labels being governed by the federal government, we don't have the ability, from my understanding, of augmenting those labels.
And does it just apply to labels? Or the reporting or prohibitions of sale?
I think there is an exemption that we inherently codified into the statute and acknowledge in the rule that if there is a federal preemption, it's not only about labeling, but they're not phased out either.
Okay, thank you. I know there's discussion around the whole preemption issue. In my mind, I'm thinking about stringency and the board's requirement to address that issue. And it sounds like because federal law is in place, we're not more restrictive than federal law, so stringency that's in the Environmental Improvement Act is not an issue. So then on the fees, I have a question on the fees. So fees, penalties, and administrative costs for enforcement all go into the same fund as I read the rule. And you'll see in 13.2.6 under objective, it says that penalties, fees, and administrative costs paid are for deposit into the recycling and illegal dumping fund. I know there were some restrictions around that fund, so I'd like you to just tell me how you intend to access that revenue to run the program.
And Chair Ely, it would be helpful for me to maybe go back to the foundation that I laid in cross-examination, indicating that in 2025, there are multiple statutes or multiple bills moving through the legislature, and maybe a theme of those bills was how can New Mexico advance the circular economy? And another bill, I believe it was House Bill 291, was the modernization, as you've heard me talk about both the department and the way the legislature is modernizing the department. That House Bill 291 was the modernization of the Recycling and Illegal Dumping Act. And in fact, it's no longer called that. It's called the Recycling, Circular Economy, and Illegal Dumping Act. So the acronym RAID is no longer available to us, as easy as that is. And in an earlier iteration of the PFAS Protection Act, analogous with the theme that we were pursuing in 2025, was a environmental stewardship program was part of an earlier draft of the PFAS Protection Act. And the idea there was that to the extent a manufacturer would like to manage the life cycle of PFAS in New Mexico, so not only bringing it in a consumer product, but managing it at its end of useful life and keeping it out of water systems and landfills, that they would have an exemption for that product. Now, the legislature asked that we take that out, or some legislators asked that we take that out. So the product stewardship exemption that was in an earlier version of the PFAS Protection Act left, but the Recycling, Circular Economy, and Illegal Dumping Act, or then still RAID fund, stayed. So and I say that, and maybe the connection isn't as strong for you all, and I'll make this connection, is that a product stewardship component of the PFAS Protection Act, as we saw it, was a circular economy. We're looking at the life cycle of PFAS and keeping PFAS out of our environment, so to speak. It doesn't end up in a landfill or wastewater treatment plant filter sludge. So we tied the Recycling and Illegal Dumping Act fund to the PFAS Protection Act then, and it stayed.
Okay.
Okay. And let me just, well, go ahead. I'm apologizing.
No, go ahead. No, please.
So agnostically, the Recycling and Illegal Dumping Fund that's referenced in the rebuttal rule is the fund in which the legislature passed the act, PFAS Protection Act, indicated we could use that fund, and deposits and withdrawals into that fund are governed by the Recycling, Circular Economy, and Illegal Dumping Act then, as augmented by the PFAS Protection Act. So it is confusing. I get it. I understand that managing 125 funds, only one is general fund and everything else is yet another fund at the department, is complicated. But this is not uncommon, meaning that Clean Fuels has its revenue deposited in the Air Quality Fund. So we're using our funds rather than create funds under the purview of the legislature broadly. And that is in accordance with both DFA and legislative finance supporting those changes happening. So I'll stop. I know it's a lot.
Yeah, so I was looking through the enabling statute and it didn't say anything like other enabling statutes, like you have the authority to collect fees and it shall go into this fund. I didn't see that, but it sounds like that is language that is in the other act that you were discussing.
So Chair Ely, I would say that there's both that ride we were on in 2025 during the legislative session where things are changing and packages of bills are moving. And then outside of that, the Department of Environment Act, which creates the department, as well as the Environmental Improvement Act, are also where we derive the ability to implement rules, including those related to fees, and use those fees for the purposes of implementing the mandates that the legislature puts upon us, including the PFAS Protection Act.
Well, and I also see in the Enabling Act, it says the board may adopt rules to carry out the provisions of the PFAS Protection Act. So that may be enabling language too. Anyway, it is confusing to me, but I appreciate your response.
Yeah, and it's confused. Chair Ely, it is confusing. I share this because when I sat down for my first budget hearing in front of the legislature in 2019, 5 days into the job, or not even, the Department of Finance and Administration analyst for the Environment Department sat down right next to me and said, "You have the most complicated budget in state government. Good luck." And I had been on the job days. I feel at this point I could teach budgeting, and it doesn't mean that I'm a good teacher. It doesn't mean that students will understand it. It's complicated, for sure. But even bills that were passed this legislative session, there's an industrial decarbonization bill that is sitting on the governor's desk that creates a rebate program at the Environment Department in which we have to adopt rules, but there's similarly less enabling language in it. And it seems to be the direction the legislature is moving in their modernization, as opposed to where maybe the history of former employees understand the department to have been.
Thank you. I'll be looking forward to your statement of reasons on this. Those are all my questions.
Okay, thank you. On the platform, Member Bitzer, do you have questions of the secretary?
I did, but the chair stole her from me. So I just want to thank him for his service. He's been a rock star, I think. This is important stuff. Everything the department does is important. So just appreciate it in that position. And I get a little PTSD because I was in a similar boat under a previous governor and had to deal with LFC and DFA in a million different ways. And I don't miss it. All right, but thank you.
Thank you. Member Carrasco, do you have questions of the secretary?
I do not.
Thank you. Member Kirby, I see you on the screen.
I do. I have some questions. Good afternoon, Mr. Secretary. It's good to see you. And I want to thank you for your efforts in all this, not only for your testimony today, but the years of work that you and all the parties have put into it. It's a huge effort to take, and I appreciate so much what you said about a complicated budget. It can make your hair hurt sometimes, and so. But I have a question. We've got. I think the state engineer's office says that we have something over 250,000 domestic wells in our state, which practically the Environment Department cannot regulate. And I know that septic tanks are sometimes the vehicle that will take PFAS items into groundwater. And so to me, that is a question that how do you think you will approach private wells and trying to get them into compliance, if that's even an accurate word to use in this case. But it seems like there's a gap here where there could be PFAS that's flowing. You talk about some of the wells that have shut down some of the dairy farmers down there, and I'm sure some of those are private or commercial at least. And so where do we go in that situation?
Yeah, I appreciate the question, Member Curry, and I look forward to one day joining the support group of former environment secretaries. But the question that you're asking again goes back to, and I can't stress this enough, that in every way the elevation, this department has had an ever expanding and elevated mission that has even exponentially increased during my time. And I say that because the legislature's expectation is that even though the Safe Drinking Water Act and the Water Quality Act do not establish a resident as a public water system by any means, the expectation is that the interventions we're taking through law, through rule, through policy, through guidance, through budget are equally distributed between those public water systems and those private residences. It is why today we have people in Curry County, in Santa Fe County, through both staff and contractors, bringing people's private domestic wells up to a standard for the installation of PFAS filtration systems. So we are last year we had $2 million to do this work in a non-regulatory sense because we're providing service to New Mexicans who have challenges with respect to their water, to say the least. And then they're providing, I don't know the exact number that was in the legislature this past session, but it's somewhere probably between $6 and $10 million in more money coming to the Environment Department to address private well water contamination. So that is all happening. And at the same time, consumer products going into septic systems would be continuing that cycle of loading the aquifer in certain cases, and not everybody is, the state doesn't have the funding, as you point out, for domestic wells, drinking water wells, to even address the PFAS at the point of use of those homes. That excludes all the PFAS that may be in agricultural irrigation wells that are used for everything from dairy cows to various alfalfa crops, and everything else that is used through the agricultural sector. So maybe the shortest of short answers would be this rule would educate consumers so that they could make a choice as to what products, when they're on septic, they would not want to bring into their home.
I know that we've talked in the past about the department doing water fairs around the state, and they conduct them. How much capture of PFAS do they have potentially to see in any of these water fairs? I know they can be delineated into specific things, but is there a general approach that the department has as to water fairs and PFAS?
Member Curry, we are not routinely offering PFAS as an analytical test for private well water. Rather, what we're doing is using our sort of sentinel monitoring around the state to establish where PFAS contamination may be. And then in that area, then we begin to reach out to communities. The Curry County area, 26,000 parts per trillion PFAS when the standard is 4, merited a very quick intervention. The same thing in La Cienega, I think those numbers were 200 times the drinking water standard. So again, we're not routinely doing that. Those tests are a little bit more expensive than the bench scale tests that we could do in our field offices today. But when there's a need for us to rally both staff and funding, and as you probably well know, we're restricted in our funding under the Federal Clean Water Act because it's not a public water system. So it really does become a ward of the state to solve that problem.
And do you have a sense, being the ward of the state, from the legislators? I've heard several of them on here today. Is there a role that they could play as far as additional funding in that area without getting into the anti-donation clause area?
Great question. The role that they're playing is there has to, given that PFAS in the state of New Mexico is considered a hazardous substance and a hazardous waste, We are able to rally some additional funding, both through the department's emergency hazardous waste emergency fund, or seek legislative approval to use money in that way. But we don't have and that allows us to both work, I wouldn't say get around by any means, but work with the anti-donation clause to provide that those interventions to people's point of use, like at their house, right? A whole house filter. It's not addressing the underlying condition. It's just merely, as I said before, a Band-Aid in order to give them the water they need to continue to live at their residence.
Thank you.
Is there anything else from the board? Oh, Mr. Ugarte.
Sorry, Secretary. All right, so I'm going to try to cover a couple of areas, different topics that you covered. So earlier, Cross touched on your experience with HB 212 in the legislative session last year. First question: you're squarely in the executive branch.
Correct.
Okay, because there was some reference to you approving amendments or changes or substitute bills, and that you really didn't play that role.
Yes, that is a correct statement, that I cannot approve legislative changes as I'm in the executive branch, and the good sponsors that were largely here today would be the ones who would carry those changes forward.
Right. I mean, clearly you were working hand in hand in informed and part of the process, but no one was looking for your approval in that while it was over at the Roundhouse.
Yes, Board Counsel, I would agree that I was not in the concurrence chain.
All right, great. Now, your rebuttal focused on the written testimony of a particular witness, and while you, in your written rebuttal, there were specific responses to, there was a general response and then specific responses to language that was in Section 3. There's a few statements that I thought I would ask, since you described earlier how you had this front row seat, you were watching what was happening through that process. So a reading from the witness statement, I guess my question would be, is this your understanding of what was happening? Because they're talking about legislative intent, and there's statements to that effect. And while your written rebuttal touches on Section 3, these statements are before that. So I'm just curious to get your answers to if this is what you understood at the time. So one of them is the New Mexico legislature expressed its public policy determination that such products do not pose risks to contamination to warrant regulation under the law. Is that your understanding of what the legislature was trying to do? So I'm sorry, so big picture is here they're saying that the labeling requirement is overreach. And because the statute has exemptions for reporting requirements and other restrictions, there shouldn't be this labeling requirement. And so they're saying that the legislature is apparently spoke clearly about their intent with the exemptions. And so it should be, I guess their point is that the legislative intent that should also not apply to, the exemption should apply to the labeling. Is that your understanding of what was happening at the time?
My understanding of what was happening at the time and why I provided rebuttal testimony was that legislators were actually saying the words out loud. We should have education. We should require labeling. And if you were to exempt a product and not label it, aren't we perpetuating the same problems we have?
And if presumably if the legislature wanted to exempt labeling from if they wanted the exemptions to apply to labeling as well as reporting, they could have done that.
Correct.
Because they were changing the language at the time. This wasn't language that NMED had proposed, as was pointed out earlier.
I agree.
Okay. There's another statement further down, is yet despite legislature's careful and calibrated policy judgment on this score, is that, it's again, it's along the same lines of that the labeling should have been exempt from the items, the products that were exempt from reporting. Is that your takeaway from being there at the time?
Yeah, I don't have I don't have the witness's testimony in front of me. And I can easily go and pull that up. But if you could just restate the question so that I understand that I want to stick with my testimony and not misspeak about these provisions.
Okay, so I'm just wondering if there's a better way to do this. I'll try one more, and my hope was that it was obvious enough with the statement that I'm reading, but if it's not, that's fine. We could move on. The labeling requirements imposes the very regulatory burden that the New Mexico legislature expressly concluded they should not have to face. So again, this notion that this category is exempt from reporting requirements, by extension, that means they should not be subject to the labeling requirements.
Right, and I think those conclusions were inappropriately reached, that the exemption from labeling should be applicable to any exemption in the statute. I think if the legislature wanted to do that, they would have explicitly done that.
Okay. Now, Mr. Lopez, I'm going to try to share something that was on Mr. Olson or Dr. Olson's.
You should be good to do that, Councilor.
So is this? Oh, great. All right, so this slide shows, I guess, the history of PFAS manufacture. And one thing that is seen is that the health concerns, as shown in this chart, are delayed from synthesis development and manufacturing. So I think we were told earlier this week that the gray area, the phase outs, reductions, alternatives, I think that's the transition from what was termed as long chain PFAS to short chain PFAS. And I think today, as I understand it, the industry is using more short chain PFAS than long chain PFAS.
Madam Hearing Officer, I know it's unusual for me to object to board council's questions, but I think this is outside the scope of Secretary Kinney's testimony.
And Mr. Secretary, to the extent anyone, including board counsel, would be drawing you out of your area of expertise or the testimony you gave earlier, please just say so.
Okay. I guess what the point I'm trying to get to is it took, whether it's the United States or the world, a while before it realized the concerns with PFAS from the 1940s, 50s until the 1960s, 70s. So to the extent, and we heard earlier testimony that we have a lot of research on PFAS and not so much on other types of PFAS. So while we've seen blood serum levels going down in humans, we don't have tests available, either environmental tests or blood serum tests for other types of PFAS. So the fact that we, for example, in the US have phased out long-term PFAS and now are maybe using more short chain PFAS, is it possible that the health concerns it can be time before we identify those health concerns in the same way that what happened earlier with the original PFAS.
I think that's an accurate, I understand your question, and I think that could be accurate. There's one sort of component to your statement that I would just respectfully challenge in terms of the phase out of long chain compounds. You know, New Mexico has we don't have any PFAS manufacturing in the state of New Mexico. So when we see some of the longer chain compounds here, we can ask ourselves, where do they arise from? And it's been very clear military bases is the federal government is a significant polluter in New Mexico. And those military bases have released significant amounts of PFAS. It does not track that a number of the rural drinking water sources in New Mexico that are not around military bases would still be seeing higher levels of those longer chains, but for consumer products. And when I gave my personal story and I said that fabric protector was 50 times the safe drinking water standard, what I did not say is that those chemicals, based on my research, were last manufactured domestically in 1999. So long-term PFAS being phased out of U.S. production, I know there's been testimony, whether it's voluntarily or aspirationally or regulatorily, I'm not debating any of that they are still imported, compounded, and distributed all throughout the states. The one compound that I'm talking about is manufactured in Denver, Colorado, or is blended in Denver, Colorado, and shipped to New Mexico. It says it right on the bottle. So I agree with you that the health impacts from long-term, long-chain PFAS, maybe as reflected in this graph, were delayed, but it does not indicate that it should not indicate to any of us that long-chain compounds or short-chain compounds have that they have a lower. I want to be careful about how I say it. Long chain compounds may not be as phased out as you think and still in commerce, and short chain compounds, whether we understand the science completely or not, as we've heard a lot of debate about in this, or a lot of testimony about, we may not see the impacts for years in a similar way as you're pointing out with this chart.
Okay. And I was really more focused on thank you for the answer. And I was more focused on there's what we don't know. And there seems to be a delay in the process of identifying health concerns and making the connections. And I think I remembered this graph during some of the conversation yesterday, and I thought it would be helpful. The last area I wanted to touch on is from what I could remember seeing in your CV, I think you spent about 9 years with the EPA.
I was 22 years with EPA,
Oh, I'm sorry.
20 plus years. I had 2 stints, so maybe you're just looking at the second.
Okay,
tour
so a
of
long
duty.
time. So and then you've been here obviously for quite some time at the state level.
Today, or, but yes, I agree.
In New Mexico.
Yes.
And so you're very familiar with the differences in the regulatory schemes at the federal level versus the state level, having worked in both.
I would agree.
And I understand you're not trying to step on your counsel here. You're not an expert on preemption, but you described the process. So you also described earlier that I think it came out in the cross that a significant part of NMED's budget comes from federal funding. So as an agency, including your council and the different departments doing their different responsibilities, they're very familiar with this notion of these are my boundaries as a state regulator, and these are the federal boundaries. And then whether it's interacting with them or knowing that that's their side of the fence, we're going to stay on our side of the fence. That's not a foreign concept either to you as an individual regulator or to the agency.
No, it's a day-to-day practice.
Okay. And so under this rule, there's all those exemptions that are, if there's some federal rule that covers it, it's exempt. Whether it's OSI or Dr. Stack's group of Skaggs group, somebody within that organization will be looking at that, presumably with counsel, to make an assessment of, well, is this covered under an exemption? And that's just part of the process, whether it's documented today, but eventually that'll be part of the scope of work, that if this is promulgated, then that's incorporated into what the process would be within the agency.
Correct. And we have a number of what I'll just generally refer to as standard operating procedures, including a delegation order, where that delegation order establishes what the legislature has and the governor have given to the cabinet secretary. And then there are certain checks and balances in executing various duties that the legislature and again the governor has given to the cabinet secretary. So those include a whole host of things, and then they also derive to some degree from our federal programs as well, so that we have the right, again, operational checks and balances. And it's formulaic to some degree about who can do certain things in the department, and not everybody is able to execute decision-making without a process followed.
Okay. And I would presume that your office has contacts in the federal government for these different areas, air, water, whatever the different regulatory fields are that they may have to interact with on a regular basis. And that's just, again, part of the normal operating procedure within the agency.
Correct. Under federal delegation primacy agreements, and then under federal grants that implement those delegations and primacies, we have our various, whether it's grants office or whether it's the Office of Water or whether it's the regional office, those are all very mapped relationships and processes.
Thank you very much. Appreciate it.
All right, Vice Chair Smina.
Thank you, Madam Hearing Officer, and good afternoon, Secretary. I just have a few more follow-up questions. In our, as we've heard, some of our military, and you just shared, some of our military bases have released significant amounts of PFAS. Given that the way the rebuttal version of the rules, my understanding is, as we had talked about earlier, is this applies on the consumer side, right? As currently drafted, would these rules address any future issues associated, releases at, say, a military base?
The Vice Chair, the PFAS Protection Act does address firefighting foams in terms of their phase out. The rule acknowledges that. The House Bill 140 and its rulemaking will come before you soon. Our counsel on that is sitting right there. But this act and this rule would not have any bearing on that. Just generally speaking, in New Mexico, firefighting foams under now state law, meaning House Bill 140, are no longer allowed to be released without cleanup, and they're not allowed to be used without, they're only allowed to be used in emergency purposes, not for training. And there's a inventory requirement for all the remaining PFAS or aqueous film forming foams, I should say, that are in New Mexico. And again, all of that is outside of the rebuttal rule and the PFAS Protection Act.
Thank you for that clarity, Secretary. So with that, I guess a follow-up question, and this goes back to labeling and some of the comments we've heard, and also some of the written comments submitted regarding some concern about where the act recognizes issues of confidential information, stating that, NMED, this rule should not require the disclosure of information. Can you share with the board and I guess I'm interested as how do you see the rebuttal version of the rule navigating what the act said in terms of confidential information and the labeling aspects?
So to the Vice Chair, to the extent that a manufacturer made assertions of trade secret or confidentiality under state IPRA Inspection of Public Records Act, we would be able to withhold that from need to be careful that there would be methods in which we would maintain that information as trade secret.
Thank you for that response. And so as it's written, you feel comfortable where we sit in this latest version, that the department could address that concern in the implementation of the rule?
And Vice Chair, the concern, again, if this is the
I'm sorry, Secretary. So the concern about protecting confidential information, as you said, as trade secret, under a trade secret consideration, or where how do I say this? Where for the protection of confidential business information.
So let me clarify then a little bit my answer. I have the rule now and the rebuttal rule in front of me, and I'm on in the reporting requirements section, and I'm not sure if this is the same, everybody has the same version, but it's Exhibit 69. In the reporting requirement, I think what we have listed here is that to the extent the department is requesting information, I'm in section or number 5, any additional information requested by the department is necessary, provided the department shall not require disclosure of records, reports, and information. And then it goes on to say that would divulge confidential business records. I think that there's a limitation placed on us, if I'm not mistaken, by the way the rule is drafted for the information we can request or obtain. And I'm not sure that I'm necessarily, addressing your exact question, but I think there's between the statute and the rule, or between the law and the rule, there is restrictions both placed in the department, and then outside of the department, there are means by which other laws address public records.
Thank you, Secretary.
Vice Chair Sweeney, I want you to ask all the questions you have, but we do need to take our first afternoon break, and we also should honor our commitment to Dr. Basu. Mr. Secretary, do I understand you're here for the duration?
Yes, I can be here for a little bit longer for sure.
And Madam Hearing Officer, I'm done with my questions.
Oh, you are? Okay. If there's nothing else from the board, any reason not to excuse the secretary? Thank you very much, Mr. Secretary. Let's take 10 minutes, and when we come back, we'll go to Dr. Basu.
Thank you, Madam Hearing Officer.
Madam Hearing Officer. I'm sorry.
Oh, any objections?
Subject to the continuing objections that we've had.
All right, your objection is noted and the exhibits are admitted. Thank you, Pam. We are back after a short break. Mr. Trujillo?
Thank you, Madam Hearing Officer. I guess my opening statement will take just a second, and then I'll have Dr. Basu, are you on?
Yes, I am.
Dr. Basu, I'm going to give a quick opening statement, and then we're going to turn to your questioning here in a second. Good afternoon, Madam Hearing Officer and members of the board. Again, my name is TJ Trujillo, and I am here on this time switching hats. I'm here on behalf of CropLife America. CropLife America represents developers, manufacturers, formulators, and distributors of pesticides for agricultural and pest management solutions. CropLife's members, ranging from small companies to large corporations, produce, sell, and distribute virtually all pesticide products used by New Mexico farmers, and helps ensure that American farmers have access to technologies they need to protect their crops, preserve their livelihoods, and produce safe, affordable, and abundant food. In this case, CropLife America supports the changes reflected in the department's revised proposed rule, clarifying that pesticides regulated under the Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA, are exempt from labeling and reporting requirements. The changes appropriately recognize that pesticides are thoroughly vetted by the federal government and federal government scientists to ensure that they do not pose an unreasonable risk to human health of the environment when used as directed. We will present one witness, Dr. Basu, who will provide information about the federal requirements that must be satisfied before the United States Environmental Protection Agency registers a pesticide for use in the United States. Dr. Basu's testimony will also address EPA's ongoing oversight of pesticides once approved, as well as the detailed review and approval process for pesticide product labels by the EPA. In summary, the changes to the proposed rule reflect that pesticides are among the most extensively reviewed and continuously regulated products in commerce, and that EPA-approved labeling is mandatory and legally enforceable. For these reasons, the board should adopt the rebuttal rule as proposed with respect to these changes and affirm the department's position on the pesticide exemption. Thank you.
Thank you, Mr. Trujillo. Dr. Basu, would you please spell your first and last name?
Yes, my first name is Manojit, Manojit. Last name Basu, Basu.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Trujillo.
Thank you, Madam Hearing Officer. Good afternoon, Dr. Basu. Thank you for accommodating the secretary. We appreciate you giving us that latitude. Dr. Basu, who is your current employer?
CropLife America.
And on whose behalf are you testifying today?
CropLife America.
Did you provide a resume filed as CropLife Exhibit 1, which states your employment history, qualifications, and experience?
Yes, I did.
Can you briefly summarize your relevant experience for the board?
I have a PhD in molecular biology, followed by a postdoc on hormone physiology at Oak Ridge National Lab. Then I went at Monsanto to do toxicology work on biotechnology-derived plants, moving on to Grocery Manufacturers Association, working on ingredient safety and product safety. And finally, at CropLife America, I'm the Vice President, Science Policy and Regulatory Affairs, looking into the pesticide portfolio for our member companies.
Dr. Basu, I have to ask you to slow down. We have both a court reporter and an interpreter trying to catch every word.
Thank you. Sorry about that.
Dr. Basu, did you provide written direct testimony that was filed in this matter as CropLife Exhibit 2?
Yes, I did.
Do you have any corrections or to your written direct testimony?
No, I don't.
Do you adopt your written direct testimony as your own testimony for this matter?
Yes, I do.
Dr. Basu, do you have a summary of your direct testimony to present to the board today?
Yes.
Please proceed with giving that summary.
Thank you. Pesticides are regulated by U.S. Environmental Protection Agency, and for any industry company to bring a new pesticide product into the U.S., the registrant or the applicant need to conduct several studies. Sometimes it could be up to 150 studies. These are studies agreed upon by US EPA along with the Organization of Economically Developed Countries, OECD, who then the agency reviews the study conducted by the applicant, and after a thorough review process on any human health effect and as well as environmental effect, the agency makes a decision of registration for the pesticide to be sold and available in the United States. The pesticide review process and registration process needs to meet requirements of Federal Insecticide, Fungicide, Rodenticide Act, as well as for residues, it needs to meet all the requirements under Federal Food, Drug, and Cosmetic Act. Pesticides are also regulated under the Endangered Species Act. It is a several year process, and in my experience within the member companies, from discovery of a molecule to registration, it is usually an 11 to 12 year process. Accumulation and all those studies are required for EPA to review and make a decision.
Thank you, Dr. Basu. Do you have anything else to add before we conclude with your direct testimony?
That will be all. Thank you.
Thank you, Madam Hearing Officer. We are done with this direct and we'll turn them over for questioning.
Oh my, thank you so much, Dr. Basu. Ms. Fiebig, do you have questions of Dr. Basu?
No questions, thank you.
All right. Mr. Smith-Cure or Mr. Roseborough? There you are.
Just a few brief questions, Madam Hearing Officer. Dr. Basu, thank you for your detailed written testimony and your oral testimony here today. Have you read the language of the department's most recent rebuttal rule as it relates to labeling?
Sorry, can you come back again?
Have you read the department's proposed rule related to labeling?
Yes, I have.
Sorry, there is nothing to repeat.
Okay,
Yes.
I'm going to read just two provisions from the proposed rule quickly, and then I'll have 2 or 3 questions about it.
Sure.
So 20.13.2.13b2 states, quote, "The labeling requirements of this rule do not apply to products for which labeling requirements are preempted pursuant to the Federal Insecticide, Fungicide, and Rodenticide Act, 7 U.S.C. Section 136V, or for which labeling requirements currently exist at 40 CFR 156.10. So my first question is, are all pesticides regulated by the Federal Insecticide, Fungicide, and Rodenticide Act?
Yes, they are.
Thank you. And are all pesticides subject to the labeling requirements at 40 CFR 156.10?
Yes.
Wonderful. In that case, are you supportive of the labeling exemptions for pesticides proposed by NMED?
Yes.
No further questions. Thank you.
Thank you. Mr. Harris, do you have questions of Dr. Basu?
No questions.
Mr. Harris said no. Mr. Weatherby, do you have questions of Dr. Basu?
No questions, Madam Hearing Officer.
All right, thank you. Any redirect, Mr. Trujillo?
Madam Hearing Officer, I have no redirect. However, I hope to win the prize for the shortest presentation.
Yes, so far you are winning. Let me turn to the board then. Vice Chair Sweeney, any questions?
No questions, thank you.
Chair Ely?
No questions.
Thank you. On the platform, Member Bitzer.
I have no questions.
All right, Member Carrasco?
I have no questions.
Thank you. And Member Curry?
No questions.
Thank you. Council, anything? No. All right. Do you have exhibits to offer?
Oh, yes. Thank you very much, Madam Hearing Officer. Yes, I'd like to move to admit the exhibits presented on behalf of Dr. Basu. Or I'm sorry, presented on behalf of Crop Life.
I'll pause in the event there are objections.
No objections.
All right. Thank you very much. They're admitted.
Madam Hearing Officer, before we proceed, I believe, Counselor, we were going to switch spots, so if we could have like a quick break, so they wanted to move up to the front, and we're going to move to the back.
Certainly. Let's take about 2 minutes.
Thank you.
Go ahead, Ms. Feebig.
Good afternoon. On behalf of the Complex Products Manufacturers Coalition, we'd like to present the testimony of Dr. Alex Stanton, Martha Marapese, and Kemba Solomon.
Thank you. I'm going to ask you to spell your first and last name in order, if you would, please.
Hi, I'm Dr. Alex Stanton, ALEXSTANTON.
And do you swear or affirm to tell the truth?
I do.
Ms. Marapese.
My name is Martha Marapese, and that's MARTHA
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you, ma'am.
Good afternoon. My name is Kemba Solomon, KEMBA Solomon, SOLOMON.
Do you swear or affirm to tell the truth?
Yes.
Thank you very much. Go ahead, Ms. Feebig.
Good morning, or good afternoon. I'm trying to get my slide to advance here. There we go. Ms. Marapese, can you please introduce yourself and provide an overview of your educational background and experience?
Yes, good afternoon, Madam Hearing Officer and the board. Thank you for the opportunity to speak to you today. My name is Martha Marapese, and I am a partner with the Environmental Practice Group at Wiley-Rein. I have held that position since 2017, and my particular area of expertise is chemical control law at the state and federal level, but I'm noted as an expert in the Toxic Substances Control Act specifically. In my role, I serve as outside counsel to companies seeking to use new and existing chemicals with product life cycles that are subject to regulation. And also part of my work involves reviewing and approving product labels for consumer products. Now, prior to 2017, I practiced chemical control law for 25 years at a different firm, Keller and Heckman, also in Washington, D.C. Environmental law is a science-heavy practice, and chemical regulation in particular requires an understanding of chemistry and toxicology. And at my prior firm, I worked hand in hand with PhD chemists, toxicologists, and certified industrial hygienists on a daily basis that were employed by the firm to solve client issues and questions. At Wiley, I still work with a PhD chemist, Dr. Stanton. Also, a PhD molecular biologist is on staff with Wiley, in addition to working with many independent consultants. So my law degree is from Catholic University in Washington, D.C. My undergrad degree is from the University of Vermont. I started out as a wildlife biology major, but I became very interested in where law and public policy and environmental protection intersect And so I found a really cool major called resource economics, which evaluates the intersection between market forces, public policy, and environmental protection. So that major teaches students how to look at regulatory and market-based solutions, quantify costs and benefits, things like that. And it prepares students, and it did me, for environmental careers in positions in government, in consulting, and in the law. So with respect to PFAS specifically, I've been familiar with these chemistries since the time I started practicing. My first firm represented the plastics industry, probably still does. That, of course, includes the fluoropolymer industry. And currently, I counsel clients on particularly TSCA regulation, but also state regulations associated with PFAS in many types of products. And I'm here today because I'm serving as outside general counsel to the CPMC. This is a group of companies and associations that assemble finished goods and complex durable goods. We're grateful to the department for including a definition of complex durable goods in the proposed revision rule. These products, just to give you a quick flavor, and I'll move on, include both consumer products, electronics, for example, personal computers and phones, but also business-to-business products, refrigeration systems that are used in hospitals and grocery stores, for example. So it's a wide range of complex durable goods that are represented in our group. Thank you.
Ms. Maripes, did you submit written testimony for the board in this proceedings?
Yes, I did.
And do you have any corrections that you'd like to make to that written testimony?
No, I do not.
Do you adopt that written testimony as your testimony today?
I do.
Ms. Solomon, can you please introduce yourself and give us a little background on your education and experience?
Good afternoon. Thank you, Madam Hearing Officer and Board, for your time today. My name is Kimba Solomon, and I am the Regulatory Affairs Manager with Yamaha United States Marine Business Unit. My primary focus involves engaging with federal, state, and global agencies on the evolution of future regulations. I also work with marine industry trade organizations to encourage the development of standards for new and emerging technologies. My goal is to encourage a regulatory environment that aligns with business and technical realities. I have a Bachelor's of Science degree from Tennessee State University and a Master of Science degree from Pennsylvania State University. I am a member of the Complex Products Manufacturers Coalition, the National Marine Manufacturers Coalition, and the Society of Automotive Engineers.
Ms. Solomon, what was the focus of your undergraduate and graduate degrees?
In undergraduate, I focused on actually my senior project was on airfoil icing on wind turbines. In graduate school, I actually worked with the Navy. There was a naval school on the campus, and I worked with helicopter gearboxes to determine condition-based maintenance on the systems versus looking at the systems to see, predictive-based maintenance. So the predictive-based maintenance is when you take your car in at 8,000 miles or whatever. So we were looking at the condition, monitoring the system consistently.
And were both of those within the broader umbrella of mechanical engineering?
Yes.
Okay. And did you submit a written testimony in these proceedings?
Yes, I did.
And do you have any corrections that you'd like to make to your written testimony?
I have a minor correction to the table that was submitted just to include the personal flotation devices.
I think we have that table on one of our slides today. Do you want to specify what the correction will be when we get to that slide?
Yes.
Okay. Subject to that correction, do you adopt your written testimony as your testimony today?
Yes.
Dr. Stanton, would you please introduce yourself and give a little background about your education and experience?
Yes, I am Alex Stanton. Thank you for having me. I have a bachelor's in chemistry from the University of Arizona, so nearby desert, not the same desert, and a PhD in chemistry from the University of Illinois at Urbana-Champaign, where I worked on nanomaterial and bulk property sensors. So trying to detect things that had very low natural signatures. This is important for chemical weapons defense work. Right out of grad school, I joined the EPA in Washington, DC, and I worked on new chemicals for 8 years. I had various jobs in the new chemicals division. I worked as a risk manager and also a risk assessor and a team leader as well in our chemistry branch. So in that context, I had lots of PFAS experience, both as a risk manager reviewing PFAS submissions for new chemicals entering commerce, and also as an assessor receiving those. And I was part of the EPA low volume exemption PFAS stewardship program, where we encouraged companies to voluntarily withdraw their low volume exemptions for PFAS products. I was also a team leader of the chemistry branch while the chemists were designing the PFAS definition for the 8A7 PFAS reporting rule, which came out recently. Now I'm currently at Wiley Ryan, where I work as a chemical analyst with Martha Marapice and support clients that are navigating the regulatory landscapes and helping them with the science aspects of their cases, as I am not an attorney.
Helping me too.
Dr. Stanton, did you submit written testimony in these proceedings?
I did.
Do you have any corrections that you'd like to make to your testimony?
I do not.
Do you adopt your written testimony as your testimony today?
I do.
Thank you. Ms. Marapice, in your written testimony, you gave a little information about the CPMC. Could you please summarize your testimony on that issue?
Yes, I'd like to emphasize that CPMC it was formed to promote the risk-based regulation of PFAS, and particularly to educate regulators about the unique challenges of companies that have complex international supply chains with thousands of SKUs, products, that is, and each of those products have potentially hundreds of components. That makes these companies unique in the supply chain for the reason that a lot of the information on the chemical composition of the components that they assemble is not within their control. And so there are several sectors in our group that lack chemical composition data for components that are internal. For parts that are internal to these components. And historically, they have not been required to collect information on these chemicals. So we want to make sure that state regulators understand the unique challenges associated with these products when they are implementing rules like the one that New Mexico has proposed.
Ms. Marapice, could you very briefly describe CPMC's recommendations?
Yes, CPMC thinks right now that this proposed revision rule is not balanced or as simple as NMED represents for some of the reasons I've just mentioned. The burdens on complex durable goods to label specifically outweigh the benefits of this rule, we believe. The proposed rule's benefits are indirect, long-term, informational, therefore not amenable to traditional quantification methods like number of individual time hours or wage that we can quantify on the cost side. So to bring the proposal in balance, CPMC is here to advocate for the same 16 exemptions for labeling that apply to the ban and reporting requirements in the statute. The other state labeling laws that have come up in discussions this week are much more narrow. Connecticut has labeling for 7 consumer-facing products. Colorado labeling for precisely 2 products containing PFAS. As we're going to speak to you today about the proposed labeling in the rebuttal rule, applies to thousands of products. And so it is unprecedented. And I want to make sure that's on the record. So if labeling does go forward, CPMC thinks that the labeling requirements for complex goods should be no more onerous than for the consumer goods that are also subject to labeling right now. And also, with regard to preemption, while we do appreciate the general preemption provisions in both the labeling and the other aspects of the rule, we do think that this rule would benefit from being more transparent in specifying preemptions for automotive and marine vessels, that there are federal laws similar to the pesticide law that govern the safety of those products. And we'd like to see those specifically carved out so that companies don't have to hire lawyers to figure out if they have to label or not. We also would like to advocate for certain other exemptions for internal components and for refrigerants, also in any labeling that would go forward. Finally, we would like to advocate here today for more time. The time frame are 6 months of less that we're looking at today is simply too short a time for the products that our members have to update labels and other materials for hundreds of components, products that have many components. So those 3 things. Thank you.
Ms. Marapese, in your written testimony, you described some of the costs that product manufacturers might face having to relabel their products. Could you please summarize your testimony on that point?
Yes. Under the Environmental Improvement Act of New Mexico, this board is charged with considering the necessity for an economic reasonableness of this proposed rule. It's asserted by the state that this proposed rule is economically reasonable, but we don't think that the state has provided enough information on the cost of labeling to industry to permit the board to make a reasoned evaluation. So we hope to do that with my testimony today. Now, the true cost of just changing the labels is significant. And in my testimony, written testimony, I illustrated what the extent of the potential cost could be using a study that was done recently, within the past 10 years on Proposition 65, 2015, because that's when the rule change went into effect. And that rule change under Prop 65 required companies to specify a chemical that had been found by the state of California to cause cancer or reproductive harm, to use put the chemical identity of that chemical in the warning statement on the label. So the study evaluated the cost of changing the labels. And that study estimated that the cost of just changing the labels would be between $15 and $30 million of economic impact to industry. The study had a high and low end estimate of affected products, from 16,000 products to 8,000 products at the low end. The study attributed $1,000 per product cost for changing the label, and also attributed another $150 cost to changes that would be required on the internet. And just the internet changes alone added $1.8 million to the cost of just changing the labels. The reason why I think that this study is instructive for New Mexico is that there are similarities. The Proposition 65 label includes a symbol. The warning has to be provided in more than one language. It applies to all businesses with 10 or more employees that sell products into California. And in the study, it found that the majority of the burden fell on the manufacturing sector, which is similar again to this reporting rule proposal that is puts the burden of the labeling, of course, on manufacturers. So there are some similarities. It's comparable. It's not precisely the same thing. For one thing, the Proposition 65 label includes an exposure element so that if a company determines there is no exposure to the chemical, it does not have to provide the warning.
Ms. Solomon, you discussed the labeling and compliance issues facing the marine sector in your written testimony. Can you please explain the demonstratives that you've prepared and explain how they elucidate those issues for the board? Let's start with the labels.
Okay, so this, what you see on the screen are some labels that are on the boat. The second slide will also show where we have labels, not just on the boat, but we are an outboard manufacturer, so we have to include labels on those as well. We could have up to 30 labels from our standards organization, just to kind of give you the gist of how many are there. These labels are located inside the boat, inside compartments on the boat, and outside of the boat as well. On our outboards, we have labels on the outside as well as the inside. If you can go to the next slide, just so you can get a feel. So the top left is the inside of the outboard. The far right is the outside. So these labels are placed on here due to federal and state requirements. We also have safety labels from ABYC and the U.S. Coast Guard. And we also have required emissions labels. Most of these labels are only in English. We do have some, if you look in that left corner, that is an example under on our outboards where you have English and Spanish. The House Bill 212 now proposes us to alter the current label by adding the Erlenmeyer flask and include the following statement. This product is made with PFAS or contains component parts made with PFAS. This proposal will increase the size of our current labels, and we may not have space depending on its location, as you could see underneath the outboard. Adding additional labels in Spanish would also create a challenge. The U.S. Coast Guard labels, no federal labels can be changed, and Secretary Kenny clarified that federal labels will not need to change, so thank you for clarifying. But for the American Boat and Yacht Council, our main standards organization, it would take approximately 3 years through their process to make a change to a label. Okay, and what you see,
No, please go ahead. I was just going to ask you to describe what you've placed on this slide and explain its relevance to the board.
Okay, so this slide shows in the left corner the safety data sheet, and on the right, you will see a technical specifications sheet. The purpose of these documents on the SDS sheet is for chemical information, and it is traditionally shown on the SDS, which are not provided to consumers. The owner-operator manuals and technical specification sheets are not hazardous communication documents. They are used by technicians and consumers, not by individuals looking for detailed chemical information. Our owner manuals are electronic in the United States. The new rule proposes listing all PFAS in the technical specification document shown here on the right. And it asks that we list technical and chemical data in this document. Listing technical and chemical data in this document could potentially confuse the consumer. Manufacturers would have to redesign the website, which would require multiple teams' involvement. Teams will have to be created to not only manage this information, they would also have to include training, standard operating procedure changes, and potentially software. Changes to the physical owner's manual can be made. However, in Yamaha's case, we would need to notify our headquarters in Japan that changes will be made. These changes can take effect quite quickly in the electronic and print on-demand versions. However, hard copies supplied with units take a little more time and effort. Our outboards are printed and installed with product in Japan. Personal watercrafts and sport boats are locally sourced, but still may take time to get into production units. As noted previously, labels are considered a component part. Many manufacturers are already in the process of procuring or have fully procured all parts for the 2027 model year. Requiring changes at this stage would create a significant burden, as it would necessitate revisiting completed procurement activities to incorporate these updates.
Ms. Solomon, what is this next figure and how does it relate to your testimony regarding burden?
For our industry, I just want to highlight the recreational boating impact in New Mexico. This shows that there's a $335.2 million annual economic impact. This industry supports 1,244 jobs and 43 businesses within the state. Current data shows that New Mexico has 27,956 registered boats in the state.
I'm going to turn back to Ms. Marapes, and Ms. Solomon, please, you can jump into if you feel it warranted. You both discussed the burdens associated with data collection in your written testimony. Can you please summarize your testimony on this issue?
Yeah, I'll go first on that. Kemba emphasized the placement and the process and the time. I'd like to supplement that with my remarks. Right now, companies are not required to test for PFAS, and the presence of PFAS is typically not disclosed on the labels or safety data sheets if they're in small quantities to when Yamaha or other members of our association import finished components. And also in instances where members have had to do supplier surveys to try to obtain information on PFAS. First, with regard to a flame retardant a couple of years ago in relation to an EPA rule, but more recently, this is happening with respect to Minnesota. The response rate is low. Many of these components are imported, as I mentioned, and so the information, again, is not in the control of the companies who are importing these products. They have to be, the information has to come from foreign suppliers. And in addition to just low response rates, the reasons for that could be proprietary. The foreign suppliers may not be able to or want to disclose the information to their downstream customers for proprietary trade secret reasons. These foreign suppliers may not have the information themselves. And Kemba, you mentioned that your company is being charged by a supplier, I think, to get that information. Is that right?
That is correct.
So the other cost that I want to point out here is to apply for a waiver, as the rebuttal rule proposes, would require a detailed investigation, even more detailed than what reporting under the rule requires. And that's because to apply for an exemption for labeling for a PFAS that never comes into direct contact with a consumer during the useful life of the product, the rebuttal rule requires a company to specifically identify the chemical identity of the PFAS, which reporters do not have to do. And also, these exemption requests have to provide presumably detailed information on the functionality of the PFAS in the product. In addition to the other requirements.
They can't keep PFAS.
And I'd already.
Pam? All right.
Thank you.
Very sorry.
So my point was, in addition to the other elements of the reporting rule, which also these companies would have to essentially investigate, and the cost of doing that, the name of the product and the functionality also has to be provided. And, I noted that the CUU exemption requests are going to be, made on the same platform as the reporting tool that NMED is currently developing. And I think NMED will find, as they develop that tool, that the information requirements are going to be largely the same. Even though these products are exempt from reporting, the task associated with asking for an exemption is essentially the same tasks. So I provided in my written testimony a reference to a 2023 economic impact analysis by the Environmental Protection Agency on their Section 8, TSCA Section 8A7 reporting rule for PFAS. And this was before any of the exemptions that Secretary Kenny mentioned were proposed. There are no exemptions at the time that this economic impact assessment was done. And EPA estimated the cost of reporting at that time to be $786 to $843 million. And I will stand by my written testimony that that's for labeling by any measure. I mean, for a reporting rule, that is an astronomical figure, unprecedented, frankly. The economic impact assessment evaluated that there would be 13,000 or over 13,000 importers of PFAS containing articles. So the components that we're talking about today that complex products manufacturers import affected by this rule. The most recent revision would exempt article importers, and EPA found in the more recent economic impact assessment that would reduce the cost of this reporting rule to $11 million. So just by exempting importers of components like the ones that Kemba and our members import, it would reduce the cost of the rule from $786 to $843 million down to $11 million. So that's a real impact. The majority of the burden in that economic impact analysis in 2023 was found to fall on small businesses. The largest component of that cost was the professional labor time associated with familiarization of the rule, a compliance determination. Even if a company at the end of the day didn't need to report or didn't need to label, a company has to spend the time figuring that out. And then, completing forms and the like. So that rule is a 10-year look-back rule. Again, it's not a one-to-one comparison. It does apply to manufacturers, does apply to a broad range of products. And I think that's another thing I'd like to point out about this proposed labeling rule. It's not just for new products. It's for products that have been in commerce for 10 years or more, as long as they're coming into New Mexico. So again, the impact of this proposed labeling on complex durable goods is very significant.
Ms. Solomon, did you have anything you wanted to add before we move to your demonstrative, or should we go to the next slide? Could you please explain what this is and how it relates to your written testimony about the burdens of data collection?
Yes, so I first want to show you this slide to show locations where PFAS could potentially be found. as you see, we have wiring that may be resistant to corrosion, abrasion, and water intrusion. It does not come in contact to the consumer. We use flotation foam required for buoyancy. It also does not come in contact with the consumer. We do have coatings on exterior parts to resist corrosion. And we also have internally engine and cooling systems that must be waterproof and resistant to seawater, heat, and UV exposure. Can you go to the next slide, please? Okay, so what you see here is an example of our service manual that goes to our technicians. This does not go to consumers, but the proposed rule is asking us not only to list the individual parts as you see here, and as an example, in the top left where it's the boat, you see the wires that are external from it. They're just not asking us to say what if the wire contains PFAS, but they're also asking, if you look where the red arrow is, it's pointing to an assembly. And within that assembly, it has internal components. So what the proposed rule is asking us to do is to not only say this assembly may have a PFAS, but go inside of it and tell us what has PFAS and list that as well. So boat builders and component manufacturers, we purchase subcomponents from numerous suppliers. These suppliers, especially those manufacturing subcomponents or providing raw materials from foreign mills, often do not disclose the chemical composition specifically regarding PFAS. Supplier response rates for many companies, despite significant efforts, they typically experience very low response rates from suppliers regarding chemical information. On average, we have about a 30% response rate, and in some cases, some people in our industry consider 15% really good, and even hiring outside firms, less than 50% the outside firms are only able to gather information from about less than 50% of the suppliers. This low confidence makes it legally difficult to tie labeling responsibilities back to manufacturers. We also have many small businesses, boat builders that build less than 5 boats per year, and they are often custom builds. They lack the manpower, resources, or teams of people to track the intricate level of detail required for the proposed PFAS reporting and labeling across thousands of subcomponents. This becomes a regulatory burden, and the expectation to label every component is somewhat seen as impractical. Cost implications come from testing, the high cost and time associated with testing each and every PFAS component can affect our lead times when we need to put boats into production. Increased part cost. If suppliers are mandated to provide PFAS data into databases, the cost of parts back to the manufacturer will increase. We are also concerned about trade secrets. Concerns about outlining every part potentially will expose some trade secrets.
I think you've already touched on a few of these other issues, but I wanted to give both Ms. Marapes and Ms. Solomon an opportunity to summarize your testimony regarding other economic impacts of the proposed labeling requirement.
Thank you. First, I want to emphasize that most of the components that we're talking about here today are, again, internal to these complex durable goods. They're often there for safety or performance requirements, being the operative word, either to meet federal requirements or industry standards. for these products. And there are additional costs associated with potentially requiring labeling for all of these products. There's a cost to consumers in New Mexico if manufacturers just decide to abandon this market, or if more time is needed than provided by the rule to label them, products could become at least temporarily unavailable. The proposed penalties in the rebuttal rule are significant, and companies will take that seriously. Testing costs, which Kemba mentioned, there's no requirement to test, but companies may feel compelled to test in order to determine if they need to comply. Those tests for complex durable goods, essentially, as we've heard the testimony, there aren't test methods to test for every kind of PFAS. If you test for total fluorine, the testing involves combusting, essentially taking these parts, a perfectly good part, and burning it, and then testing it for total fluorine, which could overestimate the amount of PFAS, if any, in there. So there's uncertainties associated with that, but the additional testing costs could be incurred by some companies. Consumers could have fewer choices. We want to emphasize here today that for some of these products, there may be no choice for consumers to make. And so that's important to keep in mind. And again, overall, this labeling would have a disproportionate impact on small businesses.
Solomon, anything to add?
Yes. I would also like to say, I just want you all to think about, from a manufacturer perspective, it is very difficult to make a state-only label. When we look at these new requirements, we have to look at it across the board. It's not just, New Mexico, Connecticut, Minnesota. We have to look at it across the board, and it's very difficult to meet these regulations on a case-by-case basis. We just don't have the resources to, only create this for New Mexico. So I would like for you to take that into consideration as well.
Dr. Stanton, we haven't forgotten about you. In your written testimony, you raised some concerns regarding the treatment of PFAS as a class. Could you please summarize your testimony on that issue?
Sure. So however you count it, PFAS as a term can encompass several thousands of chemicals. These would all be unique. They are all man-made. There's no naturally occurring PFAS. We do have quite a bit of evidence that certain PFAS are quite harmful to human health and the environment, and that's not good. And so we've taken action in phasing out or reducing the use of certain PFAS chemicals that we know are harmful. We don't want to harm anyone. But just because we know that those handful of chemicals are quite harmful, that does not follow then that all several thousand of PFAS would have the same risk profile to human health or the environment. We've talked a lot about fluoropolymers over the last few days. This is a subclass of some of the most widely used PFAS chemicals. They are, for example, not soluble in water. They're very chemically inert. They're not bioaccumulative due to their incredibly large size. They also don't degrade under natural conditions. The OECD report on the life cycle of fluoropolymers was very clear about this. They are used because they're extremely chemically and thermally resistant. So for them to break down is not something that normally occurs under their conditions of use. It's not that it's impossible. Of course it's possible. It's just that that's not quite usual for them. So because of all of this, they possess really low or in some cases no risk of contamination to the environment. They're used in medical devices. You put them in your body, in implants and medical devices because they're so biologically inert, which is what you want. You want your body to not do chemistry to something that you implant into it. And so that's just one subclass. There's a vast range of physicochemical characteristics between individual PFAS, depending on what they are being manufactured and used for. And because there's so many thousands of them, we just have very limited data on the toxicity, the bioaccumulation, and the persistence of all of those chemicals. So to me, I feel like the overgeneralization of, all PFAS are the same is a little bit misleading and, should be avoided if at all possible.
Before we move on, I think I promised everyone in the room yesterday that we would clarify your position on whether or not fluoropolymers are PFAS. Could you please explain your views on that?
Sure. The New Mexico definition is clear. Fluoropolymers are PFAS. I made a statement that they could be considered separately, and that is, in my opinion, still accurate. If you wanted to take a risk-based approach, you would want to take these several thousand chemicals in the PFAS umbrella and group them according to similar physicochemical properties for your risk assessment. And in that sense, fluoropolymers could be grouped perhaps together and apart from some of the other PFAS that we know are of concern, such as these long chain PFAS that you've already heard about.
Dr. Stanton and also Ms. Maripes, you both wrote in your testimony that PFAS in exempted products present a lower risk of exposure. Could you please summarize your testimony on that point?
Yeah, I'll start. So PFAS in complex goods, as Ms. Solomon already mentioned, they're often in internal components. We're looking at things like wiring. And so it's not going to pose a lot of risk to consumers because they're not going to be directly, touching it, eating it, breathing it. I understand there was a study discussed about, the dust in homes, which contains PFAS. And I think it is important to point out that that study was actually performed in homes and fire stations, which are not homes. And the very low amount of PFAS measured was not in the study tied to consumer goods at all. It was simply an observation of the amount of total PFAS, well, not even total PFAS, of specific select PFAS that were measured for. In those circumstances, it's unclear where that PFAS might have originated from. So for the most part, for these complex durable goods, you're not really going to be, again, engaging in them directly if you are a consumer. Often they are fluoropolymers. Again, PFAS in the form of a fluoropolymer is quite favored because of its chemical inertness and excellent thermal properties. They don't degrade over time, which normally you want. And also refrigerants, kind of the exact opposite of fluoropolymers, are very volatile, small components. They are not bioaccumulative and they are largely environmentally inert. PFAS that we know or suspect have environmental impact are already regulated by EPA, particularly limited on their emissions into the environment. Cannot be releasing these into water. And I'll let Martha speak to the robust recycling systems.
I think I'd like to just draw, excuse me, thank you again, Alex, for looking out for me as always. I think I would like to use this part of our testimony to reach back to CPMC's requests for exemptions. For example, we've spoken a few times about internal components and that they're encased in these products. Under normal conditions of use, consumers will not have contact with those components. And Minnesota specifically recognized this and did a quick change last year when it was banning PFAS in certain types of products, and the legislature, and it was a recommendation of the department in Minnesota, created an exemption from that ban for internal components. And again, in many cases, it's not because these companies don't, it's because companies need time to identify where the PFAS is in these components, identify alternatives, qualify the alternatives, do all the performance and safety testing that's necessary for that to find alternatives. And so Minnesota recognized that, and they did exempt internal components. Similarly, SNAP refrigerants have been well studied and are regulated by EPA. And again, going back to that need for transparency on preemption and exclusions, the state, as the state did in the statute, we would like to see a specific exemption for SNAP refrigerants in the labeling aspects of the rule. I think, many of these products do have recycling systems. Recycling systems, like most systems, are not perfect systems, but the alternative to that is for these products to be abandoned or go into landfills. So there's certainly, activities that the Secretary mentioned, circular economy activities that are taking place to specifically address that part of the life cycle. I think that's it. Thank you.
Dr. Stanton, in your written testimony, you described some of the uses of PFAS, and could you please summarize your testimony on that point?
Sure. I think it is well understood by everybody here that PFAS are used globally in many ways that are either difficult to replace or there are no currently known alternatives. Again, back to our chemistry, that carbon-fluorine bond is uniquely strong and has these very unique properties of being water repellent and oil repellent. And, again, we already talked about the chemical inertness of it and the thermal conductivity of it. So when it's used, it's often used deliberately because it has those properties and nothing else does. So it's expensive often to manufacture and use it, but that's why it would be used in situations where you don't have either equivalent alternatives or any alternative. Or the alternatives are just bad. This is pretty easy to think about in terms of refrigerants because we went through this as a globe already. We had some of the early refrigerants back in the day of ammonia or butane, which were either toxic or flammable. You don't want to use those. That's not good. Then we, discovered the chlorinated refrigerants and we put a hole in the ozone layer and we said that's also not good. So now we've landed on fluorinated refrigerants, which have, a lot of the qualities that we look for in a refrigerant where they're not flammable, they're not toxic. They have the mechanical compressibility that you require to change between a liquid and a gas, so it can actually be a refrigerant, and it's not putting a hole in the ozone layer. And that's how we settled on it. And if there was a better refrigerant, it would be selected. Similarly with flame retardants, there's many flame retardants in the world, and they're all pretty not great. So having another option of one that does not put out quite a harmful side effect when used. PFAS is used in that regard because it's chemically inert often.
Another point of clarification on flame retardants. There was some question yesterday about flame retardants and flame suppressants. Could you elaborate on what you mean by flame retardants and just tell us about
flame suppressants?
that?
Yeah. So PFAS are famous for their flame suppressant uses. They're quite good. There's a fire. The fire is active. You have these foams. We've all heard about the foams. Those foams put out that fire instantly. It disrupts the combustion cycle perfectly. It's very effective. That's why they're used for that. Flame retardant is so that you don't get set on fire while you're doing that action, or something else is not set on fire easily. So if you're the firefighter, you might wear clothing that's flame retardant, but you would be using the flame suppressant to put out the active fire. So it is, I want to clarify, much more famous for the flame suppressant activities than the flame retardant or low flammability qualities that it has, but it's both.
Ms. Solomon, in your written testimony, you provided some examples of the uses of PFAS in the marine industry. Could you summarize your testimony on that point?
Yes. So what this table shows are components that may have PFAS in use. And it's also showing what the technical driver is, as well as the risk of removal. So like fuel lines, for instance, currently it's the only material offering low permeation and flexibility. If we were not to use PFAS, we would be out of compliance with the EPA. Our engine seals have to operate at high temperatures because they are in contact with the hot engine exhaust. If we do not use these, we would have oil leaks and engine failures, which would contribute to water pollution. Wire insulation, it must be non-flammable, resist salt and fuel, and high melting points. So that's where PFAS may be used. And if we don't use it, it would cause electrical fires and loss of propulsion at sea in the middle of the ocean. We also have textiles. They need to be waterproof. They also have to have we use the PFAS because it's low surface tension, and it resists water and mold without cracking. So the risk of removal to this, we would have mold, and I want to add the personal flotation devices. We would have degradation of that as well, and I'll kind of talk about that in the next slide.
Yeah, before we move to the next slide, this was the table that I think you wanted to make a correction to from your report. Could you clarify what the correction is that you wanted to make?
Okay, I kind of spoke to it. So the temperature contact with the hot engine for the engine seals, and the personal flotation devices with the life jackets showing that they have degradation.
Okay, thank you.
Okay, thank you. Okay, and in this slide, I just want to talk about how life jackets and other critical safety, critical life-saving equipment and personal flotation devices must maintain their integrity and flotation for decades in the wet marine environments. PFAS is considered essential for durability. Without it, standard fabric would rot within 10 years. These personal flotation devices are certified and mandated by the U.S. Coast Guard and per International Maritime Organization's Safety of Life at Sea LSA codes. The problem is life jacket manufacturers buy materials primarily internationally, and a lot of times getting the exact information back can be a challenge when asking about PFAS information. When you look at the benefits versus the risk, the benefits of PFAS in ensuring functional safety equipment is considered to far outweigh the risk of non-compliant or failing equipment when you're in the middle of the ocean.
I think that concludes the testimony of these three witnesses. I'd like to move for their exhibits to be admitted into the record.
I'll pause in the event there are objections.
Okay, then these witnesses are available for further examination.
Thank you. They're admitted. Let's take an 8-minute break, please, and come back at 4 before we kick off the questions. Thank you for turning on the recording there, Pam. We're back after a short break, and it's time now to pose questions to the CPMC panel. Dr. Stanton, Ms. Maripis, and Ms. Solomon. Let's start with Mr. Trujillo. Mr. Trujillo, do you have, hold on, Ms. Maripis? Ms. Maripis, you should go back to the panel because the cross-examiners are going to sit over there. Oh.
Oh. Stay here and then, because we're going to do it individually.
Okay, I misunderstood. Okay, I'm very sorry, Ms. Mayorpiece. You're going to get your steps in. Would you go back?
Oh, thank you. And you're the
Yeah,
boss, so whatever you say, I'll go. I'll do it.
I misunderstood the request. Mr. Trujillo, do you have questions of Ms. Mayorpiece or any other member of the panel?
Madam Hearing Officer, before I go there, just real quick, I'm not sure how long cross-examination questions are going to go. We're obviously next in terms of our direct case. So I was working on scheduling witnesses. I was just going to request now, just for purposes of continuity, that we can begin in the morning if we finish early. I'm not sure how many questions are going to be presented. But
Any objection to that? I certainly don't object.
No.
No, okay. Thank you very much.
And the good news is I have no questions.
Oh,
So-
hooray. Full disclosure there, Mr. Trujillo. All right, to Mr. Roseborough?
Yes, Madam Hearing Officer. And just to confirm, my understanding is we still have 30 minutes per witness. Correct.
You do.
Okay. Thank you. Ms. Mayorpiece, thank you for your testimony and for taking the time to come to New Mexico on behalf of your client. For the clarity of the record, when I refer to your written testimony, I'm referring to Exhibit 3 of CPMC's Notice of Intent to Present Technical Testimony. Is that a correct representation of your written testimony?
Yes, that's correct.
Thank you. And I'd just like to discuss your qualifications for your testimony provided today. Are you testifying in your professional capacity as outside general counsel for CPMC?
CPMC has requested that I be a witness in my capacity as a regulatory lawyer that works with companies to analyze and comment on state and federal rulemakings, including those involving PFAS.
Thank you. So, but it's a regulatory lawyer. You're here, your experience or relevant qualifications are as an attorney. Is that correct?
A regulatory attorney who is, for the past 30 years, has looked at the cost and benefits of rulemakings involving my clients. Yes.
Thank you. Are you a toxicologist?
No, I am not. That's why I work with toxicologists.
And are you a chemist?
No, I am not. That's why I work closely with chemists. But environmental law, as I mentioned, is a very science-heavy practice, particularly chemical control law. In fact, many attorneys shy away from TSCA practice because it is so science-heavy. And so you have to have a capability to understand and translate the science and how it impacts your clients, the public. And so that's something I do regularly in my practice.
Thank you. And are you an economist?
No, I am not an economist. I have that undergraduate degree, which gave me a really a good base for working in a career that again involves looking at the costs and benefits to society of environmental regulations.
Thank you. I'd like to discuss CPMC's membership a bit. So we've heard quite a bit about what CPMC's members manufacture: appliances, electronics, lighting, outdoor power equipment, vehicles, communication devices, but not who they are. So can you please name 4 or 5 specific companies that are members of CPMC, which are representative of the larger membership?
Thank you for that question. The CPMC does not publish the name of its members.
Okay, so we're to just take your word that the harms you allege will be suffered by CPMC's members are real, even though they won't come out of the shadows?
What you can take my word for, and its information is available on our website, and I am testifying under oath, is a description of the types of products that CPMC members to provide to consumers, including many that are essential to health, safety, and the functioning of society.
Okay. What, was it a slip of the tongue earlier? Did I hear you say Yamaha US is a member of CPMC?
Yamaha is with us. Yes.
Okay, thank you. One more question. Can you tell me how many total members CPMC has?
23.
23, thank you.
And hopefully growing. We're looking for new members.
Are any based in New Mexico?
Many of them, I believe, have, they certainly sell products into New Mexico. I don't have any firsthand knowledge about whether they have facilities in New Mexico.
But you can't tell me which ones do.
I'm saying that I don't have any firsthand knowledge. I'm sorry, I forgot to bring my water up here with me. I do not have any firsthand knowledge of whether CPMC members have facilities in New Mexico. I do know that we're here because they certainly sell their products in New Mexico.
Thank you. I'm happy to pause. If you have water somewhere, we can get.
I'm going to grab
you.
my soda.
Yeah. We have time. Thank you. So I'd like to move on now to this idea of the chemical composition data in CPMC member companies' products. So on page 1 of your written testimony, you state that CPMC's member companies often do not have accurate chemical composition data for the products they manufacture, correct?
That's correct. For the specific chemical identities, that's correct.
Okay. And your written testimony goes on to state, quote, whether a complex durable good contains intentionally added PFAS generally depends on whether its internal component parts or a hardened exterior coating contain intentionally added PFAS for safety or performance reasons. And that's your exhibit 3 at page 2. So my question on that is, if member companies do not have accurate chemical composition data, how do you know that statement is true?
First of all, I am confident in stating that the majority of these uses are in internal components, which is in my statement. Generally, we know that there are certain classes of chemistry that go into these products, such as the refrigerants and fluoropolymers that are in our testimony. The reason why the specific chemical identities are not always known is because these companies assemble components into a finished piece of equipment. So they order components based on performance specifications, not on chemical specifications. And so that's why I think historically there's just this knowledge gap that persists today.
Thank you. In your written testimony, you also state that CPMC members, quote, do not maintain chemical composition records for each part, and the law generally does not require them to do so, end quote. And that's exhibit 3 at page 1. So my question on that point is, will CPMC's members only make the effort to determine the chemical composition of their products if there's a legal obligation to do so?
The reason for that statement goes back to, again, this is some expertise that I have on reviewing consumer or product labels and safety data sheets, is that internationally there's the OSHA hazard communication standard and also global counterparts. And those standards require disclosure on safety data sheets of chemicals that are present at 1% in the product if they contribute to a non-cancer hazard, or 0.1% if they contribute to a cancer reproductive toxicant harm. And so those chemicals, often and must appear on safety data sheets. PFAS sometimes are present at lower quantities, and also there are exemptions for articles that where safety data sheets are not required. So, that's the background as to the legal requirements under hazard communication standards have not specified that PFAS be disclosed below certain quantities. Above certain quantities, certainly our members would have that information on their safety data sheets that they receive.
Thank you. Your written testimony states, quote, "The ingredients in hardened exterior coatings are chemically bound to prevent direct exposure or release during their intended use," end quote. That's Exhibit 3 at page 2. So do CPMC's members maintain chemical composition data for 100% of their exterior product materials?
Again, these are materials that they get from suppliers, that they're already finished goods, finished fabrics, finished coated parts. So they would not have that information again unless it was supplied by the supplier.
Okay, so they actually just don't know whether whether PFAS are going to come into contact with the consumer.
In many cases, yes.
Thank you. And is that true for automobile seats?
I think I can't speak to automobile seats, but I believe Kemba's testimony included parts of a marine vessel that included seats. Yes.
Yeah. Are any automobile companies members of CPMC?
Excuse me, I didn't.
Sorry, that was quick. Does CPMC have any members who manufacture automobiles?
Yes.
Okay, thank you. In your written testimony, you state, quote, "Based on the statistical data compiled from CPMC members, the response rate for supply chain surveys, as would be required to obtain a waiver from labeling, is around 30% at best," end quote. Then it goes on to state, hold on, give me a moment. I accidentally deleted the question. So we're talking about your supply chain surveys response rates of 30%. So you referenced a statistical data compiled from CPMC members. Did all members participate in that?
I don't think I referenced statistical data per se.
That's
I
a
did
quote.
mention the 30% response rate, and that is information that we've obtained from members, but I believe Ms. Kemba's testimony expanded on that to include her own experience with in that area.
Okay. And just to clarify that, those survey results weren't attached as an exhibit to CPMC's testimony.
No, and just to clarify, there was no survey conducted.
Okay, thank you.
No.
Your written testimony states that the requirement to gather the information necessary for the labeling of complex durable goods, quote, "creates a presumption of both exposure and harm, neither of which may be accurate." Is that correct?
That is what I stated in my testimony. That's right.
Okay. So, but given that CPMC's members appear not to know the chemical contents of their products, aren't they engaging in an unfounded presumption of safety?
Again, I would like to specifically clarify that the difficulty in understanding the composition is with respect to the specific chemical identity of these PFAS chemicals, which would be a requirement under the rebuttal rule in order to request an exemption from labeling. We have testified that these products, the internal components, are typically fluoropolymers that are used for flame retardant purposes. We've testified that these chemicals are refrigerant chemicals that are well studied and regulated by EPA. And so I don't think it's accurate to say that our members don't have an understanding that there's PFAS in their products.
Thank you. Okay, in the interest of time, I'm going to move on. I want to discuss Exhibit 14 to your testimony. That's the Proposition 65 study.
Yeah.
Do you have that available? Because I'd like to go through it.
Thank you.
Okay, so in your written
Could you
testimony,
please tell me what exhibit that is again, please?
14.
Thank you. Got it.
Thank you. So in your written testimony, you claim that I'm going to call this Exhibit 14 the Proposition 65 study. You claim that it found, quote, a one-time cost of $1,000 for revising the label for each product. Is that correct?
Yes.
Yeah. And your written testimony quoted the Proposition 65 study by stating, quote, the assumption of a $1,000 relabeling cost for all packaging should be viewed as conservative, end quote. Correct?
Yes.
Okay. And because of this, your written testimony concluded that, quote, this caveat is important and also applies for NMED's proposed labeling. The costs for NMED's labeling are likely higher than OEHHA's estimate. Correct?
In my testimony now. Yes.
Yes, yes.
I'll accept that if you revert it. Yes.
Thank you. Okay, so now we're gonna jump into Exhibit 14. Isn't it true that the Proposition 65 study, or that the study's, quote, conservative methodologies actually overestimate costs? And I'd like to refer you to Exhibit 14 at page 3 for that. And if you look at number 1, I can just read it aloud. So, higher cost scenario based on conservative assumptions on the number and types of safe harbor warnings being given. These types of assumptions, the use of these assumptions is unlikely to underestimate the costs associated with the regulation, but is more likely to overestimate these costs. So I'll repeat my question. Isn't the study's conservative methodology actually likely to overestimate costs of labeling?
I see that statement was made in relation to this particular survey for this particular purpose. My testimony was intended to extrapolate to the rebuttal rule requirements for labeling. And the basis for my statements were twofold, I suppose. One, because Proposition 65 is a list of 900 chemicals, and this rule applies to potentially 14,000. So more chemicals to evaluate, and that's one basis. And then the second basis for my statement in relation to this rule, and not in relation to what they did, is the multi-component nature of the complex durable goods that our members have and would have to label.
Okay.
It would involve more effort to try to get that information, as we've been trying to.
Thank you. I understand that. Nonetheless, I'd like to drill down on this study because, well, I want to see if it correctly represents what you said it did in your written testimony. So now I would refer you to Exhibit 14 at pages 6 through 7. And that's going to take you to start, I believe, on the final page, the final 2 lines of page 6. Am I correct that it states, quote, revising the warning on larger packages or alternate means often used to provide warnings, such as package inserts or warnings and instruction pamphlets, would likely cost less, end quote, than the generic $1,000 number that you represented?
I see what you're reading and I saw that too. What they don't provide any explanation that I could find as a basis for that. And so that's one of the reasons why we asked Kemba to provide some more specific information on her owner manuals and technical sheets to provide the department and the board with more information in that area.
Thanks. So is this generally an unreliable survey to rely
I'm
on?
just
for this
saying there's
evidence?
no basis and for why they made the statement, so I don't understand it.
Okay, but they concluded it. That's the
It did.
conclusion they reached.
That's
Okay.
what it said. It's what it says, yes.
Please be careful not to speak over one another.
My apologies. That's my fault. 100%. Okay, I'd also like to discuss the combined cost estimates you cited in your proposition, in the Proposition 65 study. So I'm going to refer you to Exhibit 14 at page 3. The Proposition 65 study at page 3 outlines two total cost estimates of the regulatory scheme, a high cost scenario and a lower cost scenario, correct?
Yes,
Okay.
that was their approach. I agree.
And we discussed this earlier, but just to confirm, the higher cost scenario, where the conservative ideology came in, is more likely to overestimate the costs of product labeling. Is that correct?
I think that the cost scenario was based on the number of products that were used as the basis for the study. So 13,000 products versus 8,000 products. And so, in relation to your question, perhaps it was conservative in that there may not be 13,000 products that would be subject to labeling, but certainly they felt that range of between 8,000 and 13,000 products was a valid basis for doing this cost estimate.
I agree with that. But given that CPMC's members don't know which of their products actually contain PFAS, isn't that range, maybe 10%, maybe 90% of your products will be labeled such that this high-low scenario is still applicable if we're going to continue to use this as an analog?
I really wish I had that estimate for you, but I don't have it. And so I just really don't know specifically, the percentage of our members' products that will be subject to labeling. But again, these estimates would apply more broadly to other products that are also going to be subject to the labeling rule.
Okay, thank you. I'm running low on time, so I'm going to jump ahead a few questions, but I do want to look at tables 2A and 2B on pages 10 to 11 of Exhibit 14. Just a quick stylistic question. The little highlighting there at the bottom, that was you guys, right?
I think so.
Okay,
Yes,
okay.
yes.
So when we look at these tables, and table 2A and 2B are the high cost and low cost scenarios.
Right.
We can see the application of Prop 65's regulation to a variety of industries. Is that a correct representation?
Yes, they
Okay.
did break it down into industry sectors. That's correct.
And manufacturing is just one of those, correct?
70%, 71%
Okay.
Of the cost.
But we can look at that line item, Code 31, manufacturing. And then if we slide across, we see the costs associated with issuing signs, publications, internet warnings. But is it fair to say that to make this analogous to NMED's rebuttal rule, we should only look at the label cost line item and not the total cost associated with the others?
One of the factors that I'm not sure has been fully considered in the rebuttal rule is the impact of the labeling on internet sales and changes that would be required to the internet, including, online retail platforms. So I would respectfully suggest that cost be considered. And again, this is an approximate. I know we're talking, not quite apples to apples here, but it's the best, information relative to what is being proposed here that we could locate for this hearing.
So just for the board's consideration, I'd ask you I'm going to highlight two numbers. I've heard your disagreement that the other cost should be included. But for table 2B, low cost scenario, the label dollar amount only, am I correct that it reads $8,107,000? $8,107,253?
That's correct.
Okay. And going to table 2A, the cost for labeling is $16,214,507.
That is also correct. And just, a reminder that this is just for changing the labels and doesn't include other associated costs that is involved with getting to this point.
Okay, thank you. I see I have a few minutes left. We may jump back to that study if we have time, but I want to at least briefly discuss your legislative intent arguments. The question about whether products exempt from prohibition are also exempt from labeling under law. So my first question is, did you come to New Mexico during the 2025 regular session of the New Mexico legislature?
No, I did not. And that's why I'm not registered as a lobbyist.
Okay, so you're not registered as a lobbyist. Okay.
But we had members and industry, ACC, others that were certainly here. And we're a small knit community in Washington. So we certainly, communicate with each other.
Okay. So ACC is a member that was here?
ACC is not a member of our coalition, but I think that the secretary was on record as having communications with ACC.
He did. Okay. So they're an affiliated entity.
They're friends, but
They're friends.
yeah.
Okay. Did you personally play an active role in drafting HB 212?
Oh, gosh, no.
Okay.
It would look a lot different.
So is your testimony supported by any actual knowledge of the New Mexico legislature's intent in passing HB 212, or is it a personal legal interpretation?
No, I just would like to set the record straight on this one. As other witnesses here have pointed out, when we submitted our written testimony, it was based on the information that we had at the time. And my testimony in my written testimony was based on my professional experience and a strict reading of the statute. Because we were aware that labeling or asking for an exemption from labeling would involve essentially the same degree of effort of reporting for our members, and the legislature exempted many of those complex durable goods from the reporting, it didn't seem to us to be a logical progression that the legislature would agree that they're all subject to labeling. And with regard to that, there's been plenty of testimony on that. It's on the record. But I would just add to all of that, that the language of the statute has been acknowledged to provide the agency with discretion in how to apply that labeling authority. And so we're here today to ask the agency to do just that.
Thank you. Okay, I see I'm close to 30 minutes, so I'll leave before they cut me off. Thank you, Ms. Maripes.
Thank you very much, Mr. Roseberg. Are you moving now? Sorry, was the proposal to move now to the next member of the panel?
Yes, whoever would like to go.
All right. Don't both jump up at once. So. Thank you, Ms. Solomon.
Is that Mr. Smith here?
Yes, it is Mr. Smith here, and Ms. Solomon is taking the witness stand. Great. Go ahead, Mr. Smith here.
Thank you, Madam Hearing Officer. Good afternoon, Ms. Solomon. My name is Greg Smith here, and I'm here on behalf of the New Mexico Environment Department, Office of Strategic Initiatives. Did you review the PFAS Protection Act and the rebuttal rule in preparation for your testimony?
I slightly, I did. I scanned through it.
Okay.
Okay.
Well, I'm going to ask you some questions, and if you don't know, you don't know. So
Okay.
just please let me know. Are you aware that fluoropolymers are exempt from the sales prohibitions of the PFAS Protection Act if they are a solid at standard temperature and pressure?
I am not aware of that.
Okay. And are you aware that watercraft are exempt from the sales prohibition of the PFAS Protection Act?
I am not aware of that.
Okay. I was wondering based on your testimony.
Okay.
So a lot of your testimony relates to the inevitable uses of PFAS in watercraft. But I think given that they're exempt from the prohibitions, I'll probably focus more on labeling, which likely would apply.
Mhm.
Is that okay?
Yes.
On page 2 of your testimony, you state that original equipment manufacturers frequently lack granular insight into formulation changes at the tier 3 or tier 4 level. Is that right?
That's correct.
And are you familiar with the concept of full material disclosures?
Yes.
Okay. Can't OEMs require full material disclosures from their tier 1 suppliers?
Yes, they can. I think where we get, well, I'll just say yes.
Okay.
You want me to go into detail?
Well, I guess if they had those full material disclosures from their tier 1 suppliers, wouldn't they have all of the information they need?
No, because there is specific information that is required. PFAS has not typically been required. There are manufacturers that do request PFAS information, and they are in the process of gathering that information, but it is not at 100%.
Okay, so it's not really a full material disclosure. I mean,
It's
the research I did, it sounded like it was like 100% of what was in a product would be disclosed, but it sounds like that's
no,
not right.
that's not the case.
Okay. I wanted to ask you, doesn't the automotive industry already require full material disclosures through the International Material Data System?
They request it, but when you say, it's certain information, and when you get down to the granular level, they may not have every single component. Like I showed the assembly, they can say it contains PFAS, but inside of the assembly, they may not have each component that makes up that assembly available to them.
Okay. And is it your understanding of the rule that you have to break down what's inside of the assembly?
Yes, that's my understanding.
Okay. On page 2 of your testimony, you discuss a critical data visibility gap on behalf of OEMs with respect to the components that they procure. Is this issue similar to the unique labeling requirements of the proposed rebuttal rule? Oh, I'm sorry. My question was going to be, don't OEMs face similar issues complying with other regulations like Prop 65?
I'm sorry, can you repeat that?
Sure.
Okay.
I guess my question is, wouldn't OEMs face similar issues complying with Prop 65 as they would with our proposed rule?
I object on the basis that calls for a legal conclusion.
Ms. Solomon, to the extent you've opined about the regulations and the possible effect they would have on your industry, please go ahead and answer the question, but please do not answer it as though you're answering like a lawyer.
I am aware that with Prop 65, suppliers are required to submit a declaration of conformity to the manufacturer, not to a consumer.
Understood. On page 4 of your direct written testimony, you discuss aqueous film forming foam and fluorine-free foam. And I wanted to ask you, are you aware that the PFAS Protection Act allows for the use of aqueous film forming foam in emergency circumstances?
Yes.
Okay. Now I'm getting into notes I took while you were providing oral testimony, so it's going to go a little bit slower. I'm sorry.
Okay.
Okay, you discussed earlier that the label requires the flask as well as a statement. Isn't it true that the rule only requires an Erlenmeyer flask with the word PFAS inside of it?
It was my understanding. Give me 1 second.
Okay.
Let me look. I just need the HB 212 is in there. I thought I had it in here. Okay, so 20.13.2.13, where it said number, let's see, C1. Hold on, let me be in the wrong section.
There was a revision of the rule, so it may be that you just haven't noticed.
Maybe I may have had the other one, but it did state that that information was required.
Okay, but the current version of the rule requires a symbol. The symbol shall be an outline of an Erlenmeyer flask with the word PFAS inside the flask. The label may also include the following words.
This product is made with PFAS?
Okay.
Yeah.
Yeah, so it's either, yeah, you can just do the symbol. You were discussing owner's manuals in the Yamaha owner's manuals in the US earlier, I believe.
Yes, I did.
Okay. Were you saying that in the United States, Yamaha only does owner manuals like online?
That's correct.
Okay. Do you know if it's less expensive to alter an online owner's manual versus hard copies that are printed and distributed?
I don't know the difference in cost between the two, because the owner's manuals are sourced from different entities, and the example I gave for the outboards, those are sourced in Japan, and I'm not sure of what the cost is. On the electronic versions, the information that you're asking, we would have to, there would be an additional cost, because it could be that we would have to redesign the website to include that additional, to have every PFAS chemical included on there. So that would be an incurred cost, but I don't know the difference
Okay.
between the two.
And you don't know what that cost would be?
For the website?
For the website?
No, I do not.
And not for the manual either?
No, I do not.
Okay. I wanted to talk to you about, do you have your slides? A copy of your slides? On page 11, you talked about the economic impact of the proposed labeling requirement in New Mexico. Did you review any of the underlying data that led to this, I guess, diagram?
Which diagram is it?
I'm
Sorry.
on 11. It's the one with the recreational boating impact in New Mexico.
Okay. And I'm sorry, what was your question again?
My question was, did you review any of the underlying data that led to the production of this diagram?
This diagram that I submitted, this is from the National Marine Manufacturers Association, and that's where I obtained the information from, but no, I did not.
Okay, was this designed for this particular hearing?
No, it was not.
Okay. Do you know anything about what goes into this $335.2 million annual economic impact?
I would not be able to speak to that because it is produced by the National Marine Manufacturers Association.
Okay.
Okay.
Can I direct you to page 20 of the slides? It's the slide that talks about, it's got the diagram of the boat with the life jackets.
Okay.
When you were talking about the slide, you were talking about how you wouldn't want to be in the middle of an ocean and needing to rely on a life jacket that didn't have PFAS in it, I think. Okay. Is New Mexico adjacent to any oceans?
No oceans, but lakes.
Yeah. Okay. Have you been to any of the lakes in the state of New Mexico?
I have not.
Okay. I would represent they're not very large.
Okay.
You made a statement earlier that it would be difficult to make a state-only label.
Mhm.
And I wanted to ask you what the difficulties are that are involved with that.
So from a resource standpoint, you know, in years before we had to meet EPA standards and then came along California standards. So historically, it's really just been the EPA in California. In recent years, states are starting to create their own rules and regulations. We don't have the resources to specifically create a label for only New Mexico. We would have to consider either changing it for all 50 states or 49 states, or we would have to consider other alternatives. And the difficulty is, you know, we're tracking all of this information. I'm tracking what's coming, and we have to get teams in place. I'll use one state's requirements where we had to create a team of 10 people internally, and then we had to hire suppliers externally to help us maintain the information. We had to create new software to be managed. We had to train people, not just internally, but at the manufacturing level, so they know where to put the labels. We have to train people internally to track it. We have to get new suppliers to create it. If they don't, so we have lead times. And if the lead times for a supplier does not meet our build requirement for release, that causes an issue. And a lot of times suppliers, what we do is when we're working with suppliers, we look at the lead time to see when will this be available versus when we start our actual build. I'll use my automotive background in this case. I know manufacturers in January, we're doing vehicle testing. We would call it the dress rehearsal. So we're testing to make sure that everything that the suppliers have provided, they have to have all information in. And then in July, we start building. When changes like this occur, we have to go and resource who the supplier is if the supplier isn't able to make additional labels, because as I mentioned, they are parts. So we have to make sure that the parts are available, that we can put it on there, people are properly trained, and to do a turnaround so quickly, it's a huge burden on complex products industries.
Is time the only issue? If you had more time, would you be able to accomplish that?
Well, it may not just be time, it could be dollars. Depending on how much it would cost, we would have to make a decision. Is this profitable for the amount of time and the amount of work it takes. There are a lot of variables, but it could be time. It could be a lot of different variables, what's available. And do we have space? It's not like we can just go and say, okay, we're going to add a label. We have to look at the space. If you look at the slide where I showed the labels, I'll use the outboard as an example. The sticker, I'm sorry, look, the manufacturers hate me to say stickers, but the labels on the units, we don't even have space. You start covering up things on the equipment, and now we have an issue with performance. So we have to be very careful about placement of larger labels as well as, where they need to go.
Okay, understood. I'm looking at these slides and you're saying that you couldn't put a Erlenmeyer flask with the word PFAS in it on?
I guess, so that's where manufacturers would need clarity. Is it on each label or is it a new label that you're asking, that the ruling is asking for us to put?
My understanding, it has to be on the product.
So it could be one label in English and Spanish. So I want you to look at the top label. I don't know if I can ask you questions. But if I look at the on the label slide, on the second slide, are you able to see that?
I'm looking at it. Yep.
Okay, so in the top left corner, that's underneath our outboard. Can you, according to the ruling, it says to me that I would need to redesign all four of those labels. I do have to have that one in Spanish and add the Erlenmeyer flask.
Okay. My understanding would be you could put an Erlenmeyer flask with the word PFAS in it on there, and that would satisfy the English and Spanish requirement.
So I could just put it in between the two?
Yes, ma'am.
Okay.
In that case, do you think that it would fit on there?
It would depend. If you wanted in English and Spanish, it's a tight space. I don't think.
Yeah, well, what I was going to tell you is that PFAS is considered a universal acronym, so it's used the same in PFAS in France or Spain.
Okay, so when it says the label may also include, does that mean that's optional? We
It
can just put
does.
the flask?
Yep. In that case, do you think it would fit?
It could fit, but I don't know what it tells the consumer.
Okay, well, that wasn't my question.
Well, I'm just.
I appreciate. No, I understand. And you made the statement that we don't have the resources. Are you suggesting Yamaha doesn't have the resources to add a sticker or a label?
I was speaking in general for industry.
Okay. Earlier, you said that your company was being charged to obtain information from a supplier. Can you tell us about that?
So costs that are, if we are requiring our suppliers to provide us additional information, they are able to increase cost because it's out of scope of the agreed upon contract.
Okay. But you were talking about a specific instance. Do you remember that instance that you were describing? At least it sounded like you were.
I know of a specific instance, but I did not identify exactly what it was.
No, I know you didn't. It just sounded like you were talking about a specific instance as you were recounting an anecdote.
I was.
Okay. Will you tell us about what that instance was?
I'm not comfortable sharing.
Is there an objection from counsel or? I mean, I don't know why that would not be relevant information.
I don't want to disclose specific information about our agreements.
Okay, fair enough. I mean, you talked about it. You brought it up in your direct testimony, so that's why I'm asking.
I also know in general, other companies that have experienced that as well.
Okay. Do you know how much they charged you for the additional information?
No, I do not.
Okay. Are you being paid to provide testimony here today?
No.
Okay, thank you. That's all the questions I have.
Okay, thank you.
Thank you very much, Ms. Solomon and Mr. Smith-Care. I think instead of leaping into the next witness, since we have just 9 minutes until 5, that we should end for the day and resume at 9 in the morning. Is there anything we should talk about before we break, Ms. Feebeck?
This may be a procedural anomaly, but I did have just one redirect question for each of the witnesses. Would it make sense to do it today, or do you want me to do it tomorrow?
Oh, if you'd like to do it today, that's fine. Go ahead.
Ms. Solomon, I wanted to draw your attention back to Exhibit 69, which was the rebuttal rule. I think council asked you to look at the language. There was a lot of discussion in your testimony about what language is required to be on the label. I think you had a recollection that there was some text that was required. So I was going to ask if you could read, you don't have to read it out loud, but you can read it to yourself, subsection D1 in its entirety, to see if that refreshes your recollection as to what information is required to be placed on that label. And if it's helpful, that's on page 9. It's on page 9 and it's subsection D1 of the rebuttal rule. Okay. Look, push the green, yeah. Could you clarify what data or what language is required to be on the labels under this provision?
It says the label, it says the label may also include the following words directly adjacent to the flask. This product is made with PFAS, made with PFAS or contains PFAS.
So is it green now? Yeah. Could you read the last sentence in subsection D1? It's exhibit 69. Are you looking at 69? Okay.
The number 6 or the one in that number 1 paragraph?
It's
And it's number 1.
subsection D1 and
The
it's
last sentence?
the last sentence. It's on line 29 through 31.
Yep. The specification sheet and other product labeling information shall contain the following statement. For more information on the location of components made with PFAS, review the product's operation and maintenance manual.
Okay, is this the text that you were thinking about that needed to go in English and in Spanish on the label along with the flask?
No.
Okay.
Mhm.
Okay.
All right, thank you very much. Let's break for the day and resume at 9 o'clock. Oh, are you?
I can't hear whoever's speaking.
Yes, I did have one quick question for Ms. Maripes.
Okay.
I think she can do it from here. In your cross-examination, you said that there was no survey conducted to obtain the statistic about 30% response rate. Where did you get that information?
That information was obtained from CPMC members who had experience in complying with the TSCA rule banning the flame retardant PIP 3.1 specifically. And since that time, it's been discussed in calls and meetings, and there's general consensus among our membership that reflects the experience of the members.
So do you think maybe what you mean to say was there was no formal survey conducted?
That's correct. A survey in terms of an actual survey instrument and a formal report. There was that was not done, but certainly in terms of surveying the membership, that meaning of the word, that's true.
Thank you.
Thank you.
Thank you, Ms. Febeck. Thank you, Ms. Maher Peace. Thank you, everybody. We'll break for the day and resume at 9 o'clock tomorrow morning.